The allocation of duty roster shows only judicial magistrates are taking up matters.
No,
I have taken inspection, but Mr. Banerjee went to the
I
personally went for physical inspection yesterday.
And they said there is no civil jurisdiction as far as they have.
But they could have moved the matter on the 14th minute. They sought for an adjournment. Let me finish. But on the last occasion, we were ready to proceed with the
30th
matter.
of June 2024, he was suspended. December 2024, he was expelled from the club.
Order passed under?
Order 39 Rule 1.
So from that, the appeal will lie before the district judge. Right.
He is not taking.
I don't have a forum now.
No forum.
No, there's a notification.
No,
Kindly takes my lord.
Please bring the roster. It's only the judicial magistrates who are taking up matters.
So why the forum is not available? It has been assigned to somebody.
No. During the vacation, no civil matters will be taken up.
It has. Unless I have a notification mallet from the
Show it to them.
I'll show them.
I will tell you, Lordship.
Show it to them first.
Yes, we are aware of it.
Yes, please, we are aware of it.
Will kindly take.
Give it to me.
Just the roster, na.
But we have also found out that there is no matter filed. Milord, I will tell your Lordship, Milord. We are categorically.
One second, sir. One second, sir.
Judicial magistrate appeal. রাখো তুমি রোস্টারটা রাখো। দাঁড়াও আছে আচ্ছা ঠিক আছে আমি বলে দিচ্ছি দাও।
Oh, 17th October. Tomorrow is the last day.
Yes, Milord.
So yes.
Milord,
Yes.
I will tell you, Lordship.
Exactly.
Milord, I will tell you, Lordship. Milord, because of this controversial issue, I called up the office bearers of the Alipur Civil Court, including the president, Mr. Srikanto Bhattacharjee. He said, I have never heard of a vacation bench in a civil matter in the Alipur court, number one. And to further ascertain, Milord, there was a bench yesterday. Lordship will find that the 15th there is a bench. Milord, there are assigned benches, are there 3 benches in the
I'm
appeal.
making it clear that it will be taken up tomorrow and the order will be uploaded.
Let it be taken up. I'm grateful, man.
Where?
No, may I submit this?
Let it be.
Not this. Probably will not fit our.
District judge is only taking criminal matters. I mentioned the matter.
Sir, I will direct, I will request in view of the urgency and since the assignment is there on 17th, they will have to take it up.
But I will try to persuade your lordship's kind jurisdiction.
Despite there being this appellate forum on 17th, why should I take up? I will not take up.
Please see the nature of order once.
Wait a
Not your
minute,
lordships are
wait a
well aware of the invocation of jurisdiction under 227.
No.
Not the.
They are Alipur করে করে দাও। Let the division petition be treated as an appeal. আর appeal file করা শুরু করুন।
Milord, your
Then
lordship.
kindly permits this to be treated as an appeal.
Milord, your lordship will.
No.
Milord, I will beseech your lordship, Milord. Kindly treat this revision as an appeal by tomorrow. Milord,
So the filing section is closed. No, filing section is closed.
Yes,
I've been given to understand that
It
the
cannot
registry
be,
is open.
Mr. Mojumdar. The moment notification says 17th October, there is a bench. Filing cannot be closed.
I'm
If
grateful.
it is closed,
I will.
it is wrongly closed.
Milord, your lordship will.
What can be done? Not this is
I will direct.
from the practical.
I will direct, sir.
This is the information taken from the
Let
field.
them take leave from the bench.
This is the roster of filing. 26 September is the last date.
Yes, I don't mind.
You'll be very well. Your lordship will direct the district judge to take up the matter and
Yes.
treating this revision as an appeal.
No, I'll tell you, lordship.
We can't file.
No, 1 second.
There is no time.
Yes.
Because otherwise, Milord, ad interim ex parte.
Then what will happen now? Guide me on the procedural aspect.
Procedure will rectify and file a proper appeal appropriate.
After reopening.
No, I'm not on that. That is possible. But how this original paper will be transmitted?
Yes.
Original paper is treating as an appeal. Original paper is not necessary to be brought in because it cannot be brought in. Everything is closed.
This is an original 227 application you have filed before me.
Copies which have been served on the parties that can.
They
be
already
placed
served
before
copies on
industry.
them.
You have served to the
But
parties.
then
We'll file a fresh copy before the honorable court.
हाँ, ठीक है.
We'll file
this
a
can
copy
be-
before the district
because
judge.
from the record.
Yes.
No, but Mr. Sinha. Now this side, you just no procedural aspect.
No, apart from proceeding on this issue, I think your lordship needs to take judicial notice of the fact that there is no civil forum.
No, I will, it cannot be, Mr.
this
Sinha. In view of this.
Lord, use a very harsh word. It's a farce. Lord, we have written to the
I will direct that to
we have written to the Registrar General But specifically inquiring,
So
may I
now
put the
this
letter?
notification is there. I will direct it to happen.
But that's why I'm saying it's a farce, Lord. There is no court.
Let me pass the direction. Then let me see that there will be no court.
Lord, all of us will be remedialist because no appeal has been filed. No appeal could be filed.
No, what I can do. That is why I am asking you about the procedure, Mr. Banerjee and Mr.
Lord,
Sinha. This the physical form of this petition is before me.
Yes, my lord.
So similarly, you have also filed an online one.
During vacation, no.
Vacation, no online.
So how this or how the record will be there? That you tell me. Assist me on that.
Anyways, but the formats are different because there a memo appeal and state petition.
I can direct. No, I will direct for the time being this to be
This may be
treated as an
treated as an
appeal. I don't mind. This application to be treated as an appeal for the time being, then you will regularize in the light of the averments and pleadings made. That can be done. But how the original will be there?
Original,
Then nothing will remain before this court.
my lord, I tell you, lordship, my lord, if I can suggest before your lordship, my lord, that we have served the parties. The petition is very much there. That petition we can say file a same petition before the court as a copy and to one regularize subsequently by filing an appropriate documentation.
Regularization, I don't mind.
Subject to your lordship.
That you will do within the 7 days after
Yes.
reopening.
Yes, my lord, we will do it.
But substantive justice, how this, if I direct this copy
True copies of the
yes,
document.
that can be
True
done.
copies
If I direct
and,
this copy to be there,
my lord,
then this
my lord, your lordship can direct the true copies of the revision petition filed may be placed before the district judge, which we have treated as an appeal for the as subject to regularization on a subsequent date.
Certified copy is not there. Lord, they will not entertain without certified copies
That's
also.
my lord.
They could have applied all
My
these.
lord,
record will be there.
No, the record is before the
record
civil judge.
cannot be done.
That
Record will not be there.
That will be brought before the appellate
No,
court.
no, it cannot be brought. Everything is closed.
please show the picture.
Photograph.
There are
Then where is
photographs.
where is the utility of this notification?
Exactly, my lord.
If not, your lordship will kindly
Malaj,
see.
today your lordships are inclined to enforce this particular notification
your
and Malaj,
lordship
kindly
kindly
just give me one moment.
Photograph I produced before your lordship. I given it to your lordship immediately. Everything is. I have taken photograph yesterday. Everything is locked under.
I am not on. Oh, acha.
I
In the
cannot
court.
find the certificate with the
Malaj, today your lordship is passing a judicial order to give enforcement to this notification.
This has to be taken with
Milord,
judicial
if I
notice.
may submit to your lordship, Milord, with utmost respect and humility, Milord, your lordship will pass an appropriate order after hearing us for the time being and subject to, and then subsequently you can regularize by filing an appeal because there's no bench. Practically,
Let me see the order first.
yes,
Kindly consider, Malaj at least considers one submission from my end. Malaj kindly considers one submission from my end. Malaj, today your lordship wants to give judicial enforcement. Malaj, kindly gives me a moment. Malaj, your lordship wants to enforce.
Which page?
88 second volume, 238 second volume.
237. 237, volume 2.
Milord, I think the petitioner is Mr. Mojumdar, not my London friend.
I am appearing for the respondent though.
But you
Yes, hold your breath. Hold your breath.
When
I am interjecting.
when a senior advocate,
Mr. Banerjee, Mr. Banerjee,
this is not done.
Mr. Banerjee,
interjecting,
Mr.
Malaj.
Banerjee,
I'm excited
you
right
don't
now.
take these things into your mind.
Lordship, once you
your
have a look
seat.
at the order, it's at page 237
Wait,
in the second volume.
wait.
Malaj will kindly just appreciate. Malaj, take
Mr. Counsel,
I'll make myself.
You hold your
I'll
breath
hold. I'll-
till your turn comes.
Yes.
Yes.
This is a fast one. The body. The fast one is complete fast one. It's a misdemeanor on the.
Which? Yeah, I'm going.
Something. In I.
Mr. Somo Mujumdar,
My lord.
kindly come to the operative part.
Fine. Yes, my lord.
Yes.
243.
243. Yes. Yes.
Read the operative part.
That the defendant are hereby restrained from giving effect to termination letter dated 30th December 2024 till 3rd November 2025 owing to ensuing puja vacation.
So where is the urgency? Now that if the termination effect letter is not effected for a during,
Please come to the next page. Now, what is the effect of this?
yes.
26th, the order is communicated. 27th, this gentleman goes, creates a ruckus, not abuses the honorable judges even.
FIR had to be filed.
And this record on 5th October.
Which you are representing whom?
Well,
The plaintiff.
The plaintiff.
He proceeds on the basis in an ad interim ex parte order that he has heard both sides. Please have a look at paragraph 8 at page
So
2.
that's all right. But today I am only extreme urgency.
My lord. And
Otherwise, no.
ex facie, my lord, that learned judge did not have determination on that particular date.
Sir, those are to be decided. But
Very well. Not
today I am not on that.
an order taken effect in December 2024, state ex parte in September 2025, after 9 months.
My lord, the order by an ad interim ex parte order, mandatory injunction has been granted.
Status quo ante
And
restored
status
after
quo
9
ante-
months.
And a status quo ante of 9-10 months. My lord, can that be done in a proper judicial system, my lord? If I may say so with respect.
No,
my
sir.
lord,
I will not interfere with the order right now. There is no question interfering with this order right now.
my lord, if
In
may I-
fact, I will observe that I have not expressed any opinion on the merit, on the rival contentions of the parties. 3rd November is the date fix. I will give you liberty when it is going to open the court.
24th or 27th, along with
Immediately after reopening, you can apply for preponement of the hearing. You can ask for preponement or you can ask for whatever. The appeal is already, you
Yes.
can file your appeal.
yes.
And may I just try to satisfy your lordship?
No, Mr. Mujumdar, no question of satisfying at this stage.
Your lordship will be pleased to find.
No ruckus.
Your lordship will be.
I will make that observation.
As your lordship.
I will make
Yes,
that
and so far
observation.
as the ruckus is
Ashok.
concerned, can I just make one submission so far as the ruckus aspect is concerned? Because your lordship, they've prayed for an
Undertake
observation.
that it is their
Well,
submission.
I have in fact filed complaints myself. I have also filed a petition under 144, which has been allowed. 144 CRPC, which has been allowed. I took
144
CR, now it's smelled 107. of the
doesn't
PN.
matter. But 144, why you have taken
Well, I'll tell your lordship why. I took
before your the organization?
No. Well, this I've taken this, but I'll tell your
In
lordship.
respect of which premises?
Well, in
144?
the 144 is in respect. Well, in respect of.
In respect of which
Well,
premises?
CCFC. It's easier. No. Kindly, let's me. Well, at least.
Lordship will kindly see this is the way.
Well, can I just satisfy your lordship for a moment?
No.
Well, kindly hears me for a moment.
No.
Well, kindly hears me. For,
How can you take that?
no. Well, it's the ad interim order of injunction.
How can you take that?
Well, is in so far as the one.
How can you apply for 144?
It is because when I went to the club to enforce the order of injunction, asking them that you either give it to me in writing that you don't want to restore my membership, you give it to me in writing, I'll leave the club premises. I'll take my appropriate steps before.
It's an internal dispute of the club.
Yes.
That's right.
Well, it's,
That's right.
well, it's the
Internal
difficulty
dispute
was
of the
the
club.
difficulty was
Justice Wang Chu.
well, it's the
60.
My lord,
well, it's the difficulty was they were creating.
Victoria.
63 Supreme
Well,
Court
it's
Justice Wang
they were
Chu.
creating. They were getting aggressive with me. They threatened me, so I wrote to Baliganj PS stating that I have an order of injunction.
That is
They're not-
different. But
Yes.
how can you obtain a 144 order against the club where you have suspended?
Not the club, Mel. It's only against the members of the club who are not ready to enforce an order of court.
How can you?
Well, it's-
144? How can you?
Well, it's not against. Well, it's against a particular.
How can you?
Well,
You are suspended from a club.
not my lord, he is expelled.
Whatever. You are
I'm
expelled from a club.
because of the breach of peace in and around the surrounding
How
areas.
can you? Where is your obligation? What is your
No, I'll
right?
tell your lordship,
What is your right? You are expelled.
now that the order of injunction, this particular order of
Sir, order of injunction, if is violated, where is the provision?
order 39 rule 2A, my lords.
So how can you go for 144 and obtain an order?
It was against this particular interim order that I seeked enforcement
No,
before the club.
how can you?
I'll tell your lordships why. Because if your lordships take a look at the articles of the
no.
of the club,
Sorry, no.
well, then I'll give an undertaking that I won't go before. I'll give that undertaking until then I would return.
Yes, I will record your undertaking
Until the return.
and you,
Don't until it returnable.
Well, but kindly appreciates.
Mr. Banerjee.
I'm sorry.
Well, it's only until the return, because I'll take remedies, then I'll file an appropriate application before the trial court. I'll exercise my right.
So what undertaking? Tell me you are.
Till the returnable date, I'm not going to the club. Till the time they file an appeal before the club, I'm not going to the club. In any case, I haven't been going to the club, my lords.
Very well.
I've not been going to the club.
The opposite party number?
One month. There is only one.
আচ্ছা সবার appearance গুলো দিয়ে দেবেন সবার appearance গুলো দিয়ে দেবেন give all your names. The civil suit has been filed by the opposite party number 1, who was a member of the club, but subsequently alleged to have been expelled from the club on some alleged disciplinary grounds. The opposite party number 1, the expelled member, being the plaintiff, has filed the civil suit and obtained an ex parte injunction.
Ex parte ad interim.
Ex parte?
Ex parte ad interim.
Ex parte ad interim injunction on September 24, 2025. এটা কোন ক্লাব? Which club?
CCF, Calcutta Cricket and
ঠিক আছে।
Football Club.
কি বললাম? সেপ্টেম্বর, আচ্ছা শুনুন, কোথাও যদি অসুবিধে হয় আমার সঙ্গে সঙ্গে থামিয়ে দেবেন, 15 বার থামাবেন, আমি কিচ্ছু মনে করব না। হ্যাঁ বলুন। September 24, 2025. The order of injunction was passed by the learned court, by the jurisdictional civil court, till November 3, 2025, keeping in mind the ensuing puja vacation, then. Full stop. The paragraph, the appropriate legal remedy is by way of an appeal before the learned district judge of the jurisdictional civil court. ওই কাগজটা কোথায় দিল? একটা নোটিফিকেশন। হ্যাঁ। Paragraph. Learned Senior Counsel Mr. Shaumo Mujumdar, appearing for the club, submits that though there has been a notification issued by the office of the district judge of South 24 Parganas, dated September 8, 2025, that the vacation bench shall be there on October 17, 2025. But he has received instruction from his clients that the court is actually not functioning.
As far as civil matters are concerned.
Insofar as the civil appeals are
Civil appeals.
concerned.
Yes, my lord.
Full stop. As a result, the club has not been able to file the necessary appeal before the appellate court, before the jurisdictional civil court. First. Hence the urgency leading the club to move this instant application before this court. Paragraph. Mr. Mujumdar further submits that the opposite party number 1 has been creating disturbance and resisting the club from carrying out its regular affairs by virtue of the said ad interim order of injunction. Paragraph. Mr.
Rajdeep Mantha.
Rajdeep
Mantha.
Mantha, learned counsel, appearing for
Opposite party number 1, plaintiff.
opposite party number 1, submits that his client has already obtained an order from the jurisdictional criminal court under section
107 of the BNSS.
107 of
Well,
BNSS.
And I've also intimated Melits filed 2 complaints before the concerned PS.
Full stop. His client has also lodged complaint before the jurisdictional police station. As because the access of his client is being resisted to the club. Full stop. After hearing the rival contentions of the parties and upon perusal of the materials on record, you are for? Who is he?
I am taking the point of maintainability kind of.
Okay, maintainability of what?
It's a settled law. Internal.
All right, wait. কি বললাম? Mr. না এটা আফটার এর পরে লিখুন ওইটা কেটে দাও Mr. Nirmalno Dasgupta, learned counsel, appearing for opposite party number 2, as a member of the club has raised the point of maintainability of the civil suit itself. Full stop. Paragraph. After considering the rival contentions of the parties and on perusal of the materials on record, it appears to this court that the ad interim order, though ex parte, has been passed for a limited period till November 3, 2025. Admit that. কি বললাম? Till November 3, 2025. First up. Learned counsel, Mr. Mantha, appearing for
Opposite
party number 1 on behalf of his client and upon instruction from his client, submits that
is that I will not go to the club premises to ensure the peace.
The opposite party number 1 shall not enter into the club premises till November 4, till the time,
No.
till the time the club files an appeal from the impugned ad interim order of injunction. Full stop.
Malas, kindly makes it.
I will. Yes, next submission you tell me.
I'll have it.
Just hear me, hear me.
I'm sorry.
Full stop. Considering the above, it appears that since the order is appealable, this court shall not interfere with the same at this juncture. At this juncture. It is full stop. It is also made clear that this court does not express any opinion on the rival contentions of the parties or on the point of maintainability of the suit. Full stop. The applicant club and or any other parties to the civil suit, if is the applicant club shall be at liberty to file appropriate appeal before the appropriate appellate civil court positively within November 10, 2025.
Deeply obliged to your lordship.
November 10, 2025. Full stop. Paragraph. In the event such an appeal is filed by the applicant club, the same shall be taken up for consideration by the jurisdictional appellate authority forthwith, subject to its convenience, but without granting any unnecessary adjournment to the parties. That's all.
Well, it's just
Only one humble submission.
No, Mr. Banerjee, senior first.
My lord, only a humble submission. My lord, only one minor correction. My lord, your lordship has restrained him from
I am not restrained.
No,
He has
he has
undertaken.
not to enter till the appeal is filed.
Till the appeal is filed.
Now, not in the event.
Ten.
Taken up. Till the
I'll
appeal is taken
tell
up.
your lordship, was it?
Please,
Sorry, let my
No. Till the, because now can I make my observation?
Please.
The moment he will file an appeal, he will get right to make an application. Before the appellate forum.
will kindly not.
That-
My only.
Make an application. with-
No. You can also.
Right.
You can also, sir. I am protecting you till the time of the appeal being filed. That's all.
This is his undertaking.
No.
He said he is undertaking.
I was.
He has undertaken till the appeal is filed.
Till the appeal is filed, but
Lordship,
I'll just.
only one humble prayer, another prayer with subject to your lordship's convenience, my lord. Your lordship will correct that the
Hey, shouldn't apni to sign it?
appeal to be disposed of within a particular time.
Sir,
Particular
sir.
time.
Knowing the burden, I will not.
There is just one difficulty, Malaj. In the meanwhile, if I prefer a remedy under Order 39 Rule 2A, and there are orders that are no, Malaj, this observation, so because the courts are reopening on the 28th. Now I will.
Sir, I have only made an observation on his statutory right.
I understand.
That he has a statutory right to file
Malaj,
it.
kindly just consider what I'm saying. What I'm trying to say is that since my undertaking is till the time the appeal is filed. Now, if I prefer an Order 39 Rule 2A and some orders are passed in my favor, assuming so, on the reopening, itself on 28th or before the 10th,
Sir, I
then
will
my lord, this order will probably come in the way of that, my lord.
no,
Then your lordship
not
just
at all.
clarifies that, my lord.
No, no.
That if I prefer
You
any
cannot
remedy,
preempt
I have
things like
said
that.
that I have expressed no opinion on rival contention.
Malaj, in the event that I have, Malaj, if I file an order 39 rule 2A today, and suppose there is any order that is passed in my favor, then the fact that I've given an undertaking to the 10th,
can't
Malaj, will come in my
Preempt things like that.
No question. You have already undertaken
That's
not to enter.
Exactly. I have no, I'm bowing down to my lord on this.
Whatever,
I'm bowing down.
whatever steps. A junior member, sir. Junior member is trying, sir.
No, my lord, I am quite overwhelmed.
Against the dawn of the bar.
With seniors over here.
Junior member. Till 10th you are restrained by your undertaking.
Yes.
You have fairly undertaken before the court on behalf of your client that till
Yes.
the appeal is filed.
Yes.
So till 10th of November, you are not entering. After 10th, your right is also open. His right is also open.
Then your lordship just clarifies the date then.
I have made
Yes.
this
Recorded.
One that it's still 10. Millet will say that you will not enter. Millet has not made a time frame, Millet schedule Millet for the land district just to dispose it of. Millet in that event, if Millet 10th evening or Millet 11th he started Rakla, inter thing is Millet.
No, he has undertaken. He has undertaken.
minor appealing.
He has undertaken.
Sorry,
Tenor.
Mr. Dasgupta, you are appearing for a member. Your right is restricted only to your membership. Right? You are not the club. You are not the club. Sorry, no. Ashud.
Kindly hear me for
No.
2 seconds. Millet kindly.
Then I will make my observation with regard to the right of a member.
No, my lord, your
Not
lordship-
necessary. Not necessary in this case at this juncture.
At this juncture.
No, if he makes this submission, I have to deal with it.
But he was included in the suit as a defendant, an office bearer of the club.
All right. Next. কি বললাম? না in the event দরকার নেই। কি বলেছি in the event?
Such an appeal is filed applicant of the club.
No, by the applicant club.
Applicant club shall be taken up for consideration by the jurisdictional appellate court, subject to its convenience, but without granting any unnecessary adjustment to the parties.
Full stop. Once again, paragraph, it is made clear that this court has not gone into the contentions and rival contentions of the parties. Paragraph. With the above observation and directions, this application, আমার স্টাইলটা হচ্ছে বোল্ড হয়, this application নম্বরটা বোল্ড হবে, CO 3746 of 2025, 3746, এটা ওভাররাইটিং আছে, 3746 তো দেখে নিন, 3746 of 2025 stands disposed of, comma, without any order as to costs.
Grateful to you.
Deeply obliged to you.
There's just one small observation. Innocuous, Malaj, submission was made by the club that I was creating a ruckus. I'm just disputing and denying that. That is all, Malaj. This is that observation that I'm disputing.
আচ্ছা
and denying.
আচ্ছা ঠিক আছে,
That's all.
কি বললাম ওপরে, এর আগে একটা লিখে দিন, ওই লাস্টে ইট ইজ ওয়ান সেকেন্ড কি বলেছি পড়ুন,
Once again, it is
তার আগে একটা প্যারাগ্রাফ, একটা লাইন, the allegations of the club are disputed and denied by the OP number 1, opposite party number 1.
Deeply obliged to you.
I'm
Grateful
grateful.
to Wish your lordship a happy remainder vacation.
Thank you, Mr. Banerjee. Thank you.
Please, if we have 2 minutes of your lordship's time, I'm sure that they'll start out.
Lord,
27, my lord, from order of injunction.
Lord, item 2, my lord, I am appearing, my lord, for the petitioner. But my lord will kindly hear, my lord, Mr. Ray, my lord, who is more proximity to my lord than my lord I am presently. So, my lord,
My lord, same, my lord, appellate. My lord, 2 things. My lord, in opposition, my lord, there are 2 things. My lord, again, appellable order. My lord, we have just heard your lordship's observations in this regard. My lord, there is of course.
অমায়িক হয়ে
My
যাবে।
lord, kindly hears me whenever your lordship wants. Whenever your lordship, if they're finished, my lord, may I
Sir,
just.
kindly read the order.
Where for the petitioner, Mr. Ray, you should.
Page, page,
My lord,
page,
my lord,
page.
my lord, 338. My lord, 338. But I'll only point out
আরে আগে আমায় আসতে তো দে।
3 pages only. 338, my lord, first.
Kindly appreciate the pressing urgency for which
Yes,
this
yes,
must
there
be
is.
moved in revision.
Even for one.
Extreme pressing urgency, Mr. Ray.
Should not be
And
kept.
also the
My lord,
pleading.
kindly look at the order. My lord, I do not
338, my lord.
think,
From the residents, Learned Senior Counsel is saying extreme urgency.
my lord, not necessarily, my lord, the residents where, my lord,
Not the residents may not be, my lord, which
my lord, may not be, my lord, within jurisdiction residents, my lord,
Residents other than state.
other than state, my lord.
my lord, he's understood.
My lord, some duties, my lord, have to be undertaken, my lord, by.
My lord, he doesn't want to enter into contempt jurisdiction, my lord.
Judicial duties
My lord,
and extrajudicial duties are colliding.
My lord, I just want to make one submission, my lord. In fact, my lord,
You're for the applicant.
I'm for the applicant, my lord. I'm leading Mr. Ray, my lord. Just one submission, in my lord. I'm so sorry, my lord. I have to take my lord's leave because I have some, my lord, personal, my lord, difficulty, my lord. This is, my lord, a company matter where, my lord, will see, my lord, what orders have been passed. My lord, that's my first submission. My lord, by a shareholder, my lord, who claims to be a shareholder, and my lord, gone to a civil court, and my lord, obtained orders, which, my lord, at least I have not seen. I don't know, my lord will kindly look at it. I've never seen such drastic orders being passed, my lord, without any reason and in a company jurisdiction. My lord, the little that we know, my lord, with regard to, my lord, shareholders having no rights with regard to company properties, shareholders having no right, my lord, in a civil court with regard to company administration, all has been flouted. All have been flouted. And, my lord, orders have been passed, which, my lord, reduces, my lord, the companies, my lord, the three companies, my lord, 4 companies for which, my lord, we have preferred the applicant, completely, my lord, to a standstill so far as its operations are concerned. My lord, will
Any
kindly
company-
consider.
No company petition has been filed.
No. Civil suit filed, my lord, by a shareholder who says in paragraphs 48 and 49, my lord, will find, he says he does not qualify because he doesn't have the share of 10%, but that is, my lord, no longer a bar because, my lord, there's a question of obtaining leave under the Companies Act. My lord knows that much more than me, my lord, 244. My lord, there's a question of, my lord,
And that's
leave.
his only pleading.
And, my lord, he obtains.
The company petition.
And, my lord, 3 grounds which we have challenged. I'm sorry, my lord, I'm just making the submission. Mr. Ray will, my lord, also
My lord,
address.
I'm taking
My
a
lord,
point of
no-
maintainability.
Yes, we know that. We just heard on the question of maintainability.
ওটা
My lord,
চারে সাদা কাগজ স্টেপলিং করে দিতে বল।
my lord, no reasoning in the order. Secondly, my lord, on the question of jurisdiction, my lord, whether a civil court can exercise, my lord, these kind of drastic jurisdiction so far as, my lord, companies are concerned.
আরে A4 কাগজ দিতে বল প্রিন্টারতে। 4-5টা একটা স্টেপলিং করে। হ্যাঁ, yes, sorry.
So, my lord, that's sorry, my lord, I'm so sorry, my lord. First point, my lord, is question, my lord, order is a nullity because it's without reasons. Secondly, my lord, on the question of, my lord, no jurisdiction so far as, my lord, a company matter is concerned, my lord, to pass these drastic orders. My lord, it has to, my lord, if at all, go under a company petition. And, my lord, thirdly, my lord, an ex-party order has been passed. My lord knows under order 39, my lord, rule 1 and 2, my lord, and 3. My lord, one has to give a reason why you are passing an ex-party order. Here, my lord, will find.
Morgan Stanley.
Absolutely. My lord, we are relying on, my lord knows Chadda, 1993, 3 SCC,
Morgan Stanley.
1994, 4 SCC, 225. And, my lord, not only that, my lord, the cause of action, my lord, will find in the, my lord, documents which the court has relied upon is from 2002. They complain of, my lord, issues from 2002, and, my lord, they come and, my lord, obtain an ex-party order. I don't know how, my lord, it's been obtained, but it really, my lord, baffles all of us.
Para
And, my lord,
48.
and, my lord, so far as, my lord, the question of, my lord, maintainability, my lord, there being an appeal, my lord, that other matter, my lord, has already considered it. My lord, I'm told, my lord, we also found out there's really nothing, my lord, happening, which, my lord, has just decided. I heard, my lord, the item 1, my lord, which was there. So, my lord, kindly consider, my lord, we are asking, my lord, subject to what, my lord, my lord, there should be a complete stay insofar as, my lord, operation of this order is concerned. Then, my lord, it should be heard again. And, my lord, whatever, my lord, the learned, my lord, judge wants to pass an order after hearing us, my lord, that should be passed. But there should be a complete stay of this order. My lord, they can't enjoy this order with great respect, even for, my lord,
What is the nature of the order, Mr. Banerjee?
My lord, kindly just have a look at the order. My lord, just kindly have a look at.
Stop the running of the
No.
company completely.
Injunction, my lord,
Selling the properties.
My lord,
No, my lord, injunction restraining, my lord, I'll just read out, my lord, the
Let us
orders.
read it. Let us read it.
Yes, kindly, my lord, have a look
My
at
lord,
the order.
injunctions granted.
Page.
My lord, page 338, my lord.
My lord, only one thing. My lord, there are two matters in your lordship's list, item number 2 and item number 7. They are both, my lord, from the same order. I appear in item number 7. Senior Mr. Shah appears in item number 2, both for the plaintiffs. My lord, I have certain, my lord, points, my lord, with regard to, my lord, your lordship's, my lord, whether your lordship will entertain this matter at all or not. Kindly, my lord, hear me for half a minute on that, my lord, and then, my lord,
Kindly read
even
the order.
Mr. Shah, can we just take my lord to the
Sir,
order and
because
then
this
I
was the
will,
point of maintainability, my lord.
I
I'll
will take,
repeat
let
that.
us look at the order,
Of course,
Mr.
your
Shah.
lordship will see the order.
All
Of
right.
course, your lordship will see the order.
So let us see the order.
Yes,
Yes, kindly look at the order and then, my lord, I'll.
My lord, your lordship will see the order, but my lord, just give me half a minute, not more than that.
Why
My
not?
lord,
more
it's
than
an order of injunction.
Why not more than that? It's always
No,
a pleasure to
initially
hear
half
all
a minute, my lord, because my lord,
No,
Mr. Ray is in a slightly belligerent mood, my lord. He's
I'm always.
and he has no other court to go to. He has
Mr.
no other court to
Shah,
go to.
I have nothing else to do also except for one personal issue for an appointment. May I just take my lord to the order and then I shall leave you and Mr. Ray
Yes,
in peace.
That's why he's wanting to show the order.
Very well, my lord.
Just give me one. I'm so sorry. I'm just,
Very well.
Yes.
my lord, kindly, my lord, look at, my lord, the,
Page 339. Let us
Yes, my
come
lord.
to the operative part first.
yes, my lord. My lord, just before the operative part also, if my lord just looks at, but it's a very short order.
Yes. No, let's see the nature of the operative part.
Yes,
Let's
very well, my lord, very well. Ordered, my lord says, prayer for ad interim order of temporary injunction is allowed. All the principal defendants, including the men and agents, are hereby restrained in the matter of taking financial decisions in respect of defendant number 629. My lord, these are the incorporated companies. And misappropriate the fund of defendant number 629 companies. I don't know how, my lord, that kind of orders can be passed. Anyway, the defendant numbers 129 and made agents are restrained from utilizing or spending the advance amount as on or par consideration of rupees 15 crores as mentioned in development agreement. My lord, kindly sees the date 11 January 2023. Executed between defendant numbers 1, 6 and 10 without furnishing proper financial security before the court. Defendant numbers 1 to 10 and the men and agents are restrained from raising any construction over the suit property mentioned in Schedule A property. The defendant numbers 1 to 5 men agents are also restrained from transferring, selling out, assigning, alienating, creating any third-party interest in respect to the movable and immovable properties of the defendant number 6 to 9 companies. Defendant numbers 1 to 9 and the men and agents are also restrained from transferring, selling out, assigning, alienating, creating any third-party interest in respect of the A and B scheduled properties. Now, my lord, shareholders have no right, my lord, in respect of company properties. My lord, that's what we have grown
Then
up
the
with.
company goes into liquidation.
Yes. The defendant numbers 1 to 9 and the main agents are restrained from using the fund of defendant number 6 to 9 company and mismanage and or misappropriate the fund of defendant number 6 to 9 companies. Lord, can there be an injunction order with regard to that? Defendant numbers 1 to 5 are restrained from holding any AGM, EGM, or execute any past, present, future board resolutions. In absence of plaintiff in matters related to defendant number 6 to 9. Order shall have effect till
What was
such.
Just pleading type of shot করে দেখুন।
Yes.
And my lord, if my lord just comes to my lord, the
Pleading.
beginning of the order, no, just Mr. Ray, just give me. My lord will see, my lord, the allegations are given, and particularly, my lord will kindly note, my lord, allegation to suppression of shareholder, no notice of AGM to plaintiff since 2008.
Where?
My lord, plaintiff has raised the following key allegation. My lord finds, my lord, to the beginning of the
There
order.
on the left, my lord. Page 338. Also 5 minutes kindly.
Yes, 2, 3, then 4, then 5.
500 crores over
20 years. Then 6 unilateral development agreement with Primark. Below, this is the 2023 agreement. And then, my lord, sees heard the learned advocates for the plaintiffs who pointed out the documents filed by the plaintiff, RT application shown from where the knowledge is gathered regarding misappropriation of assets. My lord, I don't know how, my lord, from documents it can be gathered.
On these documents.
Share lying under the ownership of the father of plaintiff is transferred in favor of defendant one, excluding plaintiff. Then memorandum of association is changed by the inclusion of own family members, defendants. Relevant pages of annexure document are shown. Then, my lord, sees on careful perusal of the documents filed by the plaintiff, it appears that the interest of the plaintiff in respect of power tools and appliances companies is being infringed.
That's
The
the company.
plaintiff has shown, and my lord, plaintiff is a shareholder. So, my lord, shown support. Then, my lord, relies on all these documents. Again, my lord, there's nothing there. Well, it will find 14.
And Malad. Huh.
Then, my lord, sees the documents are given.
If
Yes.
Mr. Banerjee could
Documents show, then, my lord, considering, then, my lord, just one, Mr. Ray, just give me. My lord, I'm so sorry, my lord. My lord will just kindly see documents filed by the plaintiff shows fraudulent transaction, misuse of industrial, siphoning of such. Considering the 3 points, prima facie case. So, my lord,
But where?
my lord, the documents are immediately after, my lord, those
Document filed
documents.
by the plaintiff shows.
Fraudulent property transactions. I don't know how documents will show that, as well as misuse of industrial land. Siphoning of cash is also apparent. There is necessity to pass ad interim injunction, as otherwise the plaintiff will suffer irreparable loss and injury. Considering the 3 points, prima facie case, balance of convenience, inconvenience to the urgency, this court is satisfied to the point of allowing ad interim injunction restraining defendants. Plaintiff has paid for ad interim mandatory. And then, so, my lord, first is no reason as to, my lord, why ex parte. And Morgan Stanley, my lord, requires, Chadda also requires, my lord, remembers that you have to say why you are granting an ex parte.
All right.
And
So no reasoning, and it's a drastic order.
Mr. Banerjee will
My lord,
kindly show para
Mr. Ray,
47.
my lord, may I just take my lord's leave? I'm so sorry, my lord, I won't have.
Since he was completing on that, Malad, if your lordship kindly allows me to place 2 paragraphs only.
I will take my lord's leave, my lord. I'll take my lord's leave, my lord. I'm so grateful, my lord.
Malad will kindly straight away come to page 33 of the petition, Malad.
It is 64.
Running page?
No, 34.
33 bottom, Malad. But I'm just taking your lordship to their admitted case.
Yes, yes. 1 second. You proceed in your own way.
Yes,
No hurry.
I'm very grateful.
No hurry. I will hear your other side also.
Yes, yes.
No problem.
Petition.
This is the suit.
This is the plaint.
Plaint.
I'm not going to the other paragraphs. This is the cause of action paragraph, which how they have pleaded, Malad. Plaintiff states and some paragraph 47, Malad.
Page.
Plaintiff states.
Page.
Oh, Malad, 33 bottom, Malad. Sorry, Malad.
33.
Oh, CO to page 61.
Oh, it is 60.
Malad, 61. CO page 61, Malad. My fault, Malad.
Mr. Shah, take your
Yes,
seat.
madam.
Let him complete.
Because I had to pull his chair.
Why?
I'm trying to forewarn him.
I'm very grateful.
Yes. Yes, sir.
Malad,
Which
kindly
paragraph?
take para 47, Malad.
62.
60.
No.
63, Malad. I mean,
47, 63.
63, Malad. Plaintiff states and submits that the defendant numbers 1 to 5 have no right to hold any meeting. Malad, these are shareholders, including annual general meeting and emergency general meeting and or any other meeting at any place in absence of the plaintiff being the shareholders of defendant numbers 6 to 9. These are the 4 companies. Cross-holding companies, Malad, made target companies, defendant number 6. Then, Malad, and also defendant numbers 1 to 5 no right to misuse and misappropriate the funds of the defendant number 6 to 9. Malad, shareholder versus shareholder. Then pro forma defendant, that is not there. That the cause of action. Now, can you see para 48? Arose on 28th August 2002, 28th August 3, 5, 2008, 10, 8, 18, 18, 18, 25. Malad, there is nothing with regard to this, Malad. Section 3 is a complete, Malad, duty cast on the court. There's nothing to show that. And my lord kindly sees, the learned just notes that over 20 years, 100 crores have been misused, my lord. But the question of limitation was absolutely galore. And now what I'm trying to show your lordship, my lord, this is with regard to that limitation. Kindness is 49. After this, my lord, I say, my lord, this is an admission on pleadings that this is a company action. It is a company action. It says plaintiff has less than 1/10 share in the different number 6 to 9, and accordingly, civil courts have the jurisdiction deal with the matter. But this class action, my lord, which has been overcome now, my lord, after the 2013 Act.
With the leave.
With leave. Unless he goes for a leave and is refused. But the question of any civil court does not have jurisdiction. And now, my lord, the question as to whether these fall under 241, 242 is also in an admitted situation. Because if we take his pleadings, if he was 10%, then this court wouldn't have jurisdiction. It's only because I do not have 10%, this civil court will have jurisdiction. So it is not doubted in any manner that it's a company action. Now, looking at this, my lord, your lordship will kindly then see another point which they have taken, the question of fraud. And now it has been settled by the Supreme Court very recently, my lord, in September, that all questions of fraud vis-a-vis a company will be dealt with by the NCLT. Justice Dipankar Datta's division bench, my lord. So, my lord, it's settled. So, I am relying on this para 49, putting them on notice. They are saying this is the suit. I do not need to say any more. Now, the question of why your lordship will come in and assume jurisdiction, my lord. This is the main problem, my lord, today, my lord. On the face of it, your lordship has seen the order also, and Mr. Banerjee, please, I'm not, because it's a division, it's a vacation bench, and I don't want to repeat. Now, my lord kindly appreciates 227, my lord, with humility, your lordship has already seen, my lord. I was also joining in from behind, my lord, in the last matter, because we have seen, we have sent people, nothing is happening there. Now, vis-a-vis this, my lord, the question of urgency kindly appreciates. The running of all these 4 companies come to a standstill. The last, the penultimate direction, my lord, no use of any funds, no resolution to be passed. But that is completely, my lord, taking the company by its neck and throttling it. And why should a court do it? After, my lord, from the pleadings, it appears that it's from 2003 that they are trying to say all these things. I'm not going into this. And the timing was the last day of court. Last day of court. But it's a pressure tactics, nothing else. Malan, if I show the documents, your lordship will find these shares and whatever transfers. He was a member. He was a party to all these things. I'm not going into that. I'm on the point of jurisdiction today only. Now, my lord kindly appreciates 227 is not a bar. With your lordship, my lord, it's not a bar at all. It's a discretion. Your lordships have held it high that this discretion will be maintained, that we will not use this discretion. But your lordships have also kept it open. And your lordship specifically held where justice has to be done and where there is error in jurisdiction. I am only taking that point on the point of jurisdiction. I'm not going to, and I have not shown your lordship anything of fact. But for the pleadings which is admitted, so, my lord, I will just refer to one single judgment, my lord, and then I'll take your lordship to 2 other judgments, because I've got several judgments and I don't intend to, but on the same point. But on the same point, my lord, though I'm starting with a Calcutta High Court judgment.
On the same point.
On the maintainability of a 227. In spite of, my lord, there being a, my lord, alternative remedy.
Yes, of course.
So, my lord,
if the jurisdictional error is glaring.
That is what I'm on, my lord. In this matter, my lord, I say jurisdictional error is glaring on the face of it.
And whether the balance will also be considered at the same time.
To subserve the interest of justice.
Not only that how far this order will affect.
My lord.
How far this order will affect. Even if an order is without jurisdiction, maybe.
My lord.
But if it is seen by the court that yes, it can be permitted to remain for 2 days so that the regular forum can deal with it. That's a different issue. And if it is seen that the order is such that it affects the other side, opposite parties so badly that even if it suffers, though it suffers from the jurisdictional error, it cannot remain.
My lord.
Those are the laws.
My lord, yes. So, my lord, I'm not only, my lord, if your lordship kindly allows me, my lord. 4:30 দেখানোর তো আর দরকার নেই।
Give me that September judgment.
Yes, yes. এটা জজকে দেবো।
Relevant paragraph?
Yes, ma'am. মানে 23, 25, 30 and 31.
23.
Actually, I'm ঠিক আছে। মানে 23 issues are there, my lord. And then your lordship will kindly see 25. মানে 25 your lordship will see. The last sentence there, the findings written by the NCLT, and more particularly having noticed the allegations of fraud and coercion as a fabrication of documents, we have proved to its satisfaction the appellant. We record our concurrence with the reasons assigned and hold the company petition to be maintainable. But I've seen that paragraph, my lord. I'm grateful. Then, my lord, kindly comes to paragraph 30. Decisions are there after 30. Aforesaid decisions confirm the view. NCL and CLB possess a wide jurisdiction to decide all such matters. Incidents are integral to the complaint alleging oppression and mismanagement. That is what they have also alleged. Then such power is, however, subject to any other legislative enactment specifically debarring the NCL and CLB. There is no such enactment. Then in the incident, admit fact that determination of whether the gift is valid or not is central to the decision. Herein, therefore, the NCL did have full jurisdiction. সম্পদটা করে দিত
Yes.
So, my lord, with regard to the second part of their cause of action, my lord, fraud can be now, it is more or less settled, my lord. And why I'm saying this again, my lord, sorry, I'm repeating, my lord. The scope of the company code not having jurisdiction could have risen if it was not a case of operation and mismanagement. Here they themselves say it's a case of operation and mismanagement. Or else the question of 1/10 would never arise. They are considering to those sections. And my lord, formally, I will place that section if your lordship will kindly 244, if your lordship 1 second, that leave.
Yes.
And 430, my lord. 430 is the bar.
That is the bar.
Is the bar. And I'm on that, my lord.
The little I could remember
My lord, yes.
for last, no, I was not in touch for last 5.5 years.
My lord, once
Section 430.
My lord, may I just show
430
one?
and 244.
244. My lord, may I? Just for the complete submissions, my lord. My lord, may I show? My lord, this is reported in 2019, 18 Supreme Court cases 569. Shashi Prakash Khemka, my lord, which says that, my lord, 430. Sorry. Oh, it is all. My lord. সব জানে একসাথে আমি দিয়ে দিচ্ছি একটু নিচ্ছি তো তুমি জানো হ্যাঁ ঠিক আছে This is 2019, 18 SCC 569. Matlab para 5.
Yes. Yes.
There the Supreme Court to a certain extent kept the matter with them with obviously special powers of the Supreme Court, but it has held that with regard to the bar, it's a complete bar.
Yes.
And no, there was this judgment of the Calcutta High Court, just again, it also, if there is a question of jurisdiction, this Gainwell Enterprises versus Ashok Kumar Agarwal, 2014 SCC Online 4259.
What proposition?
That error of jurisdiction, then 227 is white. Alternative remedy will not apply.
Paragraph?
Para 28, your lordship will first find. No, it kindly gives you more, but I think we got the wrong judgment here. No, it is the section 5A.
All right.
I'll take your lordship to one moment. I'll take that back, This is it. Otin Arora, this is Justice Shorkar, your lordship will kindly see this was also a case where a challenge was made to an order passed by the NCLT. Your lordship is well aware NCLT has a specific appellate forum in NCLT. Will kindly see relevant paragraphs, 15, 16 and 19 to 26. But I wish to take your lordship to specific paragraphs where your lordship will kindly see at internal page would be 11, paragraph 19.
27.
Yes, 27 is the main, that's the final paragraph. Error is manifest and apparent on the face of the proceedings. Now, I want to only say that I have come before your lordship, and with humility I say I have been able to establish this part. That is an error which is apparent on the face of the record, considering the pleadings, the order, and the law itself, Your lordship will not be required to go into, the facts and the nitty-gritties of this matter, So, it has seen the order also. They come to a conclusion. But how? The how and why test. How did it come to a conclusion that it is dealt with or otherwise dealt with? What is the reason for this gagging order? There is a gagging order, if I may say so. That is very important. It's a dispute which they have themselves said it's a family dispute. They have been in the family, both two brothers, your lordship has done so many matters on this point, these are companies and they have admitted to it. A brother is saying that the other brother has taken away all the shares. It's a pure question.
So first you tell me,
Both the opposite party number 7, I am supporting, but I don't mind speaking after Mr.
supporting
Mr. Ray.
Ray. Acha. First, all of you are in both the matters.
Senior Mr. Shah is leading me in item number 2. I am appearing alone in item number 7. But I have the same problem as Mr. Banerjee. So with his leave and with your lordship's permission, I'll take 5 minutes, before your lordship hears the
problem. But by consent of the parties, both the matters can be taken.
Yes. Same order.
7 is my petition. I will just make 2 submissions.
Same order, same order.
All right.
No, let Mr. Mitchell then make his submission because then Mr. Shah.
No, I don't mind. First, let me understand that there will be no difficulty if a comprehensive order is passed. All right. Ashun. ওইটা আগে লিখে নিন একটা।
তুমি আগে বলে না, তোমার তারা থেকে বলে না, তারপর বলি। আরে জয়দার কি তারা আছে বলছো? একসাথে ডিল করেছে না?
দুটো 2 and 7 একসঙ্গে একটাই অর্ডার হবে। 2 আর 7 লিখুন। অ্যাপিয়ারেন্স গুলো সব লিখে দেবেন সাহেবদের। এবার লিখুন। Mr. Jishnu Saha, learned senior advocate, appears for the petitioner. Petitioner appears for the opposite party.
Plaintiff opposite party.
Plaintiff opposite party in CO.
In CO, it's CO 3767 of 2023. 3767 of 2023.
3767 of 2025.
2025.
Paragraph. Mr. Joy Saha, learned senior advocate, appears for the petitioner in CO.
Plaintiff opposite party.
Appears for the plaintiff opposite party
In my lord, CO 3756.
3756 of 2025. Full stop. Paragraph. Both being the plaintiffs in these two applications filed under Article 227 of the Constitution of India, submit that both these applications arose from the same order, same impugned order passed by the jurisdictional civil court. In two separate civil suits.
No.
Oh,
The same civil suit.
in the same civil suit. Poster. The opposite parties are also represented by various learned counsel, namely Mr. Obrojit Mitro, learned senior advocate, Mr. Shaunak Mitro, Shaunak Mitro, learned advocate, Mr. Anirban Ray, learned advocate, learned senior advocate, led by Mr. Ratnanko Banerjee, learned senior advocate, bracket VC, Mr. Aniruddha Chatterjee, learned senior advocate, Mr. Jishnu Chaudhary, learned senior advocate. Full stop. Paragraph. All the learned counsel and their respective parties have agreed that both these revisional applications can be taken up together and can be disposed of and can be considered by a single order, single composite order. Full stop. Paragraph. Hence, both these applications are taken up together for consideration. Full stop. Yes, Mr. Joy Shah.
My lord, Mr. Mitro says he'll take just 2 minutes. My lord. Let him-
I will take 10 minutes. If he wants to make a submission, if he's in a hurry, let him make a submission and leave. Personal difficulties.
My lord, in that case, my lord, let me minute. My lord, there is one point on which, my lord, both of us are agreed, and that is with regard to lack of jurisdiction. The only difference is, my lord, he says that the trial court has no jurisdiction. My lord, I say, my lord, that, my lord, he should have come by way of an appeal and not by way of a 227. It's an appealable order. So, my lord, principally, my lord, one or two, my lord, small technical points, my lord. Number one, my lord, the impugned order is under Order 39, Rules 1 and 2. And therefore, my lord, appealable in nature.
Totally. Agreed. Then.
Now, my lord, my learned friends, my lord, cannot straight away come by way of a 227. So that's the first point. Second point, my lord. Second point, my lord, is that, my lord, your lordship will scan the petition. There is an omnibus statement that the district judge's court is not functioning. There is no statement that they had prepared an appeal to move before the district judge, that they had gone before the district judge, that the district judge refused to entertain or applied for certified copy. Zero. So, my lord, before your lordship, other than, my lord, statements made from the bar, there is nothing to demonstrate.
Kunda.
So, my lord, I would have expected that, my lord, at least, my lord, the revisional application would have contained a small paragraph saying that after we came to know of the order, we went there, we applied for certified copy, not granted. We prepared the memo of appeal stay petition, approached the learned district judge, not entertained. We went to file, turned away, therefore we have come. Nothing. On the contrary, my lord, we have, my lord, already shown your lordship. On the contrary, my lord, we have shown your lordship, my lord, the notification which says, my lord, that the district judge is available. Now, my lord, the fact that the district judge is available is conceded by them. The only thing that they say is he is available but taking up only criminal matters. In that case, my lord, they had to write that they approached the learned district judge and he said, I will only take up criminal matters. My lord, in the absence of these pleadings, with the utmost of respect, they have no locus standi, my lord, today to, my lord, bypass this entire proceeding, come and say, I must be heard. Tremendous injustice has been done. My lord, on the point of tremendous injustice, I will come.
Certified copy nahi.
Leave me.
So, my lord, your lordship will see, I am grateful, my lord, my lord, I am grateful to my learned friend. My lord, every rule book has to be bypassed. Why? Because, my lord, there is, my lord, heavens have fallen on us. So, my lord, my lord, all procedure has to be bypassed.
আজকে ফাইল হওয়ার লিভ দিয়েছিল এটা আগে থেকে পুরো ফাইল হয়েছে I do not know this is
7.
leave is granted by the honorable justice Atto vacation means to file the same without certified copy on 16 আজকে is 16 today is 16 that's the file.
My lord, I don't know what is happening. Kindly have a look at this.
Signed on 14 and signed on the 14 that is item number 7. I'm sure was it chatted. How is it possible?
Yes, they've already considered it's the same matter.
What is the scope of this?
Item number
Very well, I'm hearing now two. Let me hear
Yes,
two.
very well, my lord.
If I find that procedural irregularity is there, then I will consider that.
My lord, I will, my lord.
I'll reopen after puja. We cannot invoke appellate remedy.
My lord, I'll my lord, point out two things to your lordship, my lord. My lord, certainly, my lord, all of us on this side also approach, my lord, the 227 court, my lord, when, my lord, but, my lord, there has to be an established procedure. Otherwise, my lord, the Pandora's box will open and, my lord, only 227 will become the only remedy. My lord, I want to show your lordship two things. I want to place, my lord, paragraph 42 and I want to show your lordship the notification from which, my lord, your lordship will find in the district court, central filing is open and therefore, my lord, there could have been no impediment in, my lord, at least, my lord, filing online.
সারাক্ষণ বলছে না company this suit is not just about the company এই প্রেয়ার গুলো দেখিয়ে দাও লজ্জা একটু ভাববেন যে ওটা এটা শুধু কোম্পানির মামলা হচ্ছে
Now, my lord,
district applied for certified.
my lord, slightly embarrassing basic submissions, which I should not have to make.
Right.
My lord, the notifications all speak about, my lord, the functioning of the district and sessions judge. Not only of the sessions judge. And if they are alleging, my lord, that, my lord, this is not being followed, then, my lord, that, my lord, averment must be there in the body of the pleading. It's a very serious allegation to make. There is a notification, I won't follow it. Can the district judge say that? If somebody approaches him, and if he does say that, my lord, then that must be on record. And if they have approached the district judge, they would have done so upon notice to us. I'm sure, my lord, they would not also have, my lord, gone, my lord, and behaved, my lord, in an unruly fashion as we have behaved, and, my lord, asked for an ex parte order before the appellate court. So, my lord, two things. Now, my lord, kindly, my lord, I've shown your lordship, my lord, the fact, my lord, that the central filing was open. Now, my lord, my lord, the my lord, I don't know, my lord, how, my lord, these notifications can just be wished away, my lord. I don't know, my lord. I'll not make any submission, my lord, beyond this.
They have shown pictures.
My lord, only next is, my lord, kindly
এটা
have, my
ফেরত
lord.
এটা ফেরত দিয়ে দিন দিদি, এটা তো দিয়েছে একটা।
দিয়েছে, already দিয়েছে।
Well, I'm insisting on inquiry কি হচ্ছে?
Now, my lord, kindly, my lord, have paragraph 42, my lord, of the divisional application. My lord, your lordship will find it at page 22.
I'm in 2, serial number 2,
Serial number 2.
page, para,
42, my lord, at page 22. Or, my lord, take it from 41 onwards, my lord. Your petition,
yes,
Yes.
42,
41, my lord, take it from 41.
very well.
Your petitioner states that the learned court below has closed for puja vacation from 26th, and as such, there is no scope for your petitioner to obtain certified copy. Very well. Then, my lord, on 26 September, your petitioners were served with a copy of the plaint injunction petition. Your petitioners, through their representative, thereafter downloaded order from the website of the learned trial court, became aware of the order of 25th September, so and so, passed by the court. The court of the district judge at Alipur shall reopen after the long puja vacation on 24th October. As such, your petitioners cannot invoke the appellate remedy. So, my lord, they have completely disregarded the fact that there are vacation benches, my lord, not only before, my lord, your lordship, in your lordship's court, but also, my lord, in the district courts. They have completely lost sight of the fact. So, my lord, the pleadings are to the effect that not that, my lord, that the district court is not functioning. The pleading is to the effect, my lord, that, my lord, during summer vacation, everything is closed. I have no other.
There exists no alternative application.
So, my lord, this is, my lord, completely and palpably, factually incorrect. Without any doubt. So, my lord, your lordship will not even travel, my lord, into the realm whether, my lord, district judge is functioning as district judge or as sessions judge or as no judge, or, my lord, courts are. Your lordship need not go into that. Because, my lord, the pleading is that courts are shut, I can't go anywhere else. The pleading is not that, my lord, in spite of that, there being a notification, I can't go because he's not taking it up. So, my lord, this is the second limb of the matter. Now, my lord, kindly appreciate one thing. So, my lord, your lordship, my lord, is, my lord, being invited to hold, my lord, that today, my lord, at the very first date, that the suit is not maintainable. Now, my lord, I just want to, my lord, dispel this, my lord, notion. My lord, we'll come to, my lord, whether, my lord, the order should have been passed or not. But today, what is the principal challenge? The principal challenge is a company matter. How could a civil court, my lord, how could a civil suit lie? My lord, two things. Number one, I am alleging fraud. I will show to your lordship, my lord, from Justice Dipankar Datta's judgment, there is no alternate view taken that NCLT can decide fraud. I am, my lord, armed with at least 6 judgments that NCLT does not take up, my lord, matters relating to fraud, because, my lord, it has no wherewithal to try, my lord, to try matters. It does not try matters. There is no trial. So, my lord, just, my lord, like in Vidya Drolia. My lord, what did Vidya Drolia say? Booz Allen said, my lord, fraud cannot be decided by arbitrator. Vidya Drolia said, no, you can decide not complicated questions of fraud. So, my lord, it is that. So, my lord, if, my lord, there is some ex facie fraud, you can perhaps go, my lord, to the NCLT. But if the fraud, my lord, is not going to be accepted by them, my lord, I'll say you fraudulently taken away my father's shares. Will they accept it? They'll fight me to kingdom come. They will not accept it. My lord, my entire case is that, my lord, my father, my lord, both brothers had 4%. The elder brother, my lord, has now taken away the mother's share and the father's share, and he says, my lord, he is now, my lord, 96%, I am 4%. Well, so, my lord, will he, my lord, I am saying that the entire process of capturing the company is fraudulent, My father never transferred his, that is my case. Will he accept it? I will have to prove it. I will have to demonstrate it. In which event I can't go to the NCLT. So, my lord, while I do admit that this is, my lord, a matter relating to, my lord, a company, my lord, the Companies Act does not permit me to urge questions of fraud, my lord, before, my lord, the NCLT. I'll give your lordship the decisions. I'll come to that.
Mr. Shah, today I am hearing, take a situation. They applied under Article 227. They are saying, I'm saying they are saying,
Yes,
according to them,
Yes, my lord.
the appellate forum is not available to them. So 227. That's their case, that they're saying. Now, today, I'm not going to adjudicate or make any opinion whether suit is maintainable, whether not. These are their submissions,
I'm grateful.
right?
I'm so grateful.
He says suit is not maintainable for ABC grounds. You say 200% maintainable, ABC are not grounds at all. So these are not to be decided by this court today itself. Question is two. While I'm sitting and taking up 227 matters, I will have to first see whether any jurisdictional error is committed or not. And if the error is such that it might affect the opposite party, if the jurisdictional error is such that it might affect the opposite party with the error, so that on the jurisdictional counts, I can entertain 227.
My lord, I'm so grateful, my lord. Your lordship has, my lord, considerably reduced my burden. My lord, before I proceed further, kindly take page 189. My lord, all that my learned friends have argued, nothing on merits. Nothing on merits. All that they have argued, my lord, is that, my lord, a company matter, my lord, has been converted into a civil suit. At page 189, your lordship will see a development agreement. And that is the need.
Why? 189?
It's
It's a letter.
My lord, the handwritten
Later.
189. Handwritten.
268. 268.
Huh?
68. Volume 3. No, order. Volume 3 to 68.
Yes, my lord. Your lordship has, my lord, development agreement on top, 11th January 2023.
Yes.
So, my lord, your as has fallen from your lordship. First is, my lord, your lordship is examining whether there is any jurisdictional error. My lord, just let me, my lord, overcome this point. There is no jurisdictional error because, my lord, I cannot approach the NCLT because I am alleging fraud which they are not admitting to. And the fraud is not ex facie on
Tribal issue.
some
You are saying it's a tribal issue.
It's a tribal issue.
It's to be tried by a properly equipped civil
I'm
court.
so grateful. Number one. Number two, my lord, is that, my lord, admittedly, as on today, I am 4%. And therefore, I have no automatic right to go to the NCLT. My lord, previously, my lord, under the previous, my lord, 56 Act, my lord, we used to all, my lord, file and say that, look here, this is the manner in which I have been reduced to from 10%, or this is the manner in which, my lord, I am entitled to 10%, they are not giving me. Here, my lord, today, so, my lord, that time, my lord, no leave was required. I could go and file. Here, my lord, till the leave is granted, my petition in the NCLT is not born. It is my choice, therefore, whether I will go to the NCLT and ask for leave or I will go to a civil court. No one can compel me to go and ask for dispensation. Until the leave is granted.
Should I decide that at this stage?
I'm grateful. So, my lord, when my friend says that, my lord, I have converted, my lord, a NCLT matter into a civil court matter, and therefore your lordship should intervene. I'm trying to nip that submission in the bud.
No. There the court may say that first you have to go and take a leave.
I'm so grateful. So, my lord, two things.
If the leave is refused, you have your remedy.
My lord, may I, my lord, answer this question of your lordship? Now, my lord, till, my lord, a leave is granted, the suit is not born. The NCLT proceeding is not born. I can't ask for any interim order. Now, my lord, the granting of leave, they will contest till the Supreme Court.
Yes, maybe.
So, my lord, it is my, therefore, my lord, decision.
Very well. I said
No, my lord, my lord, let me, my lord, try to, my lord, make my point. My lord, kindly, my lord, see. Kindly see, my lord,
Mr. Shah, Mr. Shah, let us first come to the impugned order once.
Yes, my lord, before that, kindly give me half a minute more. My lord, I will show to your lordship that, my lord, under section 244, there are two parts to section 244. One is, this is your eligibility criteria. Especially, my lord, I don't fulfill the eligibility criteria. It says that you have a chance to ask for waiver. You may ask for waiver. My lord, can that be, my lord, read to mean that I must ask for waiver? My lord, that is, my lord, the question which your lordship will, my lord, kindly, my lord, consider. My lord, I have a right to either go to Barasat court or to come to High Court. If I come to High Court, I have to take leave under 12A. My choice.
Suppose.
If I have, my lord,
I have a question. I have a question. Section 80 CPC. Leave is required. Right? So first you have to approach the civil court with the prayer for leave. Leave may be granted, leave may not be granted. You have your own remedy there under. If the leave is not granted till the time, what will be your remedy?
My lord, if the leave is not granted.
Till the time. I'm not saying it is decided that I will not
My
grant.
lord, my lord, as my lord counsel, my lord, to assist your lordship's court. My lord, there are, my lord,
May I just for 1 minute, my lord, I missed out a point. I'll just tell him that. My lord, the number of shareholders in the company is 10. So he can apply as 1/10. That is also there. So that is, my lord,
in all the four companies.
that is, he needs to also submit on that.
Now, my lord, may I say this? My lord, he says that, my lord, I have, my lord, I can apply. I don't need, my lord, anything. Now, my lord, may I say this, my lord, with regard, first I'll come to the section 80 point. My lord, when, my lord, as counsel, I'll tell your lordship, my lord, this is my take on the matter. My lord, there are, my lord, my lord, starting from tab 5, my lord, the Supreme Court has said that even if the maintainability of a suit is challenged, even then you can ask for an interim order. But, my lord, there are an equal number of cases to say that unless the point of maintainability is decided, you can't pass an interim order.
Because it gives
so, my lord, it's in a gray area. Number one. Number two, my lord, is that, my lord, today, my lord, kindly, my lord, appreciate this. My lord, the choice of forum is mine.
Provided it has the jurisdiction.
The choice of forum, my lord, is mine, provided, of course, it has the jurisdiction. Now, my lord, I say that, my lord, because I'm raising, my lord, questions of fraud, I can only go to the civil court. That's my specific case. Number one. And number two, my lord, I also say that, my lord, the moment I go, my lord, I will have to be, my lord, put through, my lord, this rigmarole.
This is what the third asked. This is your answer.
My lord, kindly, my lord, have.
See, question 79 section 80 প্রশ্ন করেছিলেন 82.
My lord, 80 subsection 2, my lord, without grant of notice, no interim order can be passed.
Can be. Leave.
It can be granted.
Leave. All right.
With leave. My lord, it's the same, my lord, when we go and ask for 12A. My lord, I can, my lord, take, my lord, a part of the cause of action arises within a court. I can ask for 12A. Similar sort of situation. My lord, it is not that the civil court jurisdiction is ousted. The civil court's jurisdiction is not ousted, my lord, because, my lord, it says, my lord, that a complicated question of fraud has to be tried by the civil court. My lord, I'll take your lordship straight away, my lord, into that, my lord, those line of cases. My lord, I'll give your lordship, my lord, single bench and division bench of our court.
First, sir, Mr. Shah, let us read the
Impugned order.
impugned order.
Yes.
I am
My lord, your
saying,
lordship has taken note of.
you show me
Yes, my lord.
that the impugned order records
Yes, my lord.
the incidences from 2010 or 2000, whatever,
Yes.
2, 3, whatever,
Yes.
up to 23, the incidences are recorded. The facts are stated.
The lift off from the position.
Kindly come to page 338.
Kindly give me half a minute. চোখেই দেখতে পাই না এগুলো কি
এই বাহাদুরকে একবার ডাকুন তো, এটা আমার নর্মালি একবার ওঠার টাইম।
My lord has to rise.
My lord, impugned order.
Yes.
Lordship.
So now, Mr. Shah, show me that what are the reasons shown.
Lordship. My lord, kindly see, the plaintiff has raised the following key allegations.
Where, sir?
My lord, your lordship will take it the third paragraph.
Yes.
Or my lord, just before that.
Yes. These are all
May
the
I-
case of plaintiff.
No,
stated.
may I just, my lord, this is all a part of his reasoning, respectfully. The plaintiff is a shareholder since 1992, which means, my lord, that, my lord, it is not that, my lord, I am, my lord, fly-by-night operator, suddenly come, want to, my lord, disrupt the business. From 1992, I am a member of the family, I am a shareholder. এক second, দাঁড়াও। Defendant 1 to 5 are family members. Defendant 6 to 9 are group of companies related with the plaintiff. Defendant number 10 is a separate company. So it's an entirely family company. That is the first.
Closely held.
So, my lord, they're closely held family company, my lord, where, my lord, slightly different set of rules apply.
Totally.
Then, my lord, the plaintiff has filed the suit as the disputes arise from systematic acts of fraud. Kindly, my lord, pause here for a moment. So, my lord, he makes note of the fact that the plaint allegation is systematic acts of fraud, forgery, misappropriation. These cannot, my lord, be tried, my lord, by the
These are the
Then, my lord-
submissions of the plaintiff.
Yes. Then, my lord, the plaintiffs raised the following key issues. Number 1, illegal transmission of shares. B, suppression of shareholder rights. Fraudulent property transaction. Fraudulent property transaction
That is the case made out by the plaintiff.
by us. Misuse of industrial land, siphoning of cash of 5 crores, unilateral development. Heard learned advocate for the plaintiff who has pointed out documents filed by the plaintiff. So, my lord,
You are in hurry. So I will complete your submission, then I will go for 2 minutes.
Very good, lordship. I'm so grateful. My lord. Then, my lord, kindly see, heard the learned advocate for the plaintiff who has pointed out the documents filed by the plaintiff. So, my lord, Mr. Ray is, my lord, audibly whispering that what documents? I have, my lord, the last page of my plaint. I'll show your lordship just before the prayers, given a list of, my lord, all the documents that I'm relying.
I admit.
Yes.
For the time being.
Then, my lord, kindly see. So, my lord, he considers the documents. RTI applications are shown from where knowledge is gathered regarding misappropriation of assets. That is the urgency, the RTI applications. Shares lying in the ownership of the father plaintiff has been transferred in favor of D1, excluding the plaintiff. This is, my lord, the urgency of the matter.
This is the case made out by the petitioner.
My lord, respectfully, my lord, this is after he sees the After this is not the case made out, my lord. He is, my lord, concluding, my lord, with the utmost of respect, my lord. This is perhaps, my lord, not, my lord, the case made. Of course, it's the case made out, but he is noticing the case made out. He is considering the case made out. Exclude. So, my lord, misappropriation of assets, shares lying in the ownership of the father have been transferred, excluding the plaintiff. Memorandum of association has been changed by the defendants for inclusion of their own family members. Relevant pages of the annexure document are shown. On careful perusal of the documents filed by the plaintiff, it appears that the interest of the plaintiff in respect of is being infringed. Therefore, my lord, kindly see, plaintiff has shown the documents in support. So, my lord, he makes a list. My lord, I would say, my lord, normally, my lord, interim orders, my lord, do not, my lord, list out, my lord, these are the documents that I have considered.
That is the pattern of writing.
But
One
the
may
pattern
have
of writing
different-
may be, my lord, but it shows that, my lord, this is not something that, my lord, he is just, my lord, off the cuff. He's considered these documents. He's listed out the documents which he has considered. And over here, my lord, kindly see amongst the documents that he has considered. Kindly see, my lord. My lord, kindly see, my lord, Roman 14. My lord, he has considered 15 documents. He's listed them out in the order.
That is the list.
Roman 14, development agreement dated 5th January 2023. My lord, the company has one property. That property, my lord, is being sold away. So, my lord, the question which arises is, my lord, whether the trial court, my lord, should have then decided that let me first decide whether it's a company matter, can come to my court. There is no order 7 rule 11. My friends have not, my lord, invited, my lord, the trial court, my lord, or the appellate court from there to go into the question of whether no order 7 rule 11. So maintainability of the suit has not been assailed till today. Now, my lord, the question therefore, my lord, for your lordship,
Because it was an ex parte identity order.
correct. So, my lord,
Who will take out order
who will-
7?
so, my lord, the question is the judge himself could have. So, my lord, the question is whether at that juncture,
The moment, Mr. Shah,
yes, my lord.
the moment you say the judge himself could have, the moment it says a jurisdictional error, he should have.
My lord, he could have considered this. He could have considered.
On his own motion.
He could have considered
On his own motion.
on his own motion.
Right? But he has not done so.
No, but my lord, may I say this? May I say this? Now, my lord, today, my lord, kindly, my lord, if I may put it in a question form to myself, my lord, somebody comes and shows him a development agreement, registered development agreement concerning the only single property of the company. So, my lord, in the ad interim stage, my lord, if, my lord, today, my lord, these questions are to be gone into, then, my lord, the entire purpose of an ad interim order, my lord, goes out of the window.
Absolutely.
So, my lord,
So he has to give the reason, sir. Mr. Shah, you have to give the reason that I have perused this document.
yes, my lord, that's
And
what.
this document has prompted me to pass this ex parte identity order for the following reasons.
My lord, kindly see, my lord, kindly see.
It may be a wrong order.
My lord, kindly, my lord, permit me to read on. Permit me to read on. The documents filed by the plaintiff shows fraudulent property transaction as well as misuse of industrial land. My lord, kindly permit me to pause. So, my lord, he's shown certain documents.
How the landed judge, how the court comes to a finding at the ex parte identity stage by looking the document.
No, my lord, I'll tell you, lordship. I'll tell you, the answer is not in the document. The answer is in the law. Kindly take section 179 and 180 of the Companies Act. Now, my lord, if it was property, my lord, of my lord, let us say Mr. Aniruddha Chatterjee has a lot of properties. He wants to sell his property, he can, my lord, sell. But if, my lord, it is Aniruddha Chatterjee and Company Limited, then, my lord, there are certain procedures to be followed. What are those procedures? First of all, my lord, EGM has to be convened. The members, my lord, must vote in favor of. Now, my lord, where are those? My lord, we have made out a.
Those, Mr. Shah, when the plaintiff has filed a suit, plaintiff says these have not taken place, right? It's an ad interim ex parte.
Yes.
So the defendant must come
and, my lord, refute.
But that stage
till
has
that
not yet
time,
arrived.
but till such time,
Correct. But till such time, what is the reason? I don't find any reason.
my lord, may I just read this, my lord? I don't think, my lord, my lord, this is, my lord, the reason, my lord, and it is my respectful submission, my lord, that at the ad interim stage, my lord, perhaps, my lord, your lordships hold usually, my lord, these to be sufficient reasons. What is he saying? The documents filed by the plaintiff shows fraudulent type of property. Now, my lord, your lordship, my lord, upon getting their reply, may say that no, there was nothing. But, my lord, can my learned friends invoke 227 jurisdiction to say that, my lord, there is wrongful exercise of jurisdiction? With the greatest of respect, my lord, no.
But those are the line of decisions that without reasons, the order is a
No,
nullity.
that's not, my lord, they are not, my lord, impugning the order on reasons. They are first saying it's a company matter taken by a civil court. There, my lord, your lordship will kindly see, unless this, my lord, issue is raised and the learned judge, my lord, has an opportunity to consider it. Till such time, my lord, the interim order, my lord, with the utmost of
The
respect, must be there.
227 Constitutional Court on a plain reading of the order cannot take its
So, my
decision.
lord, of course, my lord, of course. I would be the last person to disagree on this point. My lord, therefore, what am I saying? I am saying, my lord, kindly let me make this clear, my lord, because I think I have not been able to express myself properly on this. I am saying, with every emphasis at my command, that the suit is maintainable. My lord, now kindly consider 2 or 3 decisions that if fraud is alleged, and unless fraud is ex facie, NCLT has no jurisdiction. So, my lord, where do I go?
No, sir, first you satisfy me on the reasons. I will not go on those.
So, my lord, so far as the reasons are concerned,
Those will be all open for both of you
kindly see, my
to
lord.
fight out.
Yes, so the reasons, my lord, are that he considers 15 documents. From the 15 documents, he finds that document number 14 talks about a development agreement which has already been done behind my back.
How does he know behind your back? It's an ex parte stage.
My lord, behind
then
my
he has to
back,
prove
so
it
my lord,
himself.
he has to rely only on the pleading made in the plaint.
That's right.
Ex parte stage.
Absolutely.
So I say that it has happened, my lord, in complete, my lord, keeping me in darkness. So, my lord, at the ad interim stage, he has no right to raise these issues. It's only the plaint, my lord, that the learned judge has, and that is the only thing that he has to consider till such time that his Order 7, Rule 11 is on record. So, my lord, my respectful submission is that, my lord, at this juncture, my lord, what does he say? He says, I've seen 15 documents. One of those 15 documents is a registered development agreement. He goes by the averment in the plaint, my lord, that, my lord, we are kept completely in the dark. He goes by the averment in the plaint. This is the only, my lord, property of the company. And he goes, my lord, on the balance of convenience and on the irreparable injury, that if this is taken away and, my lord,
Where are the whispers?
Lordship,
Where are those whispers in the order?
my lord, may I say this? My lord, they are admitting that they have received 15 crores. Kindly bear with me for 1 minute.
No, sir. I am exercising my power
Yes, my lord.
under 227
Yes.
on an ad interim ex parte order.
Yes. Ad interim ex parte order, my lord.
Had it been a contested order,
No, ad interim ex
the
parte
approach would
order.
have been different.
My lord, ad interim ex parte order, which is appealable. I'm not giving up that point, my lord, that, my lord, they could not have.
Absolutely. Yeah,
My lord, ad interim ex parte order, my lord, your lordship will see. He says, I've considered 15 documents, 14 documents are this. This is what I find upon perusal of the documents. They're fraudulent. Now, my lord, your lordship may ultimately say that no, you could not have held it fraudulent. But where is the lack of jurisdiction? I ask myself the question.
No, I am not on again.
So, my
Mr.
lord,
Shah,
whether, my lord, the supervisory jurisdiction of your lordship's 227 court will be called into play, because, my lord, the conspectus of an appeal is much, my lord, smaller than, my lord, what your lordships exercise under 227.
No, my 227 power is wider.
Much wider. So, my lord, the grounds on which he could have preferred this appeal, he circumvents that. He comes to 227. Now, my lord, whether, my lord, these decisions are sufficient decisions, not sufficient decisions, that can only be decided, my lord, upon affidavits coming or upon him making on Order 7, Rule 11. Those are not before your lordship.
No, I am not on the Order 7, Rule 11, Mr. Shah. I will not make any comment on Order 7.
My lord, may I only say this? My lord, may I only say this? Kindly just permit me to
I am
read.
just reading the order. That's
Yes,
all.
just, my lord, permit me to read one more paragraph. considering the 3 points, prima facie case, balance of convenience, inconvenience, court is satisfied. So, my lord, he has considered the 3 golden principles. He feels, my lord, that, my lord, for the purpose. Now, my lord, neither in Morgan Stanley nor in any other decision, my lord, will your lordship see, my lord, the extent of reasons to be given. Or, my lord, any quantification of the court that you must write 5 pages.
Yes, but equally, the 227 court must satisfy its
Correct, my lord,
conscience that
yes.
reasons are there.
I 100% bow down. Now, my lord, that is exactly what he said. He says, I've looked into the documents. He finds from the documents, my lord, that, my lord, a family company, one of the sons, not consulted, father has died, shares have gone away. So, my lord, that being, my lord, the conspectus, my lord, the learned judge felt, my lord, perhaps that before they come, there should be an order.
জজ বলছিলেন না যে কোথা থেকে মানে কি করে জজ বুঝবেন the judgment is 88 Calcutta 24 paragraph 6 whatever statements I have made in the plain have to be taken to be true. There cannot be any deviation.
My lord, my lord, in my turn, my lord, I'll, my lord, request, my lord, Mr. Chatterjee to address your lordship briefly. But, my lord, this is, my lord, a proposition that he wants to say is, my lord, so well entrenched, my lord, and it's so, my lord, written in stone that it does not really require a decision, although he's giving your lordship Supreme Court on this. My lord, if, my lord, till such time that a competing pleading is before your lordship, my lord, the court has to. That's why, my lord, in Order 7, Rule 11 applications, you all don't even, my lord, invite affidavit in opposition. Only the plaint.
Absolutely.
So, my lord, if there is, my lord, these set of averments in the plaint, my lord, with the utmost of respect, he says, I've considered the plaint. He says, I've considered these documents.
So these are the.
So, my lord, that is, my lord, and, my lord, therefore, he says, and he comes, my lord, to the 3 golden principles, my lord, and he says, my lord, deserving of an ad interim order of injunction till such and such. My lord, kindly just give me 1 more minute. My lord, your lordship, my lord, will kindly see that, my lord, today, my lord, kindly see, therefore, my lord, there are, my lord, strictly speaking, my lord, the argument made by my learned friends is, my lord, on the question of lack of jurisdiction of the court and the fact that 430 was a bar. My lord, have your lordships heard one word that no, we've not entered into a development agreement? No, you all were present. You all knew about the development agreement. No, you all signed on the development agreement. Has that argument come before your lordship? My lord, while telling your lordship that the court below had no jurisdiction, perhaps, my lord, a modicum, my lord, a small portion of the submission could have, my lord, touched on the facts. So, my lord, when your lordship wait in the balance and find that, my lord, one brother, I am also my father's son, that one brother, after the death of the father, the entire father's shareholding, the lion's share, my lord, has gone to the other brother. My lord, rightly gone, wrongly gone, the court will ultimately decide. And on the other hand, there is a registered, my lord, development agreement of only one property of the company, my lord. My lord, if I tell myself, I can't, my lord. If I, my lord, was, my lord, wearing the judge's shoes, my lord, what option would I have been left with, my lord, for the ad interim relief? And today, my lord, he comes in, my lord, these are my respectful submissions, my lord.
Thank you, sir.
Lordship, I'm so grateful.
If any further submissions to be made by
Not
you,
by me, my lord, my leaders are there, my lord.
I will hear Mr. Senior Shah.
Yes.
But before that, 5 minutes. I'm a Bahadur to talk. I'm just coming within 5 minutes. Yes, Mr. Shah.
Well, two of the petitioners are yet to submit, Mr. Shonok Mitra and Mr. Abhijit Mitra.
Yes, I
My lord,
can-
perhaps, my lord, if they could
Yes.
submit, I could give a composite, my lord.
Whichever way.
response.
Now, my lord, I'll try and keep it short and not repeat anything that Mr. Banerjee and Mr. Rai have already submitted.
You are adapting those.
I'm adopting those because, my lord, we sail in the same boat. I am the majority shareholder of all these four companies. So, my lord, by
OP,
these,
Shonok Bose for OP,
Sonam Mitra,
Mitra, sorry. So sorry.
for OP2,
I've written Mitra, but
I know, OP2 to 6 in item 2 and petitioner in item 7. And I was original D1 to D5 in the suit.
Acha. So OP 2 to 6, defendant in the D7.
D1 to D5 in the suit.
All right.
Now,
Thank
my
you,
lord,
sir.
first submission is, my lord, that the pleading in the plaint, so far as his inability to go to the tribunal, is wrong. Because we have checked for each of the four companies in terms of number of shareholders, he would be entitled to go under 1/10. So the basic premise of him not approaching the tribunal is incorrect. Secondly, kindly have a look at section 430 of the Companies Act once in this context.
What
Please
does it
see
say?
the language of the provision. It's not, my lord, just one line saying no jurisdiction. Please see, it goes a step further.
What does it say?
It says, my lord, that not only will it not be able to entertain, it goes a step further and prohibits any injunction being granted by a court on any matter that is covered by 430. Please have that, my lord. The heading is civil court not to have jurisdiction. And, my lord, there's a similar provision in the Sarfazi Act in which, my lord, there is already, my lord, a decision which I shall show. But, my lord, kindly have this. No civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which the tribunal or the appellate tribunal is empowered to determine by or under this act or any other law for the time being in force. And no injunction shall be granted by any court or other authority in respect. So, my lord, it goes a step further. And it ties in, my lord, with our principal submission regarding, my lord, the lack of reasons. Even on this, if the court were minded to grant an injunction, it should have given a reason that no, this is a company matter, because all his prayers are geared, my lord, each and every prayer is geared against the companies. I'll show that from his plaint. It's a company matter, the court should have considered it. Or at least the plaintiff should have pointed it out that it's not barred. Even on this, the reasons are lacking. Now, my lord, I have compared, my lord, the operative portion. Third point is I have compared, my lord, the operative portion in the impugned order. My lord, by the impugned order, prayers A to J verbatim have been granted. Those are 10 prayers. Prayers A to J have been granted verbatim. So it's not that the court has molded relief or considered or applied its mind saying, I'm granting this. This is how you are prejudiced.
A to
J, which your lordship will find, my lord, in the injunction application in the court below, the prayer started 119. Bodily lifted, I've compared it to, my lord, grammatical, my lord, page 119 are the prayers in the injunction application. Prayers A to J, 10 prayers bodily lifted and granted. The only prayers that have not been granted are the mandatory injunction prayers, which are another 10 prayers, which are the mirror images of the temporary injunctions. And he's graciously said, I'm not granting those, but I'm granting 10 prayers bodily. Now, my lord, so far as the documents are also concerned, 1 to 15 set out, lordship will see para 54 of the injunction application. It's set out in the same order. And what document is relied on to say there's mismanagement? The first document is an Aadhaar card. Second document is an annual return. These show fraud. He's not even applied his mind. Aadhaar card shows fraud. Now, my lord.
Next.
Fourthly, my lord, On facts, I just want to put one thing in your lordship's mind, that it is an admitted position that the plaintiff stepped down from the management voluntarily in November of 2008, 17 years ago. This is the admitted position in the plaint, that he stepped down from management in 2008, and his entire complaint, my lord, in the plaint relates to management issues.
Page, para.
Please have, my lord, his pleading of stepping down. My lord, kindly give me one moment, my lord. Yes. My lord, his pleading of stepping down is at para 3, page 37. Running page 37. That the plaintiff
Para
resigned.
3,
Para 3 at page number 37.
was this, the plaint?
Plaint. It's admitted that he stepped down. Fourthly, my lord, I'm not reading the entire plaint, but kindly take it from me. I've gone through the plaint and I'll show just 2 paragraphs. His complaint is qua shareholding, and my lord, he has peppered his plaint with mismanagement. And my lord, if your lordship takes, my lord, just by way of example, I'll just show, my lord, 2 paragraphs, not more. Please have, my lord, paragraph 39 at page number 56, running page 56. My lord, it speaks to mismanagement, which is covered under 241, 242. He uses the phrase mismanagement, and my lord, this can be bodily lifted and treated as a 241. He's just been careful to avoid, instead of tribunal, he said learned court. That is all that is done. It's an oppression and mismanagement action. My lord, lastly, my lord, there was, my lord, a submission that was made by Mr. Shah, where he said he would cite some judgments, but he has not cited any, saying that NCLT cannot go into these issues of fraud. My lord, that goes to, my lord, jurisdiction. My lord, that in my humble submission is incorrect. My lord, Supreme Court has now settled it, but my lord, in the regime of the CLB 10F, my lord, it is a misnomer. 397 is not a summary proceeding. Trials used to happen. The rules permit trial.
Permitted.
They are conflating, my lord, IBC and winding up, which are summary. But a 397 is not and was never a summary proceeding. Trial is permitted, fraud is adjudicated. Now, my lord, this question is raised. And of course, my lord, I'm not repeating anything. On delay, my lord, there's no explanation. There are no reasons in the order. My lord, those are my humble submissions.
Kindly sees page 1.
1 second. Sir, first you should tell me defendant numbers.
10. I'm defendant number 10.
You are?
Primark Projects Limited.
No. Kwe the company?
Kwe the company, I'm neither shareholder nor a director. I have a registered development agreement.
Oh, you are a stranger to the company.
Total stranger to the company.
You are the you are the developer.
I am the developer under a development agreement of the year 2023.
Under agreement dated?
The agreement date is 5th January 2023.
Page?
That is at page, development agreement is at page 268. Let me see. It is 268. 268.
All right.
Page, kindly see page. Very interesting is that one paragraph which is there in the impugned judgment. List of documents. Kindly come to page 117.
Roman 14. Roman 14, 339.
Yes, page 338. Page 338, last line. The plaintiff has shown these documents in support of prima facie case 1 to 15, and then the documents filed by the plaintiff. So has he summarized? So Mr. Shah's submission was he has considered all these documents chronologically. Kindly come to page 117 of the revision. He has bodily lifted that paragraph 54 from the injunction petition. Bodily lifted. Page 117. That same Roman 1 to Roman 15.
No, that Mr. Shonmukh Mitra has made his submission.
Yes, so his bodily lifted that injunction petition.
Don't repeat.
Yeah, I'm not repeating. Now, so far as the cause of action, so far as the third party is considered, what? See paragraphs 37 and 38.
From the
That-
plaint,
From the plaint.
page,
Page 37 is page 55. The shareholders' action is that there is no ULC certificate. He has written to, under the Right to Information Act, he made a query in 6th March 2025. It is not his averment that will appear from paragraph 29 that he has discovered this agreement suddenly today. Paragraph 29 at page 51 is first time this development agreement is mentioned in the plaint.
page.
51, paragraph 29, where there is a registered development agreement, and he has taken out a certified copy of the registered development agreement.
Yes, sir.
And now his averment is that he wrote to the RTI authority, who has confirmed that there is no ULC clearance. Is that, and I ask myself this question, is that any cause of action for a shareholder? I have the ULC certificate. I have got the original.
No, that's neither
That
here
is
nor
neither
there.
here nor
Neither
there.
here nor
But
there.
a shareholder's action, and where he has taken out the certified copy of this development agreement, it seems sometime in August 2022. Certified copy নিয়েছে? The stamp is here, 2023, 7 January 23. Certified copy নিয়েছে. Or July 23 sometime. And here has written RTI queries in the year 2000, in the month of March 2025. And ULC is the only ground, there is no case of undervalued, or it is not his case. If you see the impugned order at page,
Mr. Mitro, those are really, are they relevant at this stage?
no cause of action and no, so the reasons, there is no averment, no
You are
cause of action.
appearing for a third party to the company.
I am not involved in company's affairs.
That's right. So far as the shareholders are concerned, where the shareholders action, you are a third party, stranger.
There is no averment that
Right.
I am involved in company's
Right.
management
So you are saying there is no cause of action against your client.
at all. That's what I'm saying. On
Very
the
well.
plain does not
The
disclose.
suit may, if ultimately you succeed, the suit may be dismissed partially against you.
So the ad interim order, when there is no disclosing a cause of action.
Those are to be gone into. Those are to be gone into. I am clearly on Article 227, sir. I am on Article 220. I am exercising my power and authority under Article 227. So my primary duty is to look at the impugned order. Primary duty is to look at the impugned order. Whether there is any error of jurisdiction.
That Mr. Shonok Mitra has shown, Mr. Ratnagopal, page 338, second paragraph itself says it's a shareholder's action. Second paragraph of the impugned order says the plaintiff is a shareholder since 92, and this is a shareholder's action. The plaintiff is a shareholder since 92 of Power 2, the other related company, 1 to 5 family members of the plaintiff. I am not, thankfully, there's no averment. 6 to 9 are group companies. I am not related to the plaintiff. Defendant number 10 is separate company, and disputes. Next paragraph, the plaintiff has filed a suit as dispute arises the acts of fraud, forgery, misrepresentation, and abuse of corporate and property rights of plaintiffs. So it is as his averments has been placed, this is clearly barred by 430, as Mr. Shah rightly said, that he should have applied his mind to the suo motu to the question of jurisdiction. Order 7, Rule 11, the court will not file. So when passing an ad interim order, a court is supposed to know the law. A judge, everyone is supposed to know. And 430 bar.
That's why I said, when Mr. Junior Shah has raised an objection, that since these objections are not there before you, I mean, before the ad interim stage, Why you will consider that? So to that I said, in exercise of my power under 227, which is a superintending power, which is a wider jurisdiction, if I find that it is for whatever reason, that I will have to write, give the reason. If the order is not sustainable, can I not take it up under 227, even if the appellate forum is available?
And Lordship's query was Section 80 leave. Section 82 leave has not yet been granted. And if the order is passed, without jurisdiction goes, or if the order is not passed, you challenge that, come up in appeal revision. Till you get that leave, you cannot.
No, that Mr. Junior Shah has said. Suppose tomorrow I apply for, yesterday, let's say, yesterday I applied for leave before the NCLT.
44 leave.
Whatever. NCLT, I have forgotten the sections by this time. So the leave is refused. His remedy lies in a forum, wherever, in a statutory forum or wherever his remedy lies. So, apprehending that leave may not be granted,
If
may not be granted,
not granted, that's
right.
You will not, then you can't, the
That
rights are
situation,
closed.
that situation has not even arisen today.
And most importantly, Mr. Mitra must have shown page 141. Each of these companies have less than 10 or less shareholders. So a single shareholder, they have forgotten the fact as 1/10 in number or 10%.
10%.
So 1/10 in number, he qualifies anyway. This plaintiff completely overlooked that fact.
Yes, no, that Mr. Anirban Ray submits.
Yes.
10 shareholders, so one is 1/10.
One is 1/10. 181. Sorry, page 181. They've
Doesn't matter. Doesn't matter.
Makes no difference. End of the day, makes no difference.
No difference and doesn't matter for this today on the face of this application.
Well, so my only addition is I am a total third party.
You are a
total
third
state.
party.
So why should I be affected by that?
Let us not, my lord, miss our lunch on vacation. So, my lord, I'll be try to be brief.
No.
No.
You proceed. I will take the matters
Yes. Let me,
till I am not hungry.
no, my lord, let me answer, my lord, your lordship's query straight away. My lord, first, your lordship has made it very clear your lordship is exercising jurisdiction under 227. Now, my lord, so far as 227 is concerned, my lord, today, your lordship will, my lord, have, my lord, the jurisdiction to entertain, my lord, a 227 application, which, as my lord, Mr. Anirban Ray pointed out, my lord, there is manifest error in jurisdiction. So we are talking about a manifest jurisdictional error, which, my lord, ultimately would make, my lord, a petition maintainable under 227, even when the order is otherwise appellable. My lord, that is the distinction he made by citing a judgment. So, my lord, he says that an otherwise appellable order, my lord, can be, my lord, brought by way of a challenge by way of a revisional application when there is manifest error in jurisdiction. Now, my lord, he therefore admits that the order is appellable at the first instance. And he says that the exception to the rule is that, my lord, there is manifest error in jurisdiction. Now, my lord, first of all, as your lordship has already seen, my lord, the pleading is that yes, it is appellable. I would have preferred an appeal, but I have not preferred an appeal because the appellate forum is not available. Now, my lord, the case of manifest error of jurisdiction in that sense is not pleaded. Now, my lord, your lordship is being approached in vacation. My lord, now, my lord, the petition is filed. My lord, the case is not, my lord, that, my lord, there is manifest error of jurisdiction. It is the order is not appellable, but the forum is not available. Now, my lord, so far as that is concerned, my lord, we have shown your lordship, my lord, the district judge's circular, and, my lord, the notification saying that the filing departments are open.
I accept forum is available.
So, my lord, so therefore, my lord, let us, my lord, first accept the proposition that, my lord, it is an appellable order, appellate forum available. My learned friends have not availed of the forum, they've come up in revision. Now, my lord, the question is error of jurisdiction. My lord, two questions have been raised so far as error of jurisdiction is concerned. One is, my lord, that this is an action for oppression mismanagement and hence the court inherently lacked jurisdiction because of section 430. And the second is, my lord, the order is a non-speaking order. Now, my lord, if I can satisfy your lordship on these two grounds, my lord, then, my lord, your
First, you satisfy me on the non-speaking order.
Yes, now, my lord, so far as non-speaking order is concerned, my lord, the law is quite clear that, my lord, number one, of course, my lord, I shall come to that part later. First part is, my lord, even if an order is not a speaking order, which, my lord, I do not, my lord, readily accept. Even if it is, my lord, not a speaking order, my lord, that makes it appealable, not revisable. My lord, there is ample authority to that effect. I can cite judgments right now.
my lord, that would not make it revisable because, my lord, that is not an inherent lack of jurisdiction. It is, my lord, an error on the part of the learned judge while exercising jurisdiction that he had, my lord, by, my lord, passing an order, my lord, without giving sufficient or ample reasons. My lord, so far as this is concerned, my lord, I would like to, my lord, cite before your lordship, my lord, the judgment of our High Court. My lord, this is reported in All India Reporter 1987, Calcutta, page 60. My lord,
Yeah, Mr. Shah. Yeah.
19, my lord, 87, Calcutta, page 60.
Paragraph
My lord, paragraph 16.
1/6.
My lord, 1/6. Well, please see paragraph 16. The ratio of the aforesaid decisions has clearly established the principal law that where the remedy by way of appeal, though available against the order, is illusory because of the absence of relevant material and record, the inherent power of the court under section 151 can be invoked for getting the remedy against such order, but the same have not postulated that where such appellable order is not speaking order with reasons therein, on the basis of the materials available in the record, the remedy against such non-speaking order can be obtained by invoking the inherent power of the court under 151 without taking steps of getting the remedy by way of appeal specifically provided. Well, what it says.
Paragraph 4 shows it is inherently inherited.
Yes.
Paragraph 4.
Yes,
It shows it is inherently inherited.
No, no.
Paragraph 4.
No.
Paragraph 4.
Yes, yeah.
Inherently inherited.
But, my lord, we are the beneficiaries of that inheritance.
Always. Why not?
My lord, all that I am trying to say.
Little here and there. Otherwise,
Yes.
little digression is permitted.
Saying that no reasons were there.
No, I was saying little digression
That's
is
right.
permitted.
But the judge says, the learned judge says, there is no gainsaying that no reasons were. He accepts that there were no reasons. But notwithstanding that act, my lord, the court holds that would make it appellable. Not, my lord.
Paragraph 16.
Yes. 16 and 17. I've placed 16 before your lordship. Please now, my lord, look at paragraph 17. In the instant case, there is no dispute to the fact that the plaintiff filed the objection to the petitioner's application under such and such. Then, my lord, next sentence, the matter like this is generally decided on the basis of the petition and objection supported by affidavit with annexures. It appears from the order date such and such already quoted that because of the absence of the plaintiff of the call time such and such. Then, my lord, next sentence. There is no gainsaying of the fact that the said ex parte order dated 14th August 84 was not a speaking order coupled with reasons. In view of the existence of the materials in record, the remedy by way of appeal against the ex parte order dated 14th August 84 should not have been illusory. The appellate court, after considering the materials in record, could have sent back the case on remand for fresh decision, etc. Then, my lord, last sentence. So, in the case of this nature, the inherent power of the court under section 151.
Which motion, Mr. Shah? Which motion?
Paragraph 17, my lord, last sentence.
So,
in a case of this nature, the inherent power of the court under section 151 CPC cannot be invoked, where the remedy of by way of appeal, my lord, is by way of appeal being not illusory, was available. So, my lord, here, my lord, therefore, my lord, with the greatest respect, even if we accept that, my lord, the order is not a speaking order, or, my lord, is not sufficiently reasoned, my lord, the remedy is by way of appeal. And, my lord, if the remedy of appeal was available and has, my lord, ultimately not been, my lord, availed, in that case, my lord, 227 will not lie. So, therefore, my lord, if your lordship is, my lord, looking to exercise jurisdiction under 227 on the ground of, my lord, inherent lack of jurisdiction, my lord, this is not, my lord, something that, my lord, ultimately answers the question of inherent lack. It is an error within jurisdiction. So, my lord, if we accept, my lord, that the order is, my lord, not reasoned or not sufficiently reasoned, my lord, it is not something, my lord, that is, my lord, inherently, my lord, lacking in jurisdiction, which would ultimately, my lord, allow my learned friends to approach this court under Article 227. My lord, the second question of lack of jurisdiction. My lord, the question of, my lord, the reliefs. Now, my lord, here, well, let us understand one thing very clear. My lord, rightly or wrongly, there is challenge to, my lord, the transmission or transfer of shares. My lord, the shares, my lord, the bulk of shares which is in issue here, my lord, is something that, my lord, ultimately answers to the controlling interest of the company. My lord, whoever, my lord, ultimately can claim, my lord, right to those shares has a right to, my lord, ultimately decide, my lord, on behalf of the company through our board appointed, my lord, through his good offices. Now, my lord, so far as the allegation is concerned, the allegation with regard to, my lord, the manner in which the shares have passed from the father to, my lord, one of the sons is, my lord, ultimately something that has been canvassed as a case of fraud. My lord, ultimately, my lord, so far as this, my lord, is concerned, my lord, the law as very clearly settled is, my lord, for these purposes, immediately, even for an ex parte, my lord, or administrative injunction, even for the purpose of, my lord, seeking rejection of the plaint on the ground that, my lord, the court lacks jurisdiction, or, my lord, suit is barred by law, or does not disclose the cause of action, averments in the plaint have to be taken to be correct. Now, my lord, if that be the situation, my lord, if these averments are, my lord, to be taken to be correct, prima facie, at, my lord, at least at the ex parte, my lord, ad interim stage, because, my lord, thereafter, my learned friends have a right to file an affidavit. The question is, my lord, here, on a reading of the plaint, on an appraisal of the presence of the plaint, my lord, does it answer, my lord, only to a question of operation mismanagement, or goes beyond that? Now, my lord, if there is a question of, my lord, fraud having been perpetrated in the matter of, my lord, the transfer of shares of the father to the son, my lord, I ask myself this question, my lord, and your lordship's experience also, my lord, will answer it for me. My lord, whether, my lord, the question of whether there has been a fraud in, my lord, the father's shares being, my lord, being taken over by one of the sons, my lord, is a question of, my lord, operation mismanagement. It's not. My lord, that is a matter of, my lord, civil adjudication. Now, my lord, so far as that is concerned, my lord, we have, my lord, canvassed this case very clearly and fairly, my lord, in the court. And, my lord, here, if your lordship now sees, my lord, the prayers in the plaint once. Please see the prayers in the plaint and understand, my lord, today, even if there is a crossover, my lord, we have often used the expression, my lord, a rolled up action. My lord, let us, my lord, also say, my lord, a suit for suit, which is, my lord, contains one of the prayers which makes it a suit for land. Well, ultimately, the court can always entertain the suit, but, my lord, not ultimately look at the relief for suit for land.
Reliefs cannot be dissected.
Reliefs, my lord, can be dissected.
Relief can be dissected. Relief also cannot be dissected in certain situations.
That's right. Now, my lord,
There can be partial rejection.
that's right.
Yes.
Partial rejection of plaint.
Permitted.
Now, my lord, please have a look at the prayers in the plaint. Your lordship will find the prayers, my lord, at page 67.
Yes.
Well, let us look at some of the prayers. Well, prayer C at page 67. Well, please see prayer C. A decree for declaration that the defendant numbers 1 to 5 are not the rightful owners of their equity shares in the defendant number 6 to 9. Well, question of ownership tied to, my lord, the allegation of perpetration of fraud. D. A decree for declaration that the alleged transmission of shares in the name of the defendant number 1 through Pannalal Chaudhary is void and not binding upon the plaintiff or other shareholders of the defendant number 6 to 9. Again, my lord, something that is founded on fraud. Ownership. Then, my lord, H. American H. Then please see H.
Place construction.
A decree for declaration that the defendants have no right to raise a construction over the property mentioned in Schedule A. L.
This is the main thing.
A decree for cancellation of a registered development agreement dated such and such with an outsider company.
Page, para. I mean, sorry, prayer.
Prayer. No, prayer I na L.
I'm sorry.
L. Decree for declaration of a registered development. Decree for cancellation of registered development agreement dated such and such with an outsider company, Primark Projects Private Limited. Different number 10 herein, recorded in such and such.
Can the NCLT pass?
Now, my lord, the question is, my lord, here, my lord, may I just ask myself these questions? My lord, whether, my lord, these are, my lord, prayers, my lord, which can be granted by the NCLT. Now, my lord, so far as this is concerned, let me, my lord, without, my lord, encountering, my lord, the submissions from, my lord, my left-hand side, my lord, show your lordship the law on the subject. My lord, Justice Dipankar Datta's judgment, my lord, does not, my lord, speak of anything, my lord, of, my lord, the manner in which, my lord, it has been present. My lord, may I show your lordship one or two of the judgments, my lord, how the law has been settled? Your lordship remembers.
But Mr. Shaha, Are they really relevant at this stage?
No, no, my lord, you're only relevant for this purpose. I'm very grateful. Only to answer the question as to whether there's inherent lack of jurisdiction. Now, my lord, I am answering this because, my
If
lord,
this point, inherent lack of jurisdiction, appears to be coupled with facts, mixed question of law and facts.
my lord, lack of jurisdiction is ultimately, my lord, today, if it has to be a mixed question of law and fact, it can never be, my lord, inherent lack of jurisdiction.
Absolutely. So I am saying on this jurisdictional issue, I am not adjudicating today.
In that case, my lord, your lordship will ignore, my lord, the submission that it is only the NCLT and the NCLT alone which could have exercised.
I will record their submissions. I will record your submissions as well. That's why I'm taking the press from the plane.
Yes.
Note.
My lord,
Then I will make my finding.
no, my lord, I am only question, my lord. I am answering your lordship's, my lord, question of jurisdiction. My lord, your lordship has to, my lord. First question was, my lord, whether, my lord, there is inherent lack of jurisdiction, my lord, when there is a
See,
non-speaking order.
Your submission is, sir, that if it is, unless it is inherent lack of jurisdiction, no 227.
Yes.
Avoiding the appellate authority. That's your submission, sir.
And, my lord, so far as that is concerned, that is premised on twofold arguments. Argument number one, non-speaking order. Argument number two, ousted of jurisdiction under section 430.
So that's why I said first you argue on non-speaking order.
That is, my lord, my argument. My lord, so far as the non-speaking order is concerned, my lord, 2 or 3 other, my lord, things. I will just, my lord, conclude this submission. My lord, so far as that is concerned, my lord, the statements in the plaint are, my lord, to be accepted as true and correct.
Absolutely.
Now, my lord, the court has proceeded to accept, my lord, the statements in the plaint as true and correct because, my lord, my learned friends have said bodily lifted from the plaint, from the petition, etc., etc. So, my lord, if they are to be, my lord, true and correct, in that case, my lord, today, can it be said that, my lord, by looking at the plaint and accepting the averments of the plaint to be true and correct for the purpose of passing an ad interim ex parte ad interim order, my lord, there's an error in exercise of jurisdiction which goes to, my lord, the root of the matter. But again, my lord, I'm coming back to the question of your lordship's, my lord, jurisdiction under 227, because that is what has been invoked. So, my lord, here, if it is, my lord, the law is, my lord, very well settled on the subject. I don't need to cite judgments on that, my lord, the averments in the plaint have to be taken to be correct.
Absolutely. Sacrosanct.
So, my lord, so far as that is concerned. Now, my lord, so far as this is concerned, my lord, the third limb of the argument is, my lord, why appellable and why not revisable? Because, my lord, it is very well settled now that, my lord, even if there is absence of reasons, instead of setting aside the order and remanding the matter back, the appellant court can always supplant the reasons.
Absolutely.
So, my lord, here, my lord, the question is, my lord, today, why appellable? Non-speaking order. Let me proceed on the premise that it's a non-speaking order. Although, my lord, with the greatest of respect, I'll submit that, my lord, today, my lord, the courts have held, both, my lord, in the sphere of arbitration and in the sphere of civil, my lord, law, that, my lord, what is, my lord, sufficient reasons is something that, my lord, is, my lord, a matter of some, my lord, conjecture.
And sufficiency may differ. It may be sufficient for you, it may not be sufficient.
Absolutely. Now, my lord, so far as that is
Accepted.
concerned, that is why, my lord, the law is, my lord,
Reason must be there.
again, it says that today, even if the court finds, the appellate court finds that, my lord, it is lacking in reasons,
It can
supplant the reason.
Absolutely. No
So, my
doubt.
lord, today, 3 arguments in this regard. My lord, that is also, my lord, these are also for the, my lord, fact that averments in the plaint are true and correct. I rely on 19, AIR 19.
Not required, sir. I accept.
And, my lord,
I will accept.
also, my lord, the court has the power to supplant reasons, my lord, that is.
I accept.
So, my lord, my arguments are threefold. Number one, my lord, so far as non-speaking order is concerned, it is appellable, it is not revisable. Number two, it is appellable because, my lord, the appellate court has the right to supplant the reasons. Number three,
Don't take me amiss. Your juniors all are there. They provoke me to smile. Please don't take me.
agent provocateur is to the extreme right.
Both are classmates to whom you will leave. Yes.
Third one was there, my lord.
Answer. Yes. Sorry.
No, my lord. So, my lord, threefold arguments. Number one, my lord, it is not, my lord, something that is revisable, lack of reasons. It is appellable. Number two, appellable because the appellate court can supplant the reasons. And number three, my lord, the court, my lord, did not err, my lord, by looking at the plaint because the averments in the plaint have to be taken to be true and correct. My lord, this is one limb of, my lord, the argument with regard to, my lord, your lordships, my lord, the 227 jurisdiction having been invoked. My lord, the second limb is with regard to, my lord, the bar of jurisdiction. My lord, this is what my learned friend says is inherent lack. Now, my lord, I have shown your lordship that, my lord, the allegation is, my lord, fraud in the matter of, my lord, ultimately, my lord, taking over the father's shares. I have shown your lordship, my lord, that there are prayers, my lord, which are prayers, my lord, in this regard, which says that you can't represent yourself to be the owner of these shares because, my lord, these are the product of fraud. The question is, my lord, whether these are questions that can be adjudicated by the NCLT, by the civil court, by both. My lord, so far as that is concerned, my lord, here, my lord, the law, your lordship might remember the case of ammonia supplies. Ammonia supplies had said that, my lord, the NCLT or the company law board cannot, my lord, go into complicated questions of fraud or, my lord, complicated disputes of facts. My lord, that was to an extent watered down later. But the law, my lord, came a full circle again. My lord, so far as this is concerned, may I show your lordship, my lord, 3 or 4 judgments? I shall be very, very brief. My lord, the first judgment is, my lord, Aruna Oswal. My lord, this is, my lord, reported in 2020, volume 8, Supreme Court cases, page 79.
NCLT cannot look into fraud. That's right?
Yes, my lord.
NCLT cannot look into
Yes,
fraud.
my lord. Please, my lord, see.
One second.
My lord, please, my lord, see the head note first.
Yes, sir. One.
My lord, please see the head note of the judgment. Oppression and mismanagement, jurisdiction of NCLT in respect of health does not extend to determination of disputes as to succession or ownership of shares. Proper forum for which is civil court.
Paragraph, sir.
Paragraph 25. Now,
Yes.
please have a look at paragraph 25.
All right. Then next case.
My lord, the next judgment is, my lord, please have a look at. Now, my lord, a judgment of our High Court. Or, my lord, let us, my lord, look at, yes, my lord, our High Court, my lord, Division Bench of our High Court 2024 SCC Online, Calcutta, 11480.
One.
My lord, please see paragraph 38 onwards, the Division Bench of our High Court.
Para.
38 onwards. My lord, discusses ammonia supplies, discusses Sangram Singh Gaikwad, discusses Darka Prasad Agarwal. My lord, may I quickly read it? We find from the relief sought in the plaint that the argument as to the NCLT having jurisdiction applies only to certain consequential reliefs sought in the suit in respect of alleged mismanagement of the funds of the defendant companies. Even if the said reliefs are held to be barred at the final hearing of the suit, the primary relief of declaration and partition cannot be held to fall within the domain of NCLT's jurisdiction. As held in Ammonia Supplies Corporation Limited, when Sangram Singh Gaikwad disputed questions which are pure questions of title cannot be adjudicated under the Companies Act. As held in Darka Prasad Agarwal, the jurisdiction of civil court is not completely ousted. The plinth of the plaint case is inheritance of shareholding and assets of the defendant company by the plaintiffs. What has been claimed in the suit is a declaration that the title and assets which are the subject matter of the suit vis-a-vis the companies involved on the strength of shareholding and cross shareholdings, which prima facie indicate that it is joint family comprised of the successor of late such and such, who have pervasive control, etc. Thus, going by the averments made in the plaint, the companies are joint family companies, etc. Then, my lord, the plinth of the plaint case is the entire assets of the defendants, be them juristic corporate entities or biological persons, emanate from the joint family, family nucleus of the family patriarch Sukhdev Prasad. Therefore, the plaint goes on to plead that such joint family of the family companies, which all started with sole proprietorship, was such and such. Then, my lord,
It comes to 48 onwards.
48.
47, it
40
considers ammonia, then 48.
My lord, 47, my lord, your lordship will see again, it considers ammonia supplies and Shashi Prasad Khemka.
Cited by
It is to be noted that the decisions in Ammonia Supplies Corporation and Shashi Prasad Khemka highlight the fact that the NCLT has jurisdiction only in cases covered by the Companies Act. In the said judgment, the Supreme Court also noted the section 430 of the Act bars the
Paragraph 50, sir.
Yes, and 50. The argument of the plaintiff that since the latest amendments in Benami such and such, etc. My lord, here, my lord, clearly says that, my lord, therefore, my lord, here the appeal succeeded. And my lord,
Ultimately, Order 7, Rule 11 was rejected.
yes, because my lord, ultimately it was held that there was no inherent lack of jurisdiction. Then my lord, there was another judgment of our High Court, a single judge. My lord, this is in the case of Mukesh Jaiswal. My lord, this I will not cite before your lordship the single judge, but there's a division bench on this. My lord, this is my lord 2023 SCC online Calcutta page 1812.
Online Calcutta.
1812.
No, let's
My lord, please see paragraphs 37 to 40.
paragraph.
37 to 40.
Yes.
The principal question arising in this appeal is with regard to the jurisdiction of the civil court to decide the dispute between the parties. In other words, whether the civil court has jurisdiction to adjudicate the dispute. It is essentially a jurisdictional issue which is required to be decided on the basis of Section 9 of the Code of Civil Procedure and 430 of the Companies Act. Then 430 is extracted. We have briefly narrated the facts stated in the plaint. It is clear from the averments made in the plaint that it is not a proceeding for refusal of registration or rectification of register under sections 58 or 59 of the 2013 Act. Section 58 contemplates a situation where a private company limited by share refuses, whether in pursuance of any power of the company under its article or otherwise, to register the transfer or the transmission by operation of law or the right to any security or interest within a period of 30 days from the date on which the instrument of transfer or the intimation of such transmission was delivered to the company. If there is refusal, the transferee may appeal to the tribunal under 58(5). In Adesh Kaur versus HM Motors, the jurisdiction of the tribunal in proceeding under 59 was not interfered with, as the Honorable Supreme Court observed that it was an open and shut case of fraud in which the appellant has been victim. My lord, open and shut case of fraud, my lord. Then my lord, please come to paragraph 40. As a corollary, it appears that the disputed questions of the facts are complicated and cannot be conveniently decided in a summary procedure. The jurisdiction of civil court is not ousted. Although it cannot be disputed that the National Company Law Tribunal may have jurisdiction to decide the title of any person who is a party to the application, urging that his name has been wrongly omitted from the register or should have been entered in the register in a proceeding under 59 of the present Act, read with Section 111 of the Companies Act of 56. However, the issue in the suit is not one of rectification. As observed in ammonia supplies and quoted with approval in IFB Agro in paragraph 22, the very word rectification connotes something what ought to have been done but by error not done, or what ought not to have been done was done, requiring correction. Rectification, in other words, is a failure on the part of the company such and such. Then, my lord, it is quoted from IFB Agro. And then, my lord, your lordship will see, my lord, just before paragraph 41, the decision in ammonia was followed by this court even after the deletion of section 155 and insertion of 111A. The court in Standard Chartered Bank versus Andhra Bank Financial Services Limited and Jai Mahal Hotels versus Rajkumar Devraj held that even though section 111(7) of the 56 Act seemingly enlarges the power of the company law board, the power of rectification continues to remain summary in nature, and if any seriously disputed questions arise, the company court should relegate the parties to a forum which is more appropriate for investigation and adjudication of such disputed questions. Now, my lord, so far as this is concerned, then, my lord, Supreme Court also speaks on the subject. My lord, this is IFB Agro. My lord, this is reported in 2023, volume 4, IFB Agro. এটা জয় দিল সকালে। Please have a look at paragraph 22. Hello, paragraph 23. 22 and 23. My lord, first, your lordship will find in paragraph 22 the entire, my lord, relevant portion of ammonia supplies is reproduced. And then, my lord, the Supreme Court goes on to say in paragraph 23, it is evident It is evident from the above that while interpreting section 155, this court has held that the power of CLB is narrow and can only consider questions of rectification. If a petition seeks an adjudication under the garb of rectification, then CLB would not have jurisdiction and it would be duty-bound to redirect the parties to approach the relevant forum. The court has also held that the word sufficient cause cannot be interpreted in a manner which would enlarge the scope of the provision. And, my lord, then a decision in ammonia is followed, my lord, by the other judgments. That is also related. So, my lord, here, very respectfully, my lord, the question is, my lord, is therefore there an inherent lack of jurisdiction here, which would ultimately allow my learned friends to come up and, my lord, agitate these questions in an application under, my lord, 227. My lord, the next question is also, my lord, the question is, my lord, where does a person go? If the NCLT does not have jurisdiction to decide these questions, my lord, we are not talking about 10, my lord, members of the company. We are not talking about less than 10% shareholding. My lord, that may or may not have been an issue. But in spite of that, my lord, irrespective of that, if, my lord, the NCLT cannot, my lord, decide these questions or cannot conveniently decide this question, then the
No,
courts have held.
that is the submission of the plaintiff or the case of the plaintiff on argument. But at the ad interim stage, then also, was it not the duty of the learned judge to come to a finding that yes, prima facie I am satisfied, civil court is the forum because of these reasons?
Your lordship is now, my lord, going back, my lord, to the question of reasons. My lord, with the greatest of respect, my lord, the question is, my lord, if today the learned judge, my lord, with the pardon the expression, does not write, my lord, as he ought to, my lord, can the litigant be penalized? And, my lord, that is why, my lord, here the question is, my lord, in an appeal, the appellate court can supplant the reasons. My lord, your lordship would, my lord, if your lordship, my lord, would entertain the application under 227, first be satisfied there's inherent lack of jurisdiction. And second, my lord, even if then, my lord, your lordship would have to don the mantle of the appellate court and supplant the reasons. Then, my lord, your lordship will go into the merits of the matter, which your lordship is at the very early stages of the hearing indicated, your lordship will not do at the vacation. My lord, third most important question. My lord, when approaching your lordship in vacation, my learned friends will have to make out a case of extraordinary urgency. Now, my lord, today, my lord, your lordship has seen, my lord, the order. My lord, let us, my lord, not go into the aspect of reasons of the order. Your lordship has seen what has the order directed? Don't take any financial decisions. Don't deal with the 15 crores of rupees that you have received under the development agreement. Don't alienate the property of the company. Don't construct on the property. Well, are these matters, my lord, which warrant, my lord, an approach to a high court, my lord, during vacation? Well, the question is, what is the extraordinary urgency that, my lord, attaches to such a situation?
দাদা ডেট গুলো বলে দাও 25th এসি অর
এই আমাকে একটা কনস্টিটিউশন দেবেন তো, একটা কনস্টিটিউশনের ছোট বই দাও, দেখো এখানে কোথাও আছে।
Now, my lord, 25th is the impugned order. My lord, the order, my lord, is till the 30th of October, till the 31st of October. My learned friends would have to then, my lord, make out a case of urgency. My lord, let us see what is their pleading of urgency. My lord, please have a look at the petition now. Please have a look at, my lord, paragraph 36.
Paragraph
36.
26. Yes.
My lord, please see paragraph 35 first. Learned court below failed to appreciate that the plaintiff opposite party number 1 has chosen to move the learned court right prior to the puja vacations. Then, my lord, 36. The impugned order is such that if it were permitted to be continued even for a day, the petitioners will have immense difficulty to take a constructive decision in the board, and therefore the interference with the impugned order is warranted. That is the only one single paragraph, my lord, of urgency. Now, my lord, if your lordships, my lord, have made it expressly clear.
Yes.
That, my lord, your lordship's jurisdiction during vacation is to be invoked, my lord, only in case of express urgency. I look at two things. A, they are pleading. they must plead extreme urgency because, my lord, they must say that otherwise the consequences they will suffer is something that will be irremediable. The only pleading is paragraph 36 and it says nothing. So, my lord, my learned friends come, my lord, to court with petitions under Article 227 without any pleading of urgency whatsoever. And, my lord, they expect interference, my lord, in the revisional jurisdiction. Secondly, well, if your lordship now looks back at the impugned order once, my lord, which portion of the impugned order, my lord, cannot wait, my lord, till 31st, and my lord, which portion will, my lord, cause irreparable, my lord, damage if it is not interfered with right at this moment? Please come back to the impugned order, the operative portion. Well, please see, where it says that principal defendants, including the men and agents, are hereby restrained from taking financial decisions and misappropriate funds. I don't know, my lord. Financial decisions, my lord, will not stop the day-to-day operation of the, my lord, company. There is no, my lord, injunction restraining operation of the bank accounts. Then, my lord, the defender numbers 1 to 9 and the men and agents are restrained from using, utilizing, spending advance amount of par consideration of 15 crores mentioned in the development agreement. My lord, today 15 crores is not utilized till the 31st, my lord. Is there any, my lord, heaven will fall on earth? And is that their case? That's not the pleaded case. Then, defendants 1 to 10 and their men are restrained from raising any construction of the property, Schedule A property. No urgency. Restrained from transferring, selling, or assigning, alienating, creating third-party interest in respect of movable, immovable properties of the company. No urgency. Then, my lord, restrained from using funds of 6 to 9 companies and to mismanage, misappropriate funds. Restrained from holding AGM, EGM, or board meetings in the absence of the plaintiff. Well, I have not, my lord, found anything which would warrant immediate interference because of, my lord, extreme urgency. My lord, your lordship's, my lord, court has also not been approached in vacations, my lord, at the earliest instance.
Thought there was a date, ninth there was a date.
My lord, whatever, my lord, ultimately, my lord, first of all, urgency will have to be pleaded. Secondly, urgency will have to be manifest from the face of the order to show, to, my lord, find that this is, my lord, something that, my lord, there are at least, my lord, 5 dates on which they could have approached, my lord, the district judge's court also. My lord, not done. But, my lord, my answer is, my lord, question, my lord, here is very simple. My lord, is there any pleading of urgency? No. My lord, is there anything in the order which, my lord, suggests that if not immediately, my lord, interfered with, my lord, there will be, my lord, such irremediable prejudice or injury cause, my lord, which, my lord, cannot be later, my lord, rectified? So, my lord, here on the question of, my lord, threefold question, my lord, which I have urged before your lordship. My lord, no inherent lack of jurisdiction because of absence of reasons, even if one, my lord, proceeds to accept these reasons. I would, my lord, still venture to say with respect that, my lord, there may not be sufficient reasons, but it is not absolute lack of reasons. My lord, in any event, my lord, today, even if lack of reasons is there, my lord, that can be supplanted by the appellant court. And, my lord, the reasons which have flowed are, my lord, from the plaint because the averments in the plaint are true and correct. Secondly, my lord, so far as the jurisdiction of the NCLT is concerned, my lord, so far as the prayers are concerned, at least some of the prayers cannot be granted by the NCLT. The pith and substance of the dispute cannot be considered by the NCLT. So, my lord, irrespective of 4.5% shares, or, my lord, section 244, or, my lord, the possibility of approaching the NCLT for, my lord, seeking leave, or, my lord, the other remedies that are available, my lord, 1 out of 10 members, etc. Well, if the NCLT cannot decide these questions, then the civil court has to decide the questions. So, my lord, and again, no question of inherent lack of jurisdiction or, my lord, section 430, my lord, coming to, my lord, say that you had inherently lacked jurisdiction. Now, the question from your lordship, could the court have not observed this? Yes. But if the court did not, that, my lord, does not ultimately, but again, it shows lack of reasons, does not, my lord, hit at inherent lack of jurisdiction. And the third question is,
আমি ডেকে নেবো পরে।
It's a wrong order.
Yeah.
That doesn't mean that.
Take it. My lord, and the third question is, my lord, today, to approach your lordship, my lord, a case of urgency will have to be made out. There's no pleading of urgency. There's no manifestation of the need to exercise an emergent and urgent jurisdiction on the face of, my lord, the reliefs granted in the order. আর কিছু বলবি?
লম্বা order বলছি। Not have cancelled that.
হ্যাঁ, ওইটা তো বলছি। These are not fair. Well, these are my submissions, my lord.
Anybody else?
My lord, if they finish, my lord, one word reply only, my lord, if your lordship permits me, my lord. Oh, Mr. Banerjee is online, my lord, if your lordship would kindly permit.
Just one submission, if Mr. Ray wants to add. Just one line. But still, there is no answer to the point which we raised, that whether the order has justified as to why an ex-party ad interim order was passed. If there are no reasons with regard to that, in terms of the Honorable Supreme Court judgments, is aware the Victoria Memorial judgment also, it's a nullity.
It was a one-line order.
It's a nullity. If it's a nullity, it has to go because it's a very drastic order. And that's my first submission. Secondly, so far as Mr. Shah, you made your submission, Mr. Charji was also, just give me. And secondly, I submit the question of the company court having jurisdiction, the bar being under section 430, also goes into the question of whether an ex-party ad interim order would be passed or not. It is a consideration which has to be taken into, it's a factor which has to be taken into consideration for the purpose of granting any order. I totally what has fallen from court, whether it's now barred under section 430 or not, we'll take those steps. But the question is, if I put my argument in a question form, whether they have made out a sufficient case in their plaint and the petition to justify an ex-party ad interim order in the nature which it has been passed.
That's on merits. I have not addressed your lordship.
No. We are on the question, the order itself. The order is impugned. We are under Article 2 to 7.
Okay.
I'm grateful, That's my submission,
Yes, Mr. Rai.
Only two words, my lord. My lord, the test, my lord, we have been saying a lot of things. Reasons yes, reasons no. There may be reasons, there is a out of reasons, something. The test has been long laid down from 2010 Supreme Court, which says, my lord, it is such reason that can be appropriately considered by your lordship's court. Now, whether looking into that judgment, if your lordship can make out that how this has been concluded, then it's a reasoned judgment. That is what has been stated.
All right.
My lord, Victoria Memorial, and my lord also, my lord, this is very recently quoted by Justice Padriwala in CCT versus Shukla and Brothers, my lord. Yes. Definitely, why not? You have not given us copies of judgment, so might as well we'll do something else. We stand to learn. You have not given me.
Which paragraph?
My lord, the paragraph is quoted, my lord. My lord, will kindly see. First, my lord, para 3. We are of the opinion, in absence of any reasoning in the impugned judgment, the same cannot be sustained. In this regard, we are benefited by the following observation.
Which paragraph?
At page para 3, my lord.
We are of the opinion.
Yes. Now, my lord, it quotes CCT versus Shukla, my lord, reported in 2010. I'm on that, my lord. Kindly takes the next page, para 27. At the very bottom, my lord, a reasoned judgment is primarily written to clarify own thoughts, communicate the reasons for the decision to the concerned, and to provide and ensure.
Where?
My lord, just para 27, the quotation.
Which portion?
The last sentence but one.
A reasoned judgment.
A reasoned judgment. So I am trying to say what is the reasoned judgment and how it should be dealt with. If your lordship thinks that your lordship has understood the reasons, then my lord, that is my submission.
Yes.
Grateful, my lord.
Yes, I understand.
সেইখানে গিয়ে ওইটা বলতে পারতো এটাও রিভিশনে এসছে
Reason মানে কি হলো তো বলুন।
Again, my lord,
I think, my lord, we have made our submission. First.
it is inherently, my lord, lacking in jurisdiction. Error within jurisdiction and error of jurisdiction.
এখন লিখবে
My lord, may I have your lordship's leave?
Yes.
আমাদের arbitration আছে।
This is an application under Article 227 of the Constitution of India. Whereunder an ex parte ad interim order dated September 25, 2025 has been assailed, passed by the learned civil judge, senior division, comma, first court, comma, Alipur, comma, South 24 Parganas. Bracket A for short, the civil court.
এখন তো কেউ নেই ঘরে।
Paragraph. The plaint filed before the civil court is available at page plaint.
Page 31.
Page 31. আচ্ছা এটা আপনাকে দিয়েছিলাম তো দুটো ম্যাটার একসঙ্গে হচ্ছে। At page 31 to the instant application, being annexure B thereto. The reliefs are available at pages 67 to the end, till the end. Referring to the plaint case made out by the plaintiff, Mr. Ratnanko Banerjee, learned senior advocate, and Mr. Anirban, with Mr. Anirban Ray, learned senior advocate, appearing for the
Opposite party is 1 to 5, Malad.
opposite party number 1 to 5,
6 to 9. Sorry, 6 to 9, Malad.
6 to 9,
And the petitioner here, Malad. Companies.
no.
Defendant 6 to 9. Defendant 6 to 9.
Malad, I am the petitioner, defendant 6 to 9.
That's right. কি বললাম? Mr. Anirban Ray, appearing for the petitioners. In CO 3756 of 2025, bracket A, first application, first revisional application. And defendant number 6 to 9 in the civil suit submit that on a plain reading of the averments of the plaint, it appears that a shareholder's action has been converted into a civil suit, despite there being specific statutory provisions under sections, Companies Act. Come on, Mr. Anirban Ray, under section
244. 244 and read with section 430 of the Companies Act, Malad.
244, read with section 430 of the Companies Act 2013,
কি বললেন?
bracket A, for short.
Approached. Is that what Malad, your lordship is stating? I could
কি
not.
বলেছি পড়ুন, please be mindful,
Malad.
please be mindful.
Because
Yes, পড়ুন জোরে।
On date, in meeting of the governments of the plaint, it appears that shareholder action has been converted
that a shareholder action has been converted into a civil suit,
despite there being specific statutory provisions
statutory provisions and remedies
and under section
available
Under section 241,
Section
available under section 241
241,
242, 244.
available under sections 241, 242
comma
and
244,
244. 244, my lord.
244 of the Companies Act 2013, bracket A for short, the Companies Act. Section 430 of the Companies Act provides for an exclusive jurisdiction before the jurisdictional NCLT. And the said provision also bars filing of a civil suit and passing of an order of injunction in such an action. Full stop. Learned Senior Counsel, in the light of the above, submits that the civil suit filed before the civil court being barred by law, the ad interim ex parte injunction order should not have been passed, and as such, the same is not only illegal and wrongful, but also without jurisdiction. Paragraph. Learned Senior Counsel for the petitioner submits that Learned Senior Counsel, Mr. Banerjee, for the petitioner submits that since it was an ad interim ex parte injunction order and the same was moved behind the back of the petitioner, the petitioner could not have the opportunity to urge the jurisdictional issue before the civil court with regard to the maintainability of the civil suit. Full stop. Paragraph. In paragraph, no stronger. In support. No. All right. Full stop. The second plea, paragraph, the second plea taken by the petitioner referring to the ad interim ex parte, impugned ad interim ex parte order, that the same is a grossly non-speaking order and no reason has been ascribed thereto as to why the civil court has drastically passed such an interim or ad interim ex parte order which will be evident, the nature of which is evident from the said impugned order. As no reason has been ascribed, the order impugned is in nullity and without jurisdiction. First. Mr. Banerjee then, paragraph, submits that since the appellate forum before the civil court is not available during the vacation, and since there is a cross jurisdictional error on the face of the order impugned, comma, the petitioners have applied before this court under Article 226, invoking Article 226 of the Constitution of India. 227, so sorry, 227 of the Constitution of India. Full stop. If the impugned order is a nullity and without jurisdiction and suffers from gross irregularity and infirmity, which is apparent on the face of it, straightway an application under Article 227 is maintainable. These are your submissions?
Yes, ma'am.
Yes, my lord.
These are, Mr. Ray, these are your submissions?
Yes, yes. And those cases, my lord, which Mr. Ray also relied on to show, if required, my lord, the cases which Mr. Ray,
Cases?
One of the cases of
my lord, with regard to my lord, exercise of jurisdiction under Article 227.
In support,
my lord, I have given, my lord, Atin Arora, my lord.
one second. In support, Learned Counsel, paragraph 4, in support, Learned Counsel for the petitioner has relied upon the following decisions.
Yes, ma'am. 2020 SCC Online Calcutta 2656.
2020, no.
Shailaja. Okay. না আরেকটা ছিল শাশি প্রকাশ
2020 পাচ্ছি না তো
আরেকটা দিতে মানে আতিন আরোরা মানে আরেকটা দাও না আরেকটা দাও
এক সেকেন্ড 2019 2021 2025
no my lord. My lord, we have given 2025, which is the Supreme Court judgment, my lord.
that is on
Then, my
fraud.
lord, we have given,
That is on fraud.
yes, we had also given, my lord, 2019 18 SCC
2019, yes, 18 SCC,
Shashi Prakash Khemka
yes, it is in favor of this contention.
430, my lord.
In
430.
এটা লিখে দাও, Mr. Learned Counsel for the petitioner has relied upon the following decisions, colon, আস্তে আস্তে লেখো, কোনো চাপ নেই, A B C করে, ফার্স্ট A তে এইটা করে দাও, এই শশী ভার্সেস কি আছে, রিপোর্টেড অ্যাক্ট, রিপোর্টেড অ্যাক্ট করে দিয়েছো, দাও। নেক্সট মিস্টার রে,
My lord, we have shown, my lord, Atin Arora,
হ্যাঁ, অতীন অরোরা, 2021 bracket 15 company cases,
my lord,
314,
314.
এটা রিপোর্টেড অ্যাক্ট, আর এই ম্যাটারটা হচ্ছে অতীন অরোরা, লেখো ইন দ্য ম্যাটার অফ অতীন অরোরা সাচ অ্যান্ড সাচ, লিখেছো দেখে আচ্ছা, and next
My lord, Morgan Stanley.
Morgan Stanley you have not placed formally.
No, my lord, we had just referred to it, my lord. We did not
That's
place,
right.
my lord. Correct. That's 19.
I referred.
Yes,
Yes, my lord. I'm sorry. Yes, my lord. 1994 4 SCC, I think, my lord, 225.
Acha, then Shashi,
Shailaja Krishna, my lord.
Shashi I have taken note of.
Shashi Prakash, yes, my lord, that's the first one.
Shashi লিখেছো?
2019 18 SCC.
দেখো,
No, first one, my lord.
Shashi is the first one.
So she's the first one.
That's right, 2019 18 SCC.
Yes, he has already
Correct,
noted.
correct. নোট লিখেছো? আচ্ছা, এবার কোনটা বলো?
Second
Shashi
was
লিখলে,
Atin Arora.
অতীন অরোরা লিখলে, আর
Then, my lord, Shailaja Krishna was a Satori Global. 2025.
না,
No?
then Shailaja Krishna is on fraud.
Yes.
That's so different. So these are the two cases you have.
Yes. For 430, yes, man.
Next, 430 and 227.
227.
These two
Athin Arora.
Athin, very well. Next. Mr. Banerjee, learned senior counsel, then submits that, then referring to the averments made in the plaint, submits that the plaintiffs have sought to raise a case of fraud. Plaintiff has sought to raise a case of fraud, case of an alleged fraud against the defendants before the civil court. Mr. Banerjee submits that the jurisdictional NCLT has ample authority to consider fraud while adjudicating a shareholder's action as made out in the plaint. Full stop. In support, comma, he has relied upon a decision of the Honorable Supreme Court in the matter of eta lekho. Sailaja eta puro likhe dao baba. Reported at These are your submissions? Any
Yes,
further?
my lord. Yes, my lord.
The last one, if your lordship would like to, my lord, on the point of what the reasoning should be, my lord.
Not required.
My lord.
Chair though.
So these are the
Yes, my lord. Yes, correct.
these are
Grateful.
Mr. Shaunak Mitra, learned counsel, appearing for opposite party numbers 2 and 6 in the first revisional application 226. In the first revisional application, being the defendant number 127, 125 in the civil suit, has adopted the submissions made by Mr. Ratnanko Banerjee and his senior advocate. First up. In addition, he submits that, that Section 430 of the Companies Act clearly also bars to pass an order of injunction by a civil court. He further submits that the petitioner has already stepped down from the management of the company in the year 2008. Referring to the averments made in the injunction application annexed to the petition, he submits that the order impugned is verbatim reproduction of the prayers, but without any reason as to why the prayers have been allowed at an ex parte ad interim stage. First. These are your submissions, Mr. Shaunak Mitra. Next. Mr. Abhrojit Mitra, learned senior advocate, appearing for opposite party number 7. I believe will not do.
Number 10. Defendant number 10. Opposite party number 7.
Opposite party number 4.
7.
Opposite party number 7. Mr. Abhrojit Mitra, learned senior advocate. আচ্ছা কোথাও অসুবিধা হচ্ছে না তো? আমায় থামিয়ে দেবে তুমি, কারণ পরে কারেকশন করা মুশকিল। Mr. Abhrojit Mitra, Learned Counsel, appearing for opposite party number 7 in the first revisional application, being defendant number 10 in the civil suit, submits that the company has entered into a development agreement with his client touching the land of the company way back on January 5, 2023, which is available at page 268 to the application. He submits that all along the petitioner was aware of the execution of the said development agreement since its execution. First step. Further, Mr. Mitra has also adopted the legal submissions made on behalf of the petitioner. First step. Paragraph. The petitioners in this revisional application accordingly pray for setting aside and or quashing of the said impugned ad interim ex parte injunction order dated
September 25th, September 25th.
September 25, 2025. Poster. Mr. Jishnu Shah, learned senior advocate, appearing for the opposite parties, some of the opposite parties. Opposite party number? Opposite party number 1 in the first revisional application, being the plaintiff in the suit, submits that the order impugned being passed under the order impugned being passed is an appealable order and not revisable under Article 227 of the Constitution of India. Please, now please both of you hear my recording, right? কি বললাম? Revisable under Article 227 of the Constitution of India. The appellate court in the civil court is available, but still the petitioners chose not to move this appellate court, not to move the jurisdictional appellate court, and straightway applied under Article 227 of the Constitution of India. The revisional application is therefore not maintainable. Paragraph. Mr. Jishnu Shah, learned senior advocate, referring to the pleadings, referring to the averments made in the revisional application, submits only paragraph 26 thereof deals with an alleged urgency, but the same does not show whether the petitioner had applied before the appellate authority or made any attempt to prefer the appeal. When an alternative remedy is available, the law is well settled that an application under Article 227 is not maintainable. Paragraph. Referring to the plaint in detail and the averments made thereunder, Mr. Jishnu Shah, learned counsel, submits that the plaintiff, being one brother, has filed the plaint against the other brother and family members. Poster. The specific case of the plaintiff is, by virtue of practicing fraud, the shareholding of the plaintiff in the subject company, namely Power Tool, has been reduced in an illegal and wrongful manner, and thereby the plaintiff has been left out from the control of the management of the company, management and affairs of the company. The nature of fraud as alleged in the plaint is such, the same cannot be adjudicated upon by the jurisdictional NCLT. And it is the civil court who has to adjudicate it. In support, Mr. Shah has relied upon the following decisions. এক নম্বর বা ABC যা পারো। বলছি আমার কোনো আপত্তি নেই, কিন্তু কোহেরেন্সটা যেন থাকে, কোনো অসুবিধা নেই। এই জাজমেন্ট গুলো আপনি চারটে ছেপে দিন, তারপর ডাকুন, কোনো অসুবিধা নেই। আমার কোনো অসুবিধা নেই, আসুন আসুন, আপনি 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 এই জাজমেন্ট গুলো ছেপে দিন। ইন দ্য ম্যাটার অফ, লিখুন না, অরুণা আসওয়াল ভার্সেস, এইটা দেখে নিন, রিপোর্টেড অ্যাট এইটা, আপনি নিয়ে গেলেও একটু লিখে নিন, কারণ কি ভেকেশন তো অসুবিধা হবে, নাহলে এখন সময় হোক, ক্ষতি নেই। আপনি সব নিয়ে যাবেন, কিন্তু লিখে রাখুন তাও। 2 নম্বর, ইন দ্য ম্যাটার অফ তিন নম্বর, বেশিক্ষণ লাগবে না। হ্যাঁ লিখুন না একটু তো এইটাই লিখে দিন হ্যাঁ 249 কোম্পানি কেসেস লিখে দিন হ্যাঁ হয়ে গেল এটা কত লিখলেন 3 নম্বর 4 নম্বর এই খারওয়ার কোথায় এখানে এসো এই হয়ে গেছে এই তিনটেকে একসঙ্গে ট্যাগ দিয়ে বাঁধো ট্যাগ দিয়ে বাঁধো ফুল স্টপ প্যারাগ্রাফ Mr. Jishnu Shahal and its senior advocate paragraph further submits that since NCLT is not permitted to look into the fraud alleged by the plaintiff, it is the civil court is the jurisdictional forum to try and adjudicate upon the said suit, the pending civil suit. Therefore, the civil court does not lack jurisdiction inherently. And unless there is an inherent lack of jurisdiction of a forum which has passed the impugned order, Article 226 cannot be invoked, 227 cannot be invoked when there is an available appellate forum. Next. Mr. Jishnu Shah, paragraph, further submits that sufficient reasons are there in the order impugned. The order records the finding of the court on the basis whereof the ad interim injunction was passed. He then submits that even if this court finds that sufficient reasons are not there, the law is well settled, that the appellate court can supplant the reasons. If the appellate court comes to a finding that the conclusion in the order is otherwise correct on the basis of the materials available on record. Yes, Mr. Chatterjee, Mr. Chaudhary, what, if anything else?
That we had made that submission, my lord, that certain
Mike.
that certain prayers, my lord, in the
Mike now to me. Come on.
certain points, certain prayers in the plain could never have been, my lord, considered by the NCLT at all. He had referred to, my lord, CHL and
Mr. Shah, senior advocate, then refers to paragraph prayers C, D, H, and L from the plaint and submits These prayers cannot be considered by the NCLT, right? What else?
Lord, if the reasons are also not granted or not there, that doesn't make it a revisable order, my lord. It still is a point in appeal.
Full stop. He further submits that even if reasons are not at all there in the impugned order, this does not make an order revisable, which is otherwise appealable under the law. Which decision?
That division bench judgment of the
That is
Sukumar
prior to the
Chakraborty
amendment.
judgment. He read it out for your lordship.
And he's talking about 88,
No.
89,
85.
89 CWN.
89 CW.
Got it. In support,
Paragraph 16 and 7.
Prior to the amendment done 100.
in support,
27 only.
he has relied upon a decision in the matter of RP properties reported at এইটা করে দাও।
But if the judge doesn't,
গুলিয়ে ফেললে আমার মুশকিল।
না একদম গুলিয়ে তো
Yes, Mr. Chatterjee.
My lord, also, my lord, if the judge doesn't write reasons, it's not, my lord, the fault of the litigant. That is why that judgment, my lord, which says that the appellate court can supplant.
Full stop. He also submits that
And we
if
can
the
go to
reasons are not there in the order impugned, there is no fault or laches on the part of the litigant for which the litigant shall suffer. Right? Anything else?
And this suit is not basically, my lord, a suit on companies. Part of it is, but the other part is with respect to, my lord,
No, that I
title it
recorded
says-
that those prayers cannot be. I have said that.
Kindly takes the plain true and correct.
Yes, yes.
Please. Lastly, Mr. Jishnu Shahal and his senior counsel submits that while passing an ad interim order, be it ex parte or not, the averments in the plaint to be taken as true and correct.
That is the 88 Calcutta.
On the basis whereof the ad interim order, the ad interim order has also been passed in the instant case. That's right? Paragraph. In the poster.
This, my lord, that 88 Calcutta was given Mukta Keshi's judgment. 88 Calcutta, page 25.
Where is that?
Yeah.
No.
Where heavily
It was not handed up.
ultimately
No. Not required. It's required.
because then he'll be in a fixed ballot because
In
his
support,
government says otherwise. That's why
in support,
Judgment, you don't know.
that is why he's not.
he has relied upon a decision in the matter of Srimati Mukteshwari reported at 88 Calcutta. আপনার রিলিভার এসছে? ঠিক আছে, আপনি এটা পুরো ছাপবেন, বাকিরা অন্যগুলো ছাপবে। ঠিক আছে? আর 1 নম্বরটা আপনি চেপে দিয়েছেন? হ্যাঁ? আমার চেম্বারে তো আপনি এইটা পুরো ছাপুন, অন্যরা বাকি ছাপবে। এইটা আমি শেষ করব, এইটা পুরোটা আপনিই ছাপুন, কারণ এখনো আসেনি কেউ, আমি তো বসে থাকতে পারি না। দ্যাটস রাইট। সো বাকিরা আবার যখন আসবেন পরের মামলাগুলো ওনারা নেবেন, অসুবিধার কি আছে? কি বললাম? In support of বলি না আমি, in support, he has relied upon the following decision. He has relied upon a decision in the matter of Mukteshwari Sachansa versus reported at AI 88 Calcutta. হয়ে গেল? Paragraph. These are your submissions. Paragraph. In the Mr. Joy Shahal and his senior advocate appearing for
Plaintiff in below the OP number 1 in the second one, item number 7.
OP number 1, opposite party number 1, in the second revisional application, in the WPA, come on. In CO?
CO number 3767.
3767 of 2025. CO 37
My lord is only on WPA.
67 of 2025. ওটাকে করে ব্র্যাকেটে ফর শর্ট দ্য সেকেন্ড রিভিশনাল অ্যাপ্লিকেশন একটু পড়ুন ভাই কি বললাম
Issue থাকতে I'll just come back to the decision, please.
হ্যাঁ, যা। লম্বা বড় ছবি।
for short the second revisional application, yes, Mr. Chaudhary has adapted the entire submissions made by Mr. Jishnu Shahal and its senior advocate, and in addition he has added that there is no compelling circumstances which led the petitioners to file the instant revisional applications. By exercising the jurisdiction of this court under Article 227 of the Constitution of India. These are your submissions, full stop. Paragraph. Ashu. Thank you. হ্যাঁ এখন আমি শেষ করব তারপর আপনি ছাপতে থাকুন যদি কোথাও আটকে যান বা অসুবিধা হয় দিদি আপনি আমায় ওখানেই থামিয়ে দেবেন 15 বার জিজ্ঞেস করবেন কিন্তু উল্টো পাল্টা না চাপা হয় after considering the rival contentions of the parties and upon perusal of the materials on record, this court, at the outset, reiterates the settled law in exercising its power under Article 227 of the Constitution of India. Full stop. The power conferred upon this court by the Constitution is the power of superintendence over all courts in its territory, by the concerned High Court. Alternative remedy is not an absolute bar, but it is a self-imposed restrictions. If this constitutional court, in exercise of its power under Article 226 of the Constitution of India, 227 of the Constitution of India, finds that the jurisdictional error is ex facie apparent on the impugned order, and if such a jurisdictional error affects the rights of the parties by virtue of by a party by virtue of the said impugned order, this constitutional court has plenary power and ample jurisdiction to intervene and the available alternative remedy in that case will not be an absolute restraint. First paragraph. With regard to the points of with regard to the issue raised by the petitioner, now with regard to लिखते शुरू करूं paragraph. The issue raised by the petitioner questioning the maintainability of the civil suit that the civil suit is basically a shareholder's action and the NCLT should be the appropriate jurisdictional authority to try it is a mixed question of law and facts. First. Admittedly, the impugned order was passed ex parte. The impugned ad interim order was passed ex parte. First up, as such, the petitioners herein, being the defendants in the civil suit, did not have opportunity to raise the issue of maintainability before the civil court. First. Paragraph. On a plain reading of the order impugned, hey, Khadwar, এগুলো কো একসঙ্গে বাঁধো। The order impugned it ex facie appears that the order does not disclose any reason which had prompted the civil court to pass it. First, on a careful scrutiny of the order impugned, it appears that the learned civil court has recorded the plaintiff case and the submissions of the plaintiff. The learned court has recorded that various documents relied upon by the plaintiff to show a prima facie case, along with several incidents. First, on a plain reading of the order, it appears all those incidents alleged to have taken place since 2010 and thereafter up to 2023 till execution of the development agreement dated January 5, 2023. The order further shows that the plaintiff has relied upon an alleged certificate issued by Urban Land Clearance. Issued under Urban Land Clearance. Which was a result of an application under the RTI Act in 2025. In July 2025. The plaintiff has filed the suit on September 25, 2025, as this court has been informed by the counsel for the plaintiff. The order also records the documents filed by the plaintiff shows fraudulent property transactions as well as misuse of industrial land, siphoning of fund, which has necessitated the civil court to pass the said ex parte ad interim order. But no reason has been there which has led the learned civil judge to come to a finding that why the said ex parte ad interim order was warranted to be passed. Paragraph. The law is well settled that reason is the very life of law. When the reason of a law once ceases, CEASES, the law itself generally ceases. Full stop. Such is the significance of reasoning in any rule of law. Full stop. By practice adapted in all courts and by virtue of judgment law, judge-made law, the concept of reasoned judgment or order has become an indispensable part of basic rule of law and in fact is a mandatory requirement of the procedural law. Full stop. Clarity of thoughts leads to clarify of vision, and proper reasoning is the foundation of a just and fair decision. Full stop. Paragraph. In the light of the law settled above, this court is of the firm and considered view that the impugned ex parte ad interim order, being devoid of any reason, or an interim order dated September 25, 2025, being devoid of any reason, is not sustainable in law. Paragraph. Accordingly, the said ex parte ad interim order dated September 25, 2025 stands set aside and quashed. Paragraph. The interim application has already been fixed before the learned civil judge on October 31, 2025, when the court, when the civil court shall hear out the injunction application upon notice to the respondents therein, Poster. And then the civil court shall be free to proceed in accordance with law with the hearing. Full stop. Paragraph. It is made clear that this court has not gone into the point of maintainability of the civil suit, and such point of maintainability raised by the petitioners before this court are kept open. And the same shall be heard at the threshold on the next date.
They don't file an application under Order 7, Rule 11. There's no
Let-
question of hearing that out.
Full stop.
We will file.
That can't be an issue, my lord, right
Sir,
now.
Plaint will be read.
Yes, that's on the at the time of
If
hearing the order, then I don't want to do
they
application.
take the point of jurisdiction, if it appears, it is barred on the face of the plaint, it will be barred.
That is for them.
Very well.
Them to
ঠিক আছে,
take.
কি বললাম? On the next day. Now, at the threshold. At the threshold, at the threshold. আর কিছু লেখা দরকার, at the threshold. Full stop. Paragraph. It is further made clear that this court has not gone into the merits of the suit or the injunction application and the rival contentions of the parties, and the parties shall be at liberty to urge all their respective points before the civil court.
I was wondering, my lord, in the meantime,
Full stop.
thank you.
Yes.
But in the meantime, my lord, let them not do anything with the properties of
stop.
the
With the, in view of the foregoing reasons and discussions, the order impugned stands set aside, and the revisional and both the revisional applications stand allowed. Comma,
Grateful.
with any order as to costs.
Grateful.
The learned judge would hear it out on the 31st itself, my lord, your lordship
Upon
has,
issuing notice, that's what.
That I've said.
your lordship has
Yes.
31st itself.
I've said that.
My lord,
That I have passed my order.
only one in. My lord, one indulge.
আর হাত দেবো না
One in.
অনেকক্ষণ হয়ে গেছে।
Only
Today your lordship,
আমি অন্য ম্যাটার
My lord, 2 o'clock, your lordship is
একটা
taking up
স্টেপলার দিন তো
original side matters, my lord. Number 3, my lord, it's a Birla Lota matter, my lord. My lord, your lordship will
I'm
kindly.
coming back. I will take up the original side first. Then again I will take, because in effect, 3টে appellate side শেষ হয়ে গেল আর 6টার
Item number 3 will kindly be taken up, my lord.
why
sir, I will go by the list. I will not
Because
overlap.
the meeting they're trying to hold is, my lord, on the 24th, my lord.
I will, if I reach, I will. I will not do that.
Birla Lodha can't have precedence.
No, I'm not saying that. I'm saying it's
I don't know Birla Lodha. Which Birla Lodha is this? Which one?
Priyambada Devi
Yeah, my lord, my lord.
Oh, I mean, in any event, please point it out.
My lord, then my lord will kindly do it now, because or else the other bench we cannot approach, my lord. No, what fell from me? Sorry, my lord.
Which one? Which one?
Item number 3.
I will not take up.
Next matter, my lord. Then my lord kindly gives me that liberty to approach the other bench.
আরে সেটা অরিজিনাল সাইডের
Next one, not original side. Appellate side, next matter, my
ও
lord.
অ্যাপেলেট সাইড নেক্সট
Yes.
ম্যাটার আচ্ছা দাও খুব ভালো
Kindly does that, my lord. Or else, my lord, I cannot approach the other bench, my lord.
Why should
I appear
why you continue to disturb people?
কোনটা কোনটা কোনটা
My
কাম
lord,
অন
3, my lord, 3.
পাঞ্জাব
Punjab
প্রোডিউস
produce.
পাঞ্জাব প্রোডিউস বিল্লা লোডা
Yes.
please mention like the oh yes Harshavardhan Loda yes I so I appear
Student, sir.
this revisional application stands released on my personal ground full stop
And he plays before.
এবার কি করতে হয়
Now
But
it
there's
has
nothing.
এখানে কি করতে হয়
Automatic, it's automatic.
No, it's not.
Please, Mr. Chaudhary, the notice says
Automatic
so.
হবে না।
The notice of the court, my lord, which your lordship is there for vacation bench, says it will straight away go to Mr.
other single bench
Mr. Justice, my lord.
parties
Approval-
parties
Yes.
shall be at liberty to take steps
And the file may be released, my lord.
in accordance with
Notification.
in accordance with the direction prevails
Yes, delayed or no?
in accordance with the direction prevails full stop
Without calling for any order of assignment.
এটা কি হ্যাঁ you are right Mr. Ray is right Mr. Ray সব সময় অপোজ করলে হবে
No, no,
Why will I, my lord?
no,
I
he's
have that
this is
much
his
ability,
luck
my lord.
because
আসুন কি বললাম
he's challenging an AGM in a civil suit.
আরে don't go into the merit
হয়েছে চল না বাবা।
কি
I'm
বললাম
very grateful to you, lordship.
কি বলুন একটু বলুন parties shall be at liberty to take steps in accordance with the prevailing direction
On the next day.
that is up to them full stop
Only the take steps to take the.
the record is directed to be sent forthwith whenever the requisition comes
Will be immediately put in the record.
I'm coming within 10 minutes Yes, list. Daily list.
That would it be a lordship pleasure to call the supplementary list first?
No.
No, the bank
Come on,
has.
come on, come on, daily list.
Dependent, not please, my lords. But this item 1, I'm for the defendant. I appear for the petitioner. This is my case, my lords. My lords, I am the sole legal here and the daughter of the deceased. I am seeking injunction over the assets that have been filed in the letters of administration case, my lords. My father has passed away on 1st of October 2024. My lords, by and large, the assets includes the savings and deposits he has left behind in 3 banks, my lords. That is Federal Bank, firstly, and there are other 2 banks, Union Bank of India and State Bank of India.
So what do you want?
My lords, I am saying that the respondent number 1 is my uncle, who has been the nominee of these bank accounts, my lords. My lords, what has happened? I would have your lordship attention to page 72, annexure J of my application.
No,
where
just tell me what about the matter about? What is the parent suit? It's a testamentary proceeding.
Yes, my lords. Interstate succession, letters of administration. my
Letters
lords.
of administration.
Yes, my lords.
The beneficiary is applied or the legal heirs.
My lords, legal heir has applied. I am the sole beneficiary because I am the only daughter, my lords. My father was
So
divorced.
no will left. It's not
No,
the
no,
case
my
that the executor is there, not
Nothing,
there. So
no will,
no will.
no will.
So the legal heirs applied.
Exactly, madam.
Then
My lords,
you are whom you are representing? The deceased.
my lords, I am the daughter and the legal heir, sole legal heir, my lords.
So you are the sole legal heir.
Yes, I'm the sole legal heir. My father was married, who got divorced in and around 2004 to 2005 with my mother, and that marriage has been dissolved right now. My lords, I am a NRI sitting in Australia, my lords. Presently, I am also pregnant for last 7 months also. My lords, what has happened in between after the demise of my father? My lords, the funds, particularly by one of the bank, that is Federal Bank Limited, respondent number 2.
So there is no rival claimant.
My lords, rival claimant is respondent number 1, who is my uncle, my lords.
Uncle means
My father's
brother
his
or
father-
mother's brother.
His brother, own brother. My father's own brother, parental uncle.
Parental uncle.
Yes, my lord.
He is living.
He is living. He stays.
Not you, your client.
He stays in Canada, my lords. But what happened is
So it's
that,
Canada versus Australia.
rightfully, my lords. My lords, then what happened is this, that on 29th of November 2024, that is subsequent to the demise of my father, we made a representation seeking for freezing of the accounts and deposits until and unless we get the letters of succession from this court, my lords. Meanwhile, Federal Bank has transferred the 3.40 crores lying in that account to my uncle, who happens to be only the nominee. And thereafter, my uncle has withdrawn around 1 crore. This has been particularly informed by the Federal Bank branch manager itself, my lords. That is the reason I'm approaching this court right now, my lords. My lords may have annexure J, 72 of my application.
One second. When first you informed the bank that you are
Yes,
the
my
legal heir,
My lords, I approached the bank on 17th of October 2024.
when did the testator died? Not testator.
1st of October 2024, my lords. On 2nd, I landed in Kolkata from Australia.
Wait. 1st of October.
My father died.
Father died.
Yes, my lords.
Where is the death certificate?
My lords, death certificate is attached. My lords, this has been for annexure B,
Page
24.
When did you inform the bank?
My lords, I informed by writing on 18th of October 2024. And on
2024?
Yes, my lords.
Before your father died?
No, my lords, my father died on 1st of October. 18/10/2024. 18/10/2024.
Father died on what?
1st of October, 1/10/2024.
Oh, you said 25.
24, my lords. I apologize for that.
I'm confused. 24, 1st October, father died.
Yes.
Then
on 18th, I made a
18th October, you informed the bank.
Yes, my lords. So
that you are the legal heir.
Exactly, my lords.
Show me.
My lords,
Page.
Yes, my lords. My representation is at
page
annexure E, colleague. This is page 34.
When the fund was released?
Malas, funds in and around June of this year 2025. This has been verbally communicated by the branch manager. Also,
Show me a document that fund has been released.
Malars, there happens to be no representation from the bank side, although I have made representation to apprise of the status subsequent to the filing of this PLA matter, Malars. They have remained silent completely. I have made.
Why do you want to file this? Where is the requirement? You being the sole legal heir
Malars.
to file this PLA?
Malars, because
There was no will.
there was no will, Malars.
Then-
It's an intestate succession because one of the bank asks for a court succession certificate order that
Succession certificate.
either a grants of letters of administration or a succession, Malars. That's the reason I approached this court with all of the assets lying in the three banks itself, Malars. Malars, what has happened?
All the three banks are
all the
parties.
three banks, yes, Malars. They are-
Parties.
yes, Malars. Respondent number 2, 3, 4.
Then,
Malars. Malars, then what happened is this 29th of November 2024, Federal Bank intimated me that we are in process of transferring these funds to respondent. Yes, Malars, to the nominee. Malars, and there they mentioned it as a proviso over there that he will be going to hold it in trust, Malars. On the behalf of the legal
when
yes.
did the bank write?
This is Malars 29th of 2024. Malars may find it at Annexure J, page number 72. May I read out, Malars?
I will. Page
72.
All right.
Malars, may I read out, Malars, here?
Wait.
Yes.
Then what happened?
Malars, then what happened that we mentioned a legal notice. We sent out a legal notice to my uncle itself, where he replied saying that so there happens to be some private conversation with my father over WhatsApp, and their case altogether they asserted to a case saying that existence of a oral will. Now it has no legs to stand, saying that
these are the stand taken.
Yes, Malars.
And the bank said 3 crores has gone.
Presently, out of the 3 banks, only Federal Bank has done such activity. Rest of the 2 banks have taken a divergent view and they have not done anything. They have maintained a where is it basis. You go and get us the order, then only we will process it. Malars, now what has happened is this: out of these 3 crores, now I don't know in which bank account of respondent number 1, that's my uncle, has been transferred, and thereafter 1 crore around. This is what I have came to the knowledge from the branch manager itself, that he has utilized it. Now there owes an obligation and a responsibility of the bank also to ensure, merely not by writing saying that it's a trust.
Yes, Mr. Manager.
2 things, Manoj. I was just wondering that the cause of action pleaded is of October 2024.
I will hear you. First secure 3 crores
Manoj, I'll
with
tell
the
you-
registrar.
Just one thing, Manoj, Lordship will have a look at page, not just 3 crores, but I'll indicate. My stand is going to be very clear. Please have a look at page 79, the document 72. And I'll show one paragraph that he's stated here. This is of November 29, 2024. Lord, if your Lordship looks at the application, so why is it
Do you deny that she is the daughter of the deceased?
I don't deny that she is the daughter. But she also does not deny two. She does not deny one.
No.
fact. Well,
Do you
two
deny?
minutes, Manoj.
Do you? No, I'm coming, sir. I will hear you. Don't worry.
that's
Request an
right.
affidavit to be heard.
That's right.
But before that, something. I will hear you also. That's before directing something. I will also hear you. Do you deny that she is the daughter?
No.
Do you deny that any other legal heir?
No. I did just deny one fact. One fact he admits that in paragraph 12 he writes in October 2024, he's found out that I am a nominee to the bank account.
Yes, you are nominee. Admitted.
I am a nominee. So as a nominee,
What is the
entitled to-
obligation of a
Correct.
nominee?
I take it in trust. And then it has to go in terms of, that's very clear.
That's precisely.
That's it. So that is my stand before the court today. I have apprised my client. Only difference is, this money, which is why I want an affidavit, this money is not that of my brothers. This money, I'll tell you, Lordship, this money, kindly see how there is no averment in the application. that
Mr.
the Lordship-
Banerjee, this makes too much of suspicion now.
I'll tell you, Lordship. I'll indicate.
All right.
So which is why I'm saying that I will file an affidavit.
You make your submissions.
But
But
I have
7 days, within 7 days, you have to secure with the registrar original site.
I'll go a step further. As a nominee, please record that I'm a nominee in respect
Yes,
of
I will.
whatever funds will come to me as a nominee, I will put it with the registrar.
No, whatever. First, whatever amount you have received from this bank.
But that I'll have to take instruction what amount I have received. I'm saying what I've received and what I'll receive in future also as a nominee.
No question
give
of
the
receiving
direction.
further.
No, I am taking a step forward because
No,
I
sir,
understand
you
what a nominee is
I will restrain the banks
from
not to release any further.
in favor of anybody.
Anybody.
Very,
Anybody.
very well.
He first establish her claim. She
That's
will
right.
establish
That
her
is my
claim.
only thing.
So if
That
that
is
is
not-
right, sir, Mr.
So
Banerjee,
whatever I have received.
why so much of painful act that
No.
unless she asserts its right on her father's money, uncle will control, uncle will take.
Uncle will not take. I will whatever I've received as a nominee.
Have you served notice upon Federal Bank?
Yes, my lord.
Where is that?
Certificate of service has been filed, my lord.
I will do it on my own. I will put Lordship will make that as a part of the order, not record my concession.
No.
I will put that in with the registrar. And please restrain the bank from giving it out to anybody else.
Giving it out to you.
Anybody.
To you.
No, including her.
No, why?
I'll tell you, Lordship. Because then this rival claim will have to be asserted.
Yes.
Then,
If you get a decree, you will execute then.
give me 3 weeks, I'll file an affidavit.
No, you will do. But before
at least
that,
so
within-
far as page 72 is concerned. where he
whatever,
says-
sir, may what come. Daughter claims, sole daughter, she will have the first claim. So I will protect that also, that it will not, of course, I will protect her. But I will not restrain
Whatever
her
I
to
have
receive.
No, but whatever I have received as a
The
nominee,
moment, sir,
I will put it with the registrar.
Sir, the moment she has arrived in the picture, the nomination goes. In law, just it evaporates, erased. So she will be.
I am addressing that. Whatever I have received as a nominee, I will secure it.
Of course, you have
As
to.
page 72, what he's showing,
Of course,
I will
you have
secure
to.
that. I'll put it with the registrar. I have indicated that to my client, and I'm completely
You
willing
have
to.
to, and henceforth
That
you
is
will
all
not
that
be
I'm entitled
nominee.
to in law.
Henceforth you will not be nominee. If you have a rival claim, I will give you
No,
that
not the
liberty.
rival claim. Kindly give me 3 weeks time to file an affidavit to this.
Of course, but in the
So
meantime,
I will just be able
in the
to show
meantime,
the source of funds.
injunction restraining you from receiving. The beneficiary has arrived, so the nomination goes automatically. Automatically.
Injunction restraining me from receiving the nominee from receiving funds.
From any of the remaining two banks, and whatever he has received,
Whatever
he has
I
to be with
received in
that.
terms of
I have
72.
understood,
Yes,
sir.
my lords. Grateful.
I will put it in.
Grateful. Has to be secured.
I'll secure that.
You now just both of you just assist me in recording facts.
Yes, ma'am.
This is an interlocutory application filed by the petitioner, who has already initiated a proceeding before this court for obtaining a letters of administration in respect of the estates of her deceased father. Paragraph. The father died on October 1, 2024. As would be evident from the death certificate annexed at page 24 to the application. Full stop. The savings in whatever mode and manner of the deceased father are lying with respondent number 2, 3, and 4. Bracketed for short, collectively the banks. Where the respondent number 1 being the brother of the deceased is allegedly the nominee.
Admitted. That's an admitted fact.
No, all right. Allegedly the nominee. Full stop. The specific paragraph, allegation of the petitioner being the daughter and the only legal heir of the deceased, is that the respondent number bank, respondent number
Respondent number two, Federal Bank.
2 has already released a sum of about
3.40 crores.
3.40 crores.
The figure is correct.
And he has utilized 1 crore out of that.
This figure I don't know.
I will record that. In favor of the petitioner, a respondent number 1, being the nominee, being the alleged nominee. The petitioner further submits that the rest of the 2 banks have not yet released any amount in favor of the respondent number 1. The banks have asked for proof of heirship from the petitioner so that steps can be taken in accordance with law in respect of the estate, E-S-T-A-T, oh, tumi acho, estate of the deceased. The petitioner is in the process for receiving the same and has accordingly instituted the proceeding for letters of administration before this court. Which court? This court?
Yes, before this court.
Full stop. Oh, original cited.
Yes, original.
Before this court. It is also submitted that the petitioner has received information that out of the said about 3.40 crores or more than that, whatever has been released in favor of the petitioner, respondent number 1 by the respondent number 2, more than a sum of rupees 1 crore has already been appropriated allegedly by the respondent number 1. Paragraph. Mr. Shuddho Satto Banerjee, Learned Counsel, appearing for respondent number 1, comma, at the threshold, comma, denies the quantum of money, denies and disputes the quantum of money referred to above. However, full stop, however, comma, Mr. Banerjee, on instruction from his client, admits that the petitioner, being the only girl child, is the sole legal heir of the deceased. First paragraph. Considering the rival submissions of the parties and considering the letters, materials on record, and specifically the letters dated October 18, 2024 and November 29, 2024 at pages 34 and 72 respectively of the petition. Comma, this court at the threshold is of the view that the moment the sole legal heir has arrived, on the scene, comma, the nomination loses its force. Full stop. In any event, at the highest, the nominee would have a right to receive the estate of the deceased by virtue of nomination and to hold it as it is, as a trustee and or a custodian, and not beyond that. The nominee has no right to appropriate any part of the estate of the deceased. Where is your notice, Federal Bank?
Well, it's the intimate notice given to the Federal Bank, right, my lords?
That you will be moving this application. Where is
Well,
your
that-
affidavit of
that
service?
Master summons have been dispatched to them and affidavit of service have been filed, my lords. It's on record. This is the copy of the affidavit of service, my lords.
Acha, master summons.
Yes,
affidavit.
my lords.
Full
It
stop.
has been served.
Full stop. The affidavit of service on record. Affidavit of service is on record. Paragraph হলো তো? পরের paragraph. The respondent number 224 are not represented, comma, despite notice. Paragraph. In view of the above, the following directions are made. Colon. A. The respondent number 2 positively within 3 working days from the date of communication of this order shall communicate in writing with the detailed bank statement to the petitioner.
And me, my lord.
Petitioner and the respondent number 1 communicating the actual quantum of money being part of the estate of the deceased has already been released in favor of the respondent number 1. Paragraph. Next, B. Semicolon and for B. Upon receiving such communication, the respondent number 1 shall secure the entire amount received by him from the respondent number 2 with the learned registrar, original site,
Yes.
register original site of this court, positively within a period of 1 week from the date of receiving communication from the bank.
Kindly make that 2 weeks, my lord.
1 week. Because
I'm in
ultimately
Canada.
you have to bear the interest on it.
No, that's right. But I'm in Canada. But it'll take me some time. He's coming after a year. I'm
Very
paying
well,
for a week
very
more.
well. But ultimately you have to pay
Yes, I
interest.
understand that. If the money is otherwise secured, then
Within 2 weeks, comma, 2 weeks from the date of receiving the communication from the bank. এতে চলে এসো তো একবার। পড়ো। Such full stop at ওখানেই ওই প্যারাগ্রাফে such communication can also be made over electronic mail. Full stop. তারপর বি কি বলেছে? বি কি বলেছে? আবার পড়ো, আমার খেইটা হারিয়ে যাবে না। From the bank. C. This,
That he'll just reinvest this money.
no, that though, I will direct
Yes, then
upon
this,
this,
yes,
that
yes,
is all
this-
right.
This word was a part of my concession.
Uh-huh.
Absolutely.
B. The registrar original site, landed register original site, upon receiving the money from the respondent number 1, shall invest it in an interest-bearing fixed deposit account with any nationalized bank of her/his choice, and shall prepare a report accordingly and keep the said report, keep the same in the original file of the cost papers.
Well, it gives me 3 weeks.
Such fixed deposit, such investment shall be made by the registrar original site, landed registrar original site, positively within 3 working days from the date of receiving amount from the respondent number 1. By forwarding letter, the office of the registrar original site shall forward a copy of the fixed deposit receipt to the learned advocate on record for the plaintiff.
And me.
Why?
Get to know, because I'll have a rival claim.
You will take take information from the office of the registrar. You have no right.
No, that right will be decided. No, just an intimation that has been gone in.
You will know.
That's I'll just get to know that he's done it. There's nothing else here.
Full stop. Paragraph. Paragraph. Remember main paragraph. Question of calculating interest, comma, if any, payable by the respondent number 1 for the period the amount has been withheld by him shall be considered at the appropriate stage.
And what is the estate of the deceased? That's the letters of administration. I will have, so gives me that 3 weeks time to file an affidavit.
For what we have
I'm
filed
coming,
an
sir, I'm coming.
So just my affidavit I'll file.
Yes, you will file. Ki bolna? At the appropriate stage. Paragraph. The respondent number 2, 3, and 4 and or their men, men, agents, servants, assigns and or officials shall be restrained by an order of injunction not to release any further sum or not to release any sum and or any further sum in favor of the respondent number 1 until further order. Full stop. Paragraph. This order shall also not prevent the respondent banks to comply with their formalities and legal requirements required to be done by them and also by the petitioner, comma, in the event the petitioner lodges his claim in respect of the estate or part of it of the deceased, insofar as the three banks are concerned. These three banks are concerned. এটা পড়ো। Comma, in the event. Full stop. The banks shall proceed in accordance with law. Paragraph. Respondents shall file affidavit in opposition on or I'm giving you, but basically nothing remains.
No, there will be. Whatever is there.
কি বললাম? Justify your presence, no issues.
No. Apart from the bank, there's some other aspects also.
কি বললাম?
Nominee, there's nothing I can do.
Affidavits in opposition, give me a date of your choice.
3 weeks.
You give me a date, 3 weeks, 4 weeks, 9 weeks, I don't mind.
Grateful, so grateful, Your Lordship.
Because the application in all practical purposes has lost its force.
Not when. By the 14th?
On or before
14th of November.
November 14, 2025. Affidavit in reply, if any, thereto shall be filed by November 30,
Grateful.
2025. Full stop. Paragraph. After completion of the aforesaid period, the parties shall be at liberty to mention the application for hearing before the regular bench, comma, upon notice to each other.
Grateful,
Thank
Your-
you.
So grateful, Your Lordship.
Grateful. কার্ডটা কি নিচ্ছি? আমি যে একটা অ্যাপিলেট সাইডে হ্যাঁ কোনটা না কিছু ডিসপোজ Yes. Yes.
My lord, before my learned friend starts, my lord, there are 90 respondents. But I am appearing for respondent number 1. I believe Mr. Shah is for respondent number 2. But there are several people who have filed demurrer applications in another application. I believe whether the motion has been affected on those.
About others. If I have
No,
filed an
90
application,
respondents.
yes, you have been served. If you're right, you are entitled.
Application pending
Yes.
from
Can I move, my
2024,
lord?
same press.
Yes.
I am one of
I know.
the defendants who has filed a demurrer application. Lordship's last order My lord, records that the demurrer applications are to be taken up first before the
That's better.
injunction
First,
application
kindly
is
see the-
May I
considered. That is the
just-
order of 21st April.
Elders come to court. Youngers not.
He may be in other greener
apologize.
pastures.
I
Not,
apologize,
not
my lord.
merely, not merely enjoying the comforts of home, if I'm not wrong.
Yes.
Yes, Mr. Shah.
My lord, may I, it's my application, my lord.
90 respondents, we do not even know.
All right, let me
Yes,
hear,
yes.
madam.
My lord, so far as I am aware of the fact that there are 90 defendants, and my lord, I am also aware of the fact that in this suit, some of the defendants, only 5 defendants, have taken out, these are the companies, taken out an application under Order 7, Rule 11.
What's the nature of your suit,
Nature
madam?
of the suit is, my lord, a partition suit. Suit for partition. My lord, the suit was filed in the month of February 2024, my lord. My lord Justice Mukherjee, my lord, Arindam Mukherjee released it on the personal ground. Thereafter, my lord, the application was assigned before my lord Justice Sugoto Mujumdar. Injunction application, my lord. My lord, at that point of time, on 19th March 2024, my lord, Lordship will take the order.
Show me the prayers in the last application.
Yes, I shall come. First, let me just show to your Lordship one thing. The order, 19th March 2024 order. My lord, the directions for filing affidavit was given. That was the first direction.
Show me the prayers, madam.
Yes. Well, why I'm saying, my lord, shall show to your Lordship the prayer.
Plus, show me the prayers.
Yes, it is set out in the application.
Show me which page. Suit prayer I got. Page
The
43.
petition also, paragraph 43.
Page?
Page 44. Paragraph 43, GA1 prayer has been set out.
First, madam, come to your present prayers.
So first, my lord, before the,
No, I'm coming.
Yes.
Typographical. Kindly let me understand where is the difference between B and C.
There is the list is same. I'm not asking for injunction against all the defendants. My lord, only against the 4 of the defendants who have not.
No, kindly see your prayer B and C now in this application, madam.
Yes.
Read them.
Yes.
Where is the difference?
Yes, difference is it is confined to defendant number 14, 22, 23, 24, and 27.
But both the prayers are same in this petition.
Maybe, my lord, Lordship will ignore one of the prayer, my lord.
I am ignoring.
Kindly.
All right. You choose which one I will ignore.
My lord, it has gone. There's a typographical error, my lord. Lordship will combine it
Copy
with
and
the B.
paste. You tell me which one I will ignore. First, I will record that.
C, my lord, kindly keep
C. Very well. Wait, I'll hear you. At the outset, comma, MS Monju Manot. Now, Manot or Agarwal? Which one?
Same, my lord. Mixed.
Learned senior advocate. Appearing for the plaintiff petitioners. Plaintiffs oblique petitioners. Submit that On plain reading of the prayers B and C, it appears both are identical and same, including the description of the respondents mentioned therein. First up. Accordingly, comma, in her usual fairness, learned senior advocate submits she shall not press for prayer C to the instant application, and the said prayer C may be treated as relinquished oblique abandoned. ঠিক আছে, এবার বসে পড়ো। Yes.
Now, my lord, the suit was filed. The application was released by my lord Justice Mukherjee. My lord, kindly take the second volume on XSG, page 172.
Second volume.
Page 171.
Page.
Page 171.
117.
171.
Second volume তো 17 নেই, 105 থেকে শুরু।
171.
Oh, 171. Yes, madam.
It was released on 19th of February 2024. Then my lord come to Annex G, page 172.
174. Yes.
Now, my lord, the defendant numbers 1, 2, and 3 appeared, my lord, on 19th of March 2024, my lord. Then, my lord, kindly come to page 173. Since the application involves complicated questions of fact and various properties, this court is not inclined to pass any editing order.
Which one?
Page 173.
73.
173.
73 is the second page of some order.
173, my lord.
173 তো দেখছি। No.
Yes, this one only.
So tell me the order first. How are I understand?
My lord, it is the order dated 19th of
Yes,
2024.
read on.
My lord, this order says that GA1 of 2024 is filed making various prayers like appointment of receiver, ad interim order of injunction. Ad interim orders are also prayed for in terms of prayers A to H in respect of annexes B, C, and U. Copy of the application is to be served upon the parties. Affidavit in opposition shall be filed within 3 weeks from date. Reply, if any, within 2 weeks thereafter. Then, my lord, the prayer for ad interim order was made. Since the application involves complicated questions of fact and various properties, this court is not inclined to pass any ad interim order at this stage, and the matter was directed to appear on 3rd May 2024. My lord, that was on 19th of March 2024. Today, my lord, we are in October 2025. Thereafter, number of occasions, my lord, the matter appeared before the Honorable Court, my lord. Extensions were granted to them to file affidavit in opposition. Now, my lord, some of the defendants, my lord, have chosen to file the affidavit in opposition, my lord, and we have filed our reply. So far as defendant number 2 is there, 1 and 2 and 3, those who appeared originally, my lord, only defendant number 2 has filed the affidavit, my lord. And some of the companies have also filed the affidavit. But so far as defendant number 14,
yes.
my lord, thereafter, lordship will find on a regular basis, my lord, they had sought for injunction, extension of time to file affidavit, which was being granted. And my lord, last of such order was passed on 21st of April 2025. My lord, in fact, the court had given the liberty that very well the hearing of the application will start and it will not prevent them from filing affidavit. Till today, my lord, defendant number 1, defendant number 3, and the other defendants, including the 5 defendants against whom I have sought for the relief, have not used any affidavit, my lord. This is the, and some of the defendants, my lord, against whom the notice of motion has been
So
taken up.
today, which prayer you are insisting
Yes,
for?
I am insisting, my lord. Why a question will arise? What is the urgency? Why an application?
Must you show me which prayer you are
Yes.
insisting for?
Prayer B.
Prayer?
B.
Why only 4 defendants, 5 defendants,
Why?
not the
Because
70?
Because, my lord, these 5 defendants are the main defendants in which the properties of the Joyce Karia family group of companies have been acquired. And, my lord, so far as the defendant number 22, my lord, already a part of the property has been sold at Bardwan. Negotiations are going on to sell the properties at Raiganj. And we have come to know that within a day or two, the deed of conveyance will be executed.
Where is the pleading?
Yes.
Then?
Now, so defendant number pleading is there. Now, defendant number 22, 14 is, my lord, Judge
Now you do one thing.
Yes.
Kindly come to your previous prayers.
Yes.
Previous prayers?
Yes. For paragraph, page 44, paragraph 43.
Correct.
Yes.
Kindly come to prayer B. Same prayer except name of the respondent.
Name of the respondents, it was against all.
There you have prayed respondents.
Against all of them.
Which includes these 5 also.
Yes.
Which includes these 5 also.
Yes.
Now, whatever reason, injunction was not passed.
Yes.
I do not know whether you carried out any appeal or not.
No, we have not filed any appeal.
Fair enough.
No appeal was.
Now, from your application, you show me what is the changed circumstances and subsequent development you pleaded.
Yes.
Which warrants an immediate interim order during the vacation.
Yes.
Show me.
Now, my lord, kindly come to
paragraph
45.
Yes. Place it, madam.
46 rather, my lord.
Whatever paragraph you
the
want to
petitioners
place.
have come to know that the defendant respondent number 22, during the pendency of the said suit and the application, and the respondent defendant numbers 1 to 6, themselves and through their agents are selling and disposing of the assets of the respondent number 22, being the land situated Purva Bardhaman, by executing several deeds of conveyance. Then we would kindly take paragraph 47. We have lodged a complaint with the police on 21st May 2024. Then kindly come to page paragraph 48. Now, my lord, so far as the Bardhaman property is concerned, my lord, the conveyances, now we have come to know that it has already been executed. Paragraph 48. I have got the deeds of conveyance also with me. My lord, we have obtained certified copy that property at Bardhaman has already been sold.
Where is the pleading?
My lord, we have being situated by executing several deeds of conveyance at paragraph 46.
That is your apprehension.
No. Yes, but recent thereafter.
These are too bold a statements.
No, my lord, kindly come to page paragraph 48. The petitioners have come to know that defendant respondent numbers 2, 3 are attempting to alienate and negotiating to sell the land at Raiganj, which is being held in the name of defendant numbers 23 and 24 at a consideration of rupees 70 crore. Negotiations have been done, my lord. Until unless the conveyance is being registered, my lord,
Madam,
I cannot.
Madam, on this plea, there cannot be any subsequent development to be taken and accepted. Because when expressly your ad interim prayers have already been refused, right? Unless a solid evidence is brought before this court on the same prayer.
My lord, may I just submit, my lord? My lord, since March 2024, October 2025, my lord, they have not filed any affidavit, my lord.
That's a different issue.
And my lord, no, my lord, so far as my application is concerned, GA1 of 2024, my lord, I can place. But in order to prevent the mischief, because until unless I can have the proof only with regard to the sale of the property only when the deed is being executed. Because otherwise the company is under the control of the defendant numbers 1, 2, and
Madam, on
3.
these averments, I cannot pass any interim order today, which has already been refused by the previous courts on the self-same cause of action. There is no such subsequent development which calls for an immediate interim order.
Lord, what I submit, my Lord, that these 4 defendants, defendant number 1, 3, and these 5 defendants, my Lord, against whom today I am seeking the relief, my Lord, have not used any affidavit. They have my averment
I can advise direct them once more, but no injunction. No injunction.
Lord, what I submit, my Lord, is this, that my apprehension that or whatever is my allegation or my averments, that negotiations have been done with regard to the Raiganj property at 70 crores, my Lord.
No.
Let my learned friends say that they are not selling the property at Raiganj. They are not selling the property. Let them say. Let them.
They will say on affidavit whatever they want to say.
Because, my Lord, the affidavits from them is not forthcoming. So that my application for injunction GA1 becomes infructuous, my Lord.
There are, Mr. Rupak Ghosh, assist me. There are defendants.
Yes,
90
90 defendants.
Lord, in this application, I have not sought for relief against other defendants.
You sought for against 23 and 24, para 48.
I have served them.
I am praying for your lordship's leave, my lord. I have to catch a flight.
My Lord, this is the affidavit of service, my Lord.
All right. Affidavit of service filed in court today is taken on record. Full stop.
May I have a look at it?
Huh?
May I have a look at
My Lord, I have served even.
May I look at it?
Taken on record. Full stop. There are 90 numbers of respondents impleaded in this petition. It's a paragraph. Huh? Next paragraph.
There's no
The parent suit is a suit for partition. Full stop. In the said suit, earlier, an order for injunction was moved. An order for injunction was applied for. Full stop. The prayer would be evident from prayer B in GA1 of 2024 as set out in paragraph page 44 to this petition. The orders were passed from time to time on February 19, 2024, March 19, 2024, and March 11, 2024. Aage pore kore diyo baba. Appearing at pages 171 to 174 to this petition.
One more order at page 189, same application.
Date,
my lord, 21st April 2025, last order.
That I have shown.
Last order, where also the Honorable Judge records that there are demerer applications.
Will be heard first.
Will be heard first.
Before the injunction.
Ki bollam? Order dated?
Order dated 21st April 2025, 189.
These are not concerned with the
Order
defendant.
dated
21st April 2025.
Well, these
April 21, 2025 at page
189, correct, the relevant portion 190.
189
Yes.
to the instant petition.
We'll say that demerer application has to be heard out first. No appeal from either orders.
All these orders show that the prayers for injunction prayed for earlier in terms of prayer B to GA1 of 2024 was not passed even after repeated consideration, and affidavits were directed to be filed. The order dated April 21, 2025 records that the demurrer applications filed by the party, some of the defendants,
Some of the six
some of the
defendants.
defendants shall be taken up before hearing the injunction application.
My lord, it also records that my application for injunction shall also be considered for passing further order.
After demurrer.
No, it does not say so.
And the injunction application was also directed to be considered. Paragraph. The said GA1 of 2024, the first injunction application, as referred to in paragraph 42 to the instant petition.
43, my lord.
43, I'm so sorry. Is still pending, and the respondents have not, and some of the respondents have not filed their affidavit in opposition therein. Paragraph.
My lord, including the defendants against whom I am seeking the relief.
Pending the said paragraph, pending the said first injunction application, the instant petition has been taken out. Full stop. Learned senior advocate for the plaintiff stroke petitioner has pressed for an order of injunction in terms of prayer B to the instant application. Paragraph. On a conjoined reading of prayer B in GA1 of 2024 and the instant petition, it appears that specific 5 numbers of respondents against whom injunction has been sought for in the instant application, in the instant petition. Whereas against all the respondents, the order of injunction was prayed for in GA1 of 2024, which obviously include these 5 respondents. And the injunction, prayer for injunction was not granted. Paragraph. The plaintiffs petitioners have not preferred any appeal from the previous orders passed by the coordinate benches when order of injunction was not granted.
Will it be my lord's pleasure to record that I have submitted that these defendants have not used the affidavit despite repeated directions being given.
MS Monju Manat, learned senior advocate, submits that these 5 respondents referred to in prayer C to the instant petition have not yet filed their affidavit in opposition, despite extension being granted by the court. Paragraph. On the basis of the subsequent development as cited, as pleaded in paragraph 46 to 48 to the instant petition, learned senior advocate renews the prayer for injunction against these 5 respondents. Paragraph. The petition has been opposed by Mr. Jishnu Shaha, learned senior advocate, appearing for respondent numbers 2, Mr. Rupak Ghosh, learned advocate, appearing for respondent number, comma diye. Mr. Rupak
Lord,
Ghosh,
that
learned advocate.
respondent number 1 has also not used any affidavit, my lord.
Recorded.
All right.
2 years.
কি বললাম?
No, on these 5 respondents.
Rupak Ghosh, appearing for respondent number 1, and Mr. Junior Shah.
Yes, ma'am.
Ishan Shah, learned advocate, appearing for
Respondent number 7, my lord.
respondent number
7, my lord.
7. Learned paragraph, learned senior advocate further submits respondent number 1 has also not filed affidavit in opposition. Paragraph. Considering the rival submissions of the parties and considering the materials on record, and more specifically the amendments made in paragraph 46 to 48 to the instant petition, comma, this court is of the considered view that no specific case has been made out citing any subsequent development that an order of injunction, that a prayer for order of injunction can be renewed through the instant petition, which has already been refused by the previous orders in the previous injunction application. The averments made in the instant petition are bold and general, without any particulars. Paragraph. In view of the foregoing reasons and discussions, there is no scope for passing any order of injunction. As prayed for herein. Full stop. The respondents shall file affidavits in opposition on or before date. এখানে একটা ক্যালেন্ডারও নেই। Give me a date.
10th November, my lord.
Huh?
10th of November, my lord.
November 10, 2025. Affidavit in reply by November 27, 2025. Paragraph. After the aforesaid period expires, comma, the parties shall be at liberty to mention the petition upon notice to each other before the regular bench for inclusion under the heading adjourn motion.
But I have nothing to say. But only one thing think I should bring it to your lordship's notice. The notice of motion we checked, my lord, is only taken out against 39 out of 90, and only 5 have been served. And all our postal receipts, no my lord, track report. And maintainability may be kept open of this petition.
It is pertinent to mention that as observed by the coordinate bench in its order dated
21st April 2024. 5.
April 21, 2025. The demurrer point shall be heard first.
No, my lord, so these demurrer applications have been taken out by the 6 defendants, my lord.
Naturally,
Other
but
company. It is not relate. Kindly record that these demurrer application does not relate to these 5 defendants and the defendant number 1.
No, it is recorded, madam, in the order. GA number such and such, GA number such.
Lordship is recording that these demurrer applications shall be heard first. That
Sir, madam, I have
No,
said
that
as observed, as observed.
my lord, I am submitting, lord. Kindly don't record that line. That is already there in the order.
No.
Demurrer pertains to the suit, my lord.
Observe, we have not carried out any appeal. That's why I said. Chalo.
Grateful, my lord.
কি বুঝতে পারছি না। হ্যাঁ, ওটা তো প্রথমে হবে। হ্যাঁ। ওটা প্রথমে হবে। নেক্সট। এটা কি হবে এবার? দেখি নেক্সট।
I am for the railway authority.
May it pleases my lord, I appear for the petitioner. My lord, this is my application, my lord, for modification of order passed during the vacation on 9th of October, my lord, granting me 7 days time, my lord, to tender the bank guarantee. My lord, there is a background to this. My lord,
What do you want now?
my lord, extension of time to tender my bank guarantee.
My lord, this my lord will kindly come to page 112.
Show me the last order.
That's why I'm showing my lord, the in first order.
Show me the last order.
123, your lordship. 123.
Initially, my lord, while hearing of this matter, 2 days time was court was pleased to grant 2 days, but that was extended till 7 days. Since Saturday and Sunday was ensuing, they asked that 7 days time may be given. My lord will kindly come to page 112.
That is not the perhaps the correct.
Kindly
Let
come to
my
page
learned friend
112.
should allow me to place my case first. And then he'll get an opportunity, my lords.
Considering the prayer made in this application, দুপক্ষের নাম দিয়ে দেবেন. And considering the order passed, last order passed on October 9, 2025, as a last chance.
May I, my lord, will kindly come to page 100. This is the stance they are taking every time. My lord will kindly come to
I'm
page.
saying as a last chance.
My lord will kindly.
As a last chance and as the peremptory opportunity. Time for furnishing the bank guarantee in terms of the order dated September 18, 2025, passed in AP 169 of 2025, stands কি বললাম পড়ো, as a last chance. Peremptorily extended, এইখানে peremptory দাও, আগে peremptory যদি বলে থাকি কেটে দাও. Stands peremptorily extended. কবে খুলছি আমরা?
24th, my lord. 24th it's opening, my lord. Will kindly.
October 28, 2025.
So grateful, my lords.
Too long.
Full stop.
Long, my lord. My lord will kindly see come to page 112. My lord, kindly, my lord, please. My lord.
Show me that you have taken this plea before the earlier court.
My lord will kindly come to page. We have.
Show me that your plea was taken before the earlier court.
No.
That was not recorded in the court. My lord will kindly come to 112 once, my lord.
No.
So grateful, my lords. So
My lord, that plea was.
উপরে অ্যাপিয়ারেন্সে যেন নাম হবে, অর্ডারটা পড়ো.
So grateful, my lords. So grateful.
$2025.
This is the third time they have coming, my lord.
So grateful, my lords.
With the on the above terms, this application কি আছে, GA কত?
Let there be an
GA1, my lord, GA1.
GA
1.
1 of 2025.
We have objected to let it be recorded.
Stands GA 1 of 2025 stands disposed of, comma, without any order as to cost. তার আগে একটা লেখো. The prayers in the petition has been objected by Mr. Rajesh Jha, learned advocate, appearing for Railways.
So obliged, my lords.
Next.
This your lordship was kind enough to allow us to move today. Lord, the issue is very short. I'll indicate, Lord, we found out a slightly easier way for us at least. Lord, a letter of credit purchase invoice issued by a German company. I am Lux. I'm importing 8 machines where, Lord, if I put in a fabric and I designate a certain unit, the cloth gets ready-made and it comes out. The terms are the letter of credit will have to be issued till payment is made. The goods are not, I am not entitled to take the goods. But I receive an intimation on 4th of October that the company has gone into insolvency, a custodian is appointed. I immediately,
Which company?
the German company, the supplier has gone into insolvency, a custodian is appointed. All transactions, even in the usual course of business, will have to be routed through the custodian, like your lordship is aware. So I write to the bank. Bank doesn't do anything. Bank writes a letter to me on 10th saying the company has now filed for letters of credit and for the money to be taken out. I am only praying for this today. The goods are to reach only in the second week of November 2025. The pro forma invoice says unless I make payment, I will not be entitled to take the goods. I will undertake to keep the letter of credit extended. The bank has written this letter to me after we've served, saying please get an order of court. We will not invoke the letter of credit. I'll show that email, my lord, just now. I'm only saying this. I'm undertaking to keep the letter of credit extended. The goods are not coming now, so the German party is not getting prejudiced. I'll show that document also. Please have a look at this, my lord. Please arrange a court order today by 4 p.m.
First, you show me from your petition that German company has gone into.
Yes, yes. I'll just show that, my lord. Yes. Kindly have a look at page 58. I'll show the order straight away, my lord. At page 81, kindly come. 81 is the order in German. There are two page numbers that your lordship will find. The order is at page 81. Kindly turns over to page 85. That's the English translated. I'll actually take 2 more minutes. I don't intend to trouble your lordship any further.
85.
85 is the translated version of the German. Kindly see it's an order, local court, Heischingen, insolvency court, regarding the application for opening of insolvency proceeding over its own asset. The local court hereby orders to prevent detriment changes, financial situation pending a decision on the insolvency petition. Preliminary self-administration is ordered. Preliminary custodian, Erkin, somebody, attorney at law, enforcement action. Creditors are prohibited from realizing, collecting, or repossessing collateral. Such assets may be used by the debtor under the custodian supervision. 5 and 6, your lordship will kindly see.
But where is the dispute? That
yes, so then
you are the supplier or you are the purchaser.
I am the purchaser.
You are the purchaser.
So what happens is, my lord, these two clauses I'll just show. 5 and 6, kindly have a look at. So when I enter into the contract, I enter into a solvent party. Now I'm seeing when the goods have been shipped, they're taking the money, everything, the custodian is in charge of the affairs and management of that company. So if there is a warranty issue, my after sales service, everything is gone.
Why gone?
But who will?
Your warranty, then the insolvency professional.
So I have to.
He should.
Correct.
He should be the trustee.
So I have to reach out now. In that background, your lordship. Now in that background, kindly come back to 85 once.
You should have to apply before the insolvency professional.
If I want the money back, which is why they write a letter to me saying this is the situation now. After they lodge the letter of credit, they write a letter to me saying this is my situation. I have gone on the insolvency. Please cooperate with me. If you have any further clarification, please write to us. I write the clarification after receive the bank letter. The clarification lordship will see at page 101.
Banerjee, if you have gone for an agreement to purchase the goods, and if you receive the goods,
I haven't.
Then you will have to pay
the
price of it.
Yes.
So you have not yet received the goods.
Correct. And that is the point.
They're taking the money.
They are taking them. This is the point. This letter, if your lordship looks at, I'm so grateful. I end here. Just please have a look at this one letter that has come from the bank at page 101. Page 87.
Has the consignment been shipped?
Yes. Bill of lading shifted before arriving in November.
It has been shipped.
It's been shipped.
It's yet to be received by you, or
it's not even arrived in Calcutta.
yet to
In,
erect or yet to receive by you on
between 10th to 12th of November 2025.
21st of November.
21st of November. I'm sorry. It is coming on 21st. Yes, he's right. On 21st of November, it comes to ships land in the port. Now, please have a look at just appropriate your lordship's query, my lord, page 87. This is my cause of action. And I'll show that pro forma invoice. So I'm saying till the 24th, because your lordship kindly have a look at page 87.
Where is the plaint?
Plaint, my lord, is annexed. I'll have to formally present the plaint, my lord, but I thought at least to show the urgency.
No.
Plaint is here, my lord. Plaint is there. I'm showing your lordship from the injunction application.
Yes, but the plaint, you have to.
I have to present the plaint.
Leave under clause 12.
Yes, my lord. I have to take leave under clause 12.
You have to.
I have to. I have to pray for that leave. I have to pray for the leave under clause 12, order to rule 2, and section 12A of the Commercial Code Act because of the urgency. But to
Section
exemplify,
12A, have you complied?
no, which is why I'm seeking the leave. So that I can't go for mediation. I need urgent reliefs. Because, my lord, if your lordship is on the injunction application, just apropos your lordship's query. One, please have a look at page 87. I'll not argue further. My lord, this is the point that your lordship has asked me the most important question. Page 87 of the injunction application. I will not trouble your lordship any further. Just please see that this is the bank's letter at page 87. This is given on 10th of October. 10th of October, received by me on
87.
page 87.
2 pages are there.
Yes, not it's 6687.
I've received. Yes.
This I've received on 14th. Please have a look at the last sentence. The bank writes to me, for clean documents, your account will be debited on or before today. So the goods come in second week of November.
Where do I get that?
Yes, Lord, that your lordship will kindly have a look at this.
No, where you have disclosed
that
the goods will come on.
No, that there is a specific pleading, but kindly have a look at this document once, Lord. I'll be able to satisfy your lordship.
What is this document?
Well, Lord, this is the document from Logwin Logistics that is sent to us. Please have a look at the vessel and departure date. Your lordship will find this date from my bill of lading, and it is reaching Kolkata, India on 21st arrival time, 21st November 2025. Look, in terms of that letter that the German party writes to me, I have sought for that clarification from them. They've received the clarification. Now they want the money out. And before giving me they write to me saying, I've gone into insolvency. If you have any clarification, please bear with us. You seek the clarification. I'm only saying this. Let them come and clarify before the court. I will keep the letter of credit extended. The goods are not coming anytime before records that not. But if the money goes out today, what has rightly fallen from this honorable court, I will have to take it up in Germany with the custodian there. And the goods would not have reached by then. And this is why we pleaded fraud also, that after the custodian is appointed, one more interesting fact, the letter of credit issued in respect of account A. They write to the bank saying, now invoke it and put it in account B.
So first, a plaint has to be admitted.
Yes, not plaint, I'll have to present, yes. That your lordship will kindly have a look at, Milord. I have prayed for leave under order 2, rule 2 at page 35.
No, what is the paragraphs for clause 12?
Yes, Milord, paragraphs under clause 12. Your lordship will find at paragraph 32 of the plaint. Paragraph 32 is for clause 12. Para 35 for order 2, rule 2, Milord, because naturally if the money actually, if the machine come.
Paragraph clause 12?
Clause 12 is paragraph 32. Order 2, rule 2 is paragraph 35.
Wait.
Yes, Milord.
Who is defendant number 1?
Defendant number 1 is the German party. And defendant number 2 is the bank who's written that email that please give us an order by 4 o'clock. We will stay our hands. Everything received within, not my registered office is within. And D1 and D2 are outside. and 35, if I may, my lord, order 2, rule 2, because I'll have claims and damages also separately. Again, because these are very important machines for me. My lord, I'll tell your lordship, apart from just this matter, my specific instructions are that if the company comes forward and the custodian once indicates before this court, either on the 25th or on 28th, that they'll look after the warranty, because these machines are important to me. I am Lux. I will go ahead with the transaction. But it can't be that you take the money out today through the custodian.
The bank.
Bank, you know, that is the only response, saying get an order from the
No, but you have
served.
implemented.
Yes, we've served. Implemented affidavit of service is here. And to the extent where the bank has written that email communication, that please, I just showed that to your lordship, that get an order by 4 o'clock, we'll stay our hand. So we've requested them to stay their hands at least till 5.
Should. First, এই original side এখানে তো endorse করতে হবে.
Section 12A
Endorse
also.
করো.
Lord. Order to rule.
Leave granted under clause 12 of the latest patent. না, কিন্তু তোমায় লিখতে হবে তো endorse করতে হবে তো পেছনে. হাতে মাইলররা লেখেন। লিখুন। Leave granted under clause 12 of the latest patent and also under order 2, rule 2 of Code of Civil Procedure 1908. Poster. No, but 12 leave is also endorsed on the fiat or separate order.
Your lordship, you can just pass an order. Separately, your lordship needn't endorse it.
No.
12A, Commercial Codes Act, not required to be endorsed on the plaint. Just an order is enough.
But order 12
order 2, rule 2
and clause 12 are in the fiat.
Yes.
They are on the fiat.
That's right.
That's right. 1908. Paragraph considering the urgency pleaded. Leave is also granted under section 12 capital A of the full
Commercial Codes Act 2015.
Commercial Courts Act 12 capital A of the Commercial CCAP Courts CCAP Act ACAP, 2015. ঠিক আছে, এটা আপনি একটা অর্ডার ছাপবেন আর তুমি লিখবে, পেছনে একটা লিখে দেবো আমরা। চলুন। হ্যাঁ, এর তলায় এবার এটা হয়ে গেল। এইবারেতে আপনি এটা লিখুন। Petitioner. Affidavit of service filed in court today is taken on record. Paragraph. Mr. Shuddho Satto Banerjee, learned advocate, appearing for the plaintiff stroke petitioner, appears for the plaintiff stroke petitioner. Paragraph. None appears for the defendants stroke respondents. Paragraph. In view of the extreme urgency shown, comma, the instant petition has been taken up for consideration at its interim stage. And at its interim stage. Add space the interim stage. Paragraph. The petitioner is the buyer and the respondent number 1, comma, a German company is the seller of certain articles. For the purpose of purchasing the articles from the respondent number 1, the petitioner has executed a letter of credit with the respondent number 2, which is valid till
But LC till it's discounted, so it will be valid.
which is still valid, covering the price of the articles mentioned under the purchase order, dated.
I'll just indicate the date. It is 25th of September, no? May, 25th May. 11th of June, 2025.
June 11, 2025, at page?
Yes. 69.
Page 69 to the petition, full stop. The letter of credit with all its terms and conditions is available. The letter of credit with all its terms and conditions is available at page
49.
49 to the petition.
Page 70. Milord, your lordship will make that 70, Milord. Sorry. 70.
49
No, 49 is the draft. 70.
At page 70 to the petition.
Yes, 70 of the injunction.
Paragraph. Which is the document you are showing that the company has gone into insolvency?
At page 85. This is the order of insolvency.
Referring to a document at page
85.
85 is the translated document.
Yes, it's the translated order copy of the order at page 81.
Huh?
81 is
The order is 81.
It's in German, yes.
Ki bollam? 81. The translated copy whereof is available at page 85 to the petition, comma, Mr. Banerjee submits that the respondent number 1 has suffered an insolvency proceeding and has been declared to be insolvent and is going to be declared as an insolvent company and is going to be declared and is likely to be declared as an insolvent company under the appropriate law of Germany. This fact was never informed to the petitioner at the time of execution of the purchase order, nor thereafter. Then bank's documents show me that they are asking for money.
Yes, that your lordship will find that at page 87.
Referring to page 87 to the petition, Mr. Banerjee submits that the German company has already written to respondent number 2 bank for releasing the amount covered under the letter of credit. Mr. Banerjee submits that the articles have already been shipped, and as per his information, the same shall arrive at the port of Calcutta. Honorable, that shipped, SHIPPED. the port, POTRT, Bondor, port at Calcutta, on or about
21st November 2025.
November 21, 2025. First. He apprehends that, comma, if in the meantime the amount covered under the letter of credit is transferred in favor of the petitioner, before the in favor of the respondent number 1, before the petitioner receives the articles under the purchase order, and if any and if ultimately the article does not reach to the petitioner,
or is found defective,
or even if does not reach REACH to the petitioner, or even if reached REACHED but found to be defective, the petitioner has to proceed with its claim, comma, if any, comma, under the appropriate law of Germany in the relevant insolvency proceeding at Germany. Paragraph. Accordingly, Mr. Banerjee prays for a restraint order on the release of amount covered under the letter of credit for the time being. Poster. Paragraph. After considering the submissions made on behalf of the petitioner and upon considering the materials on record, it prima facie appears to this court that since the respondent number 1 has gone under the insolvency proceeding, and in the meantime, before the article reaches to the petitioner, the amount is released. The petitioner would have to run after the respondent number 1 by joining in the insolvency proceeding pending at Germany under the appropriate law of Germany. The respondent number 1 and 2 are not represented. Poster. In view of the above, this court
Prayer
is
A, Your Lordship would kindly consider.
in view of the above, this court is of the prima facie view that a restraint order shall be passed for a limited period. Otherwise, if the amount is paid to the respondent number 1, who is under an insolvency proceeding, then the petitioner would have to suffer an irreparable prejudice, irreparable injury, may suffer irreparable prejudice. Full stop. Irreparable prejudice, comma. If the article does not reach to the petitioner ultimately, or if any defect is found therein. Paragraph. In view of the above, there shall be an order of injunction. An order of injunction in terms of prayer A to the petition till October 31,
Very grateful.
2025. When the matter shall be made returnable before the regular bench.
Sir, I have one more indulgence. The liberty to me to communicate the gist of this order to respond number 1. I mean, respond number 2, and they'll act on the basis of this communication.
In view of the urgency shown, the learned advocate on record for the petitioner shall be at liberty to communicate gist of this order to the respondent number, to the respondents.
Respondents, yes.
Forthwith.
Very great.
ওই জায়গাটা কি বলেছি? Till বললাম October 31, 2021. Sorry, 2025. For further consideration.
Very grateful.
Full stop. Arakta likun. The petitioner shall communicate this order to the respondents and file an affidavit of service before the regular bench.
One more. That my undertaking that I shall keep the letter of credit valid and extended.
Hmm?
My undertaking that I shall keep the letter of credit valid and extended.
Full stop. কি বললাম?
করে রাখা হচ্ছে।
Regular bench. এর আগে একটা প্যারাগ্রাফ দিন। The petitioner in the meantime shall keep the letter of credit validated and alive.
Yes.
In accordance with law.
Ex parte, my obligation is higher.
ঠিক আছে।
Grateful.
Comma as undertaken by the petitioner. এনো ওই অর্ডারটা প্রথম পার্টটা করে তারপর এটা করুন। এটা আর্জেন্ট আছে, হ্যাঁ, এটা এক্ষুনি করুন, করে আমায় দিয়ে সই করিয়ে সার্ভার করুন। এটা কিন্তু আর্জেন্ট। হ্যাঁ, ভুল যেন না হয়। কি ওটাও থাকবে ফার্স্ট প্যারাগ্রাফ, তারপরে তো যেমন বলেছি। আর তুমি এন্ডোর্স করে দাও। আমি তো জানি এটা কোর্ট অফিসাররাই সই করে। হ্যাঁ, সেটা করো, সেটা জানি। ঠিক আছে, তুমি করে নিয়ে এসো, আমি জিজ্ঞেস করছি। চেম্বারে এটাকে সার্ভার করতে হবে আজকে, না সার্ভার না করে বেরোবেন না, একদম বেরোবেন না। আর আস্তে আস্তে ভালো করে করুন, যেন ভুল না হয়। ডাকো প্লিজ। এটা হয়ে গেল দরিয়ান সাইড। চলো অ্যাপ্লিট সাইড কি আছে দেখি, দু একটা ডাকো। document. কি হলো একটা লিস্ট সেট আপ করতে? কি কম্পিউটারের লোক আছে না নেই? তুমি কম্পিউটারের লোক? হ্যাঁ, করে দিয়েছো? থ্যাংক ইউ, বসে পড়ো।
Oh, Lordship, I appear for the petitioner. My lord, this is a suit for, my lord, the partition. Preliminary degree has been passed by the trial court. My lord, the learned Balurghat, my lord, Dokhin Dinajpur. My lord, the final degree has been, my lord, the application has been filed on 19th, my lord, the February 2025. Thereafter, my lord, there was an, my lord, the judicial order passed by the Calcutta notification, Calcutta Gazette. Kindly come to page 39. That is, the two districts has been divided and judicial work has been allotted between the two districts. My lord, this petitioner made an application under section 39 for the transfer of the degree. The learned trial court, my lord, kept it pending, my lord, 7 days. They have not given any transfer the degree to the Raiganj.
Show me which page. Where is your application?
My lord, the application, my lord, kindly come to page 30 starts. This is my application. This is my lord, final degree. That is my.
Come on, tell me for transfer application.
Transfer application, kindly come to the page 38.
Pending before which court?
Pending before the learned wala senior division Balurghat, Dokhin Dinajpur.
He has to dispose it off.
He has to dispose it off.
This is an application যেখানে ভাই অসুবিধা হবে একদম। ও তুমি তো চেনো, থেমে যাবে, আমার 15 বার জিজ্ঞেস করবে, কিন্তু পরে আমি করতে পারবো না। This is an application under Article 227 of the Constitution of India. Paragraph. The fiat FI80, the fiat of the application shows that the department has not received any notice on caveat. Full stop. Paragraph. The solitary grievance of the petitioner is that the application filed by the petitioner at page 38 to the application, 38 to the petition, pending for considerable period of time before the court of the learned civil judge, ঠিক জানা যায়, হ্যাঁ, learned civil judge bracket senior division, comma Balurghat, comma Dokhin Dinajpur. Paragraph. In view of the above, the said concerned civil judge is requested to take up the application and dispose it off by passing a reasoned order in accordance with law. Dispose কি বললাম আমার পড়ো in view requested document shall করে দাও কি বললাম পড়ো say take up the said application at page 38 to the petition তারপর কি বলেছি হ্যাঁ in accordance with law within a period of 3 months
3 months
from the date of communication of this order. Paragraph. It is made clear that this court has not gone into the merits of the said application or the merits of the claim of the petitioner. Paragraph. With the above observations and directions, this application CO কত আছে
875
হ্যাঁ
3758
bold CO থেকে
58
of 3758
হ্যাঁ 3758
CO 3758 of 2025 stands disposed of, comma, without any order as to cost. Next. আচ্ছা ওইখানটা লিখে দাও বাবা none appears for the opposite parties মাথার উপর none appears for the opposite by caveatটা লিখলে তারপর হ্যাঁ yes
my lord in this matter I am appearing for the petitioner my lord the defendant number 1 is defendant number 2 is the landlady defendant number that is petition number 1 petition number 2 hearing is the landlady and petition number 2
show me the impugned order
my lord
22nd July
that is the certified copy
show me
that is order number 7 my lord 22nd July 2025 my lord in this
no what certified copy certified copy of show me 5th of August
no my lord previous there is
acha 27th July
my lord
yes
in the an order has been passed directing us to open the padlock my lord within 3 days that is the last week in view of the matter the petition for
where
that is
27th July
yes my lord 22nd July 2000 next page my lord that is operative part of the order.
wait under which provision
under order 39 rule 1 and 2
how the revision is maintainable
revision is maintainable this is against means appeal not against suit this order has been passed in means appeal 85 my lord. The initially my order was rejected my lord order 39 that is at page 51 against means appeal was filed and an application under order 39 rule 1 and 2
serve and come back
my lord there should be stay my lord your lordship kindly comes to page my lord otherwise the police will forcefully my lord your lordship kindly comes to page 68 my lord.
What is the suit for
suit for declaration permanent injunction and damage filed by the alleged tenant my lord. He voluntarily
you are the tenant
no I am the landlady and my husband I am the landlady and husband
show me the plaint
that is initial that is page 17 agreement period has expired, my lord, on 17 January. All ex-party orders.
He has left the premises.
Yes, my lord, voluntarily in the month of January, my lord.
Show me from the plaint.
That is their plaint, my lord.
That's right.
That is their plaint, my lord. And I had no scope to file objection. And before after passing of the order, my lord, I contested the suit by filing written objection.
Which paragraph they have pleaded that you have locked the premises? Show me.
That is page 24, my lord. Line
All right.
4, line number 4.
Show me. All right.
Page 24.
1 second. Ashu. This is an application filed under Article 227 of the Constitution of India. The petitioner herein is the landlord
And lady, my lord, that is.
landlady. Are the landladies? Are the
Only landlady, prisoner, but one is the husband, my lord. He has no right in the property, but he has been made party.
petitioner কি লিখলাম? The petitioners herein. না এইভাবে লিখুন। Petitioner number 1, who was defendant number 1 in the title suit, is the husband of the petitioner number 2, who is the defendant number 2 in the title suit. The petitioner number 2 is the owner of the suit premises. The opposite parties, how many?
One.
Opposite party is the alleged tenant in respect of a portion of the suit premises, wherefrom
Shop room.
he allegedly carried out a shop room / Dashakarma Bhandar. The title suit filed by the opposite party tenant of the opposite party shows that in prayer D to the plaintiff, an order of permanent mandatory injunction was prayed for to open the shop room by removing the lock affixed on the door leaf LEAF of the suit room. This paragraph, prayer D to the plaintiff clearly shows that the suit room was locked by the landlord. And a decree has been prayed for removal of such lock. In the above factual matrix, the impugned order was passed. In the
Injunction application,
in the above matrix, an injunction application was filed when the jurisdictional civil court declined to pass any order. Being aggrieved by the opposite party preferred appeal number 85 of 2025 before the appellate court, jurisdictional appellate court. When the appellate court, by its impugned order dated July 22, 2025, directed the petitioners herein, being the defendant landlord,
Defendants
by virtue of an ex parte order, ex parte ad interim order, to open the door of the said suit shop room as described in the plaint within the suit shop room as described in the plaint, and failing which the appellant tenant was granted liberty to move the court for further direction. The appeal is pending.
Then matter was transferred to the Court of the Learned Additional District Judge, second fast track court. Then another application under section 94 was made. And in that,
sir, that is neither here nor there.
No, in that order, that is order number 9, dated 5th August 2025.
Yes.
After 2 pages,
What happened?
Order dated 5th August 2025.
What happened?
Certified copy.
What happened?
Well, they then directed on that 94 of the 94 application of the Code of Civil Procedure.
Next.
OC Darpur, that is.
Thereafter, The appeal was thereafter the appeal was transferred before the additional district judge,
second fast track Hooghly.
comma, second fast track court, comma, Hooghly. When the second impugned order was passed, dated August 5, 2025, under which
On the next page, my lord, OC Darpur PS is directed to help giving effect. That is to implement the order.
the local police authority was directed to implement the said first impugned order dated July 22, 2025. Paragraph. Both the said two orders, July 12, 22, 2025 and August 5, 2025, are impugned in this application. Paragraph. আচ্ছা মাথার উপর লেখো ওই কেভিয়েটেরটা লিখতে হবে কিভাবে শুরু করেছি অর্ডার তারপর লেখো none appears for the opposite parties ঠিক আছে তারপর লেখো the fiat shows হ্যাঁ হ্যাঁ এবার লেখো লাস্ট question after considering the impugned orders passed by the jurisdictional appellate court and upon reading prayer D to the plaintiff, it appears to this court that by virtue of the said ad interim order, ex parte ad interim order dated 22nd
June 2025.
July 22, 2025. July 22, 2025. The suit was partially decreed in terms of prayer D to the plaintiff, comma, which is not permitted to be done in law. Full stop. A suit cannot be decreed at an ad interim stage. Without holding a proper trial. Full stop. The law does not permit an interim order to be passed, which in effect would decree the civil suit, pending suit, which in effect would decree na kore, would allow the pending civil suit. Paragraph. Prima facie case has been made out. In view of the above, the operation and effect of both the impugned orders dated July 22, 2025 and August 5, 2025 shall remain stayed until disposal of the instant application. Paragraph. The petitioner shall serve a copy of today's order upon the opposite party and the local police authority, and shall file an affidavit of service when the matter shall be taken up next. Full stop. The matter shall appear under the heading motion before the regular bench in the monthly list of December 2025. পরে করবো চেম্বারে গিয়ে এখন Next. Our quota ache.
6, my lord.
6. In 6, my lord, I am for the, my lord, petitioner herein, my lord.
I am
My lord,
appearing on behalf of the opposite party's caveator.
I have served him. My lord, the petitioner, before petitioners, there is a dispute between them, my lord.
No, but the caveat, there was no caveat, it shows.
My lord, we have served him. We have served him and he is appearing.
Come on.
Now, my lord, this is a, my lord, Charabagan Byam Sumiti. It's a society, my lord, registered under the Societies Act.
What is your claim?
My lord, my claim is that, my lord, one interim order, there was a dispute between the members. And, my lord, one title suit was filed in the court below. And, my lord, in that, my lord, title suit, firstly, one interim order of injunction was passed. Not to
dispute between
the members of the society.
Society. Why
That-
civil suit will be filed?
No society, my lord. This
My
is
lord, this
club.
is the club. This is the, my lord, Charabagan Byam Samiti. Since, my lord, there is a private entity, private dispute. Therefore, suit is maintainable, my lord.
And
In
then
respect of, this is
you are the plaintiff.
register. They are the plaintiff. They are the plaintiff. They filed the suit, my lord. Since, my lord, there is a dispute regarding the members or secretary, etc., we have challenged, etc. One interim order of injunction was passed in respect of two properties, A scheduled property and B scheduled property. My lord, A scheduled property is a building, my lord, and B scheduled property, so far as my knowledge, I have taken, my lord, instruction that that's the land. And, my lord, on this property, my lord, one status quo order was passed. And, my lord, thereafter, we filed an application under Order 39, Rule 4, my lord.
Vacating.
For vacating.
Which is still pending.
And my lord, along with 151 petition. And, my lord, they have also filed another application for, my lord, performing Kali Pujo in the year 2023. Now, my lord, I am coming to the main dispute. Now, my lord, at that juncture, my lord, the order I have annexed here, kindly come to the, my lord, operative portion of the order, dated, my lord, 17/10/23, page 59, my lord.
You are challenging the order dated.
My lord, I have challenging the order dated, my lord, 24th September.
24th September.
My lord, wherein, my lord, this order passed earlier has been modified in a, my lord, only a mere application filed under section 151. And they have been, my lord, allowed to perform Kali Pujo on the A and B scheduled property. But earlier occasion, Kali Pujo was, my lord, allowed by the court if permission is given by the authorities. Now, my lord, we have also filed one application, and, my lord,
you want Kali Pujo not to be performed?
Yes, no, my lord. I am what my humble submission before your lordship, that we may be joined separately or, my lord, in the said Kali Pujo. Otherwise we shall be deprived.
You have taken out an application.
My lord, I have taken out an application for
before the civil court.
No,
my lord, civil court, my lord, they have filed the application.
How you are agreed by this order?
By this order, because of that, my lord, interim order was passed in respect of A schedule and B schedule property.
Yes.
Then that was confirmed.
It was modified.
Therefore, my lord,
let's say it's modified to the extent allowing them to perform
by performing in both the, my lord, A and B schedule property.
Kali Pujo,
my lord. This is, my lord, this is the problem.
Show me the earlier order of Kali Pujo.
My lord, kindly come to page 60. I have page 60, my lord, 6, the operative part. Started from, my lord, page 59. Order dated 17/10/23. Kindly come to, my lord. Page 66, my lord. Hence, it is ordered. Page 66, my lord.
This order is in
Yes,
respect of an application under Order 39, Rule 1 and 2, not permission.
This application,
And
my lord.
this time he has challenged an order under 151.
Yes.
Yes, my lord.
This is revisable order, my lord.
No, all right.
My lord, the order passed in it is, my lord, modified the earlier order. Kindly see, my lord.
No.
Kindly see, my lord. My lord, kindly see. Hence, it is ordered that all the parties to the suit are directed to maintain status quo with regard to nature and character of A and B schedule suit property and the C schedule committee till disposal of the suit. And, my lord, next one. On the other end, both other hand, both sides in their application with prayer for permission to perform Kali Puja at the B schedule property. Kindly, my lord, note it. Did not mention about the construction of any permanent structure thereon. Hence, it is presumed that the parties to the suit will not make any permanent structure for the purpose of Kali Puja at their
So if
applications as
the
aforesaid.
similar order is passed, you are happy?
Similar in respect of B property, my lord,
Yes.
we shall be allowed to, my lord,
You
join.
shall be allowed, I cannot consider.
Because of that, we have also applied before the authorities concerned.
You go and
But
fight it
in
out.
that event, my lord, in that event, my lord, they,
Whether you will be allowed or not, that I will not consider.
my lord, then it at
Why
this.
not restrict your Kali Puja to the B schedule?
Yes.
My lord, I am inviting your lordship.
Yes.
No, sir.
Up to the impugned order for
Yes.
appointment.
I will come.
Yes, impugned order
I will
is-
come. Will you restrict your Kali Puja like page 66 at B schedule?
No, my lord. My humble submission.
Very
is
well.
that-
Then I am modifying.
My lord, kindly consider. My humble submission is that the petitioner is no way connected with the club.
Oh, that is
No way
and
connected.
status quo.
My lord, the petitioner disturbing the peaceful
Mr.
possession
Counsel,
of the peaceful
Mr.
possession of the.
Counsel, Mr. Counsel,
Yes,
the
my
point is, legal point is very simple.
Yes.
Either you agree for B schedule property, you will carry out Kali Puja, I don't mind.
Yes.
Or what he has raised the dispute that by your way of 151, you cannot modify order 30.
No, my lord. Order has not been modified. For that reason, my lord, I am inviting your lordship come to.
Acha, very well, come to page 66.
Come to page 66. Yes, my lord.
On the other hand, read on.
On the other hand, both sides in their application with prayer for permission to perform Kali Puja at the B schedule property did not mention about construction of any permanent structure thereon. Hence, it is presumed that the parties to the suit will not make any permanent structure for the purpose of Kali Puja as per their application as aforesaid. If no permanent structure is made, the nature and character of the suit property will not change. Both sides admitted that Kali Puja has been conducted at the suit property for a long time. This is the 56th time that.
Sir.
My lord, that is.
Please. So, prayer was restricted to perform Kali Puja on B schedule property.
B schedule property.
My lord, if you lordship, kindly, the last.
Yes, my lord. B schedule property is the room of the club.
Sir, I don't mind, but this order shows you are permitted to hold Kali Puja on B schedule property.
Yes, my lord.
Right?
Yes.
Now come to the page.
My lord, kindly come to page 67.
Better I release.
No, my lord. Last two lines.
So first, let me.
It is for your lordship's passing the order. It will be better, my lord. My lord, kindly see, my lord, the prayers for page 67, my lord, middle portion. I am reading, my lord. The prayers for performing Kali Puja made by both sides stand rejected on contest without cause. It is further made clear that court has no objection if such Kali Puja is performed as per existing rules after getting necessary permission from the competent authority without changing nature and character of the suit property.
Not
My
only
lord,
that,
this
my lord,
for your lordship's convenience.
my lord, not only that, my lord, this year.
Therefore,
my lord, already I have obtained permission from the.
Sir, that is for the police authority.
Yes, my lord, already I have.
But
till that point of the I have
by this order,
yes,
151.
Yes, my lord.
What is in that?
My lord, kindly come
In the petition under 151,
the learned
Puja
advocate.
permission filed on Atho by the defendant is hereby allowed to
my lord, it
on
will be
contest
other
Dependent, it will be plaintiff.
for Puja permission.
Yes, my lord. That the petition under section 151 of CPC for puja permission filed.
Show me the petition.
By the.
Show me the 151 petition.
My lord, kindly
My lord,
to page.
kindly come to the
Kindly show me the petition 151.
115 petition. কোথায় আছে? পেজটা বার করো।
Page 70, my lord.
Page 70.
Yes, 77 is the prayer. Kindly come.
77 is the prayer.
Right?
Yes.
It's prayed that your honor may graciously please to permit your petitioner plaintiff for performing Kali Puja in the year of 2025 within the club building of A and B schedule properties
on
Is
behalf of the Charabagan Bayan Samiti and be pleased to enforce the same through Chatterjee Hat Police
Right.
Station.
Now come
Right.
to the
Yes.
impugn order.
Yes,
Yes.
so A and B you have prayed for,
Yes.
and kindly come to the page 66.
Yes, the middle paragraph here and B দিয়েছে দাঁড়াও বলতে দাও না যাবে কোন দিক থেকে
B schedule property.
Then you, if you are agreeable for B schedule, I will pass the order. If you don't agree, then I will stay that order.
yes ভগবানকে বললাম
Yes, my lord, I will perform the Kali Puja on the B schedule property.
আসুন। Mr. Ranjan
সাহা
Shaha, learned advocate, appears for the petitioner. Mr.
Sanjeev Seth,
Sanjeev Shet, learned advocate, appears for the
opposite parties.
opposite
Plaintiff.
party. Plaintiff.
না না বি শিডিউল তো গেল মতো করবে
The record shows that by an order
তাহলে বলেছিলাম দেবেন সেপারেটলি দেবেন তুমি পিটিশন করোনি তো ওখানে
by a previous order
বলবে তো।
dated October 17, 2023, passed under Order Roman 39, Rules 1 and 2 of the Code of Civil Procedure, Annexure G at page 59 to the writ petition. The plaintiff was allowed to perform Kali Puja at B scheduled property on the terms and conditions mentioned therein. Subsequently, the plaintiff made an applied under section 151 of the CPC and at page 70 to the petition. When the impugned order was passed with a prayer, with a prayer to perform puja on both A and B schedule property to the plaintiff. Paragraph. The impugned order dated September 24, 2025 was passed by the jurisdictional civil court, whereunder the said application under section 151 of CPC was allowed Who was plaintiff?
I am the plaintiff.
And this was the defendant's application.
Subsequently, by another order, my lord,
it was
that was corrected, modified.
Acha. When?
My lord, that order is, my lord,
26.
order dated 26th of September.
Where under the same? Was allowed. Full stop. Subsequently, a corrective order was passed on September 26, 2025, changing the nomenclature of the party.
Yes.
Full stop. Paragraph. After hearing the rival contentions of the parties and upon perusal of the materials on record, it appears prima facie that the order passed by the jurisdictional civil court in October 17, 2023 was a substantive order, wherefrom no appeal was carried out. The parties accepted the said order and performed the Kali Puja for the relevant year of 2023. By way of an application filed under section 151 of the CPC, the said substantive order could not have been modified or altered by allowing the parties to perform Kali Puja at both Schedule A and B properties. When the order dated October 17, 2023 was restricted to Schedule B property. However, Mr.
Seth.
Full name.
Sanjeev Seth.
Sanjeev Seth, London advocate,
ACTH.
appearing for the opposite parties, plaintiff. How many? More than one.
Club and represented
Opposite
secretary.
parties and oblique plaintiffs, comma, on instruction from his clients present in court, comma, submits they shall perform Kali Puja for this year at the B schedule property only upon compliance of all the necessary formalities in accordance with law. Full stop. Accordingly, Kali Puja for the year 2025 shall be performed at the B schedule property upon compliance of all the necessary formalities and legal requirements strictly in accordance with law. That's all.
Yes, ma'am.
My lord, I pray before your lordship that, my lord, since we are also the members of the society or the club, my lord, we are also, my lord, wanting to participate in the
I cannot order.
or in the B schedule property.
I
My lord.
cannot.
We have, for which, my lord, we have filed application for my lord permit.
Go and file there, get an order
We have
there.
filed. Then, my lord, file one line maybe, my lord, if we file an application, our application be, my lord, considered in accordance with law.
Since Mr. At this juncture,
yes,
Mr. Ranjan
Saha
appearing for the petitioner submits that his clients have filed an application.
They have already filed on 26th.
Under?
No, they have filed before the authority.
Under?
For permission of organizing Kali.
Cross Kali Puja.
Yes, my lord. They are claim.
No.
Nothing doing.
My lord.
Nothing doing. Chalo.
Great.
With the above observations, directions, this petition, bold CO 3766 of 2025 stands disposed of without any order as to costs. And the impugned order stands modified accordingly.
Grateful, your lordship.
That's it. Next. 7 and 9 बोलना
चलो
এটা কি last 8
Lordship, I am from the petitioner husband. The petitioner had filed a match suit in the year 2018, and subsequently the wife had filed an application for alimony pendent lit. So, the alimony pendent litis application was fixed for affidavit of asset and liabilities, but the wife.
What is the urgency?
Lordship, the urgency is in this matter, a distress warrant was issued. So the husband appeared in the case and said and submitted that we have been paying regularly. There was a mutual compromise.
Move before the regular bench.
Lordship, kindly hear. Lordship, 28 lakhs award has been issued by there has been an instance where a DW was kept in abeyance by the lawless trial court, but yet the requisites for
Serve
the
and come back. Serve and come back. No.
Lordship, please kindly give me a stay in the meantime.
No. Show me the order.
Lordship,
After perusing all the above referred discussions, I have
I've been
modified
paying
the order.
30,000 every month. I will continue to pay. Kindly give me a stay in the matter. Your
No.
Lordship,
I will simply order serve and come back. I'm not refusing.
Lordship, kindly give me a stay. I will continue to pay the maintenance amount, your lordship.
No.
Lordship, kindly. Lady, there has been a compromise petition, your lordship.
Considering the order impugned.
One thing, your lordship, compromise was done.
Even then, they have filed a petition for reconsideration.
Well, very well, you
He wants
move it before the regular bench.
We have been harassed by the police because of filing requisites for
Your lordship,
distress warrant, your lordship. Distress warrant has been
Considering,
kept in abeyance,
considering
your lordship.
your lordship,
nature of the order
he
impugned.
was passed on compromise.
আচ্ছা না
Even,
তারপর আগে মাথায় লেখো
even then,
the fiat shows fiat FIAT shows the endorsement made by the department that no notice of caveat has been received. Paragraph. None appears for the opposite parties. After considering the submissions made on behalf of the petitioner and on perusal of the order impugned,
your lordship,
dated.
kindly 1 minute.
Sir, I will not stay.
Your lordship, kindly rehearing order direction for rehearing.
Lordship, the execution matter was dismissed because it is not maintainable. A reconsideration petition application.
Sir,
was filed.
madam, you have to serve and you have to move before the regular bench.
Sir, lordship, kindly give me a stay in the meantime. I will be paying the maintenance in the meantime. I'm paying and I'm willing to pay it.
Court did
Just
not accept the statement of accounts.
Lordship, court did not take in
I will not, I will not pass the order of stay. I will not refuse it at this stage. I will simply say you will serve and you will renew your prayer.
Lordship, I am willing to pay the amount. I will
No.
continuing to pay, but kindly give me a stay, your lordship.
September 25, 2025, comma. This court directs the petitioner to serve a copy of the application upon the opposite party and file an affidavit of service when the matter shall be taken up next before the regular bench. Full stop. It is made clear that this court has not considered the interim prayer. Has not considered the interim prayer.
So I
And the petitioner, this court has not considered the interim prayer. And a simple direction for service has been made. Full stop. The matter shall appear before the regular bench on December 2, 2025.
Gratefully, lordship.
Well, this matter is slightly different from others. The matter relates to Waqf Act 1995. My lord,
sir, show me the impugned order.
Kindly see, my lord, impugned order, last page. In legal page, my lord. May I read it more? Both sides filed Hajira. Today is fixed for passing order in respect of.
Is it not an appealable order?
Yes, my lord.
Is it not an appealable order?
No, my lord.
There is no appellate forum.
No, my lord. Because these are, my lord, 3 members here. 2 members from the board and 1 chairman. And my lord, this is a CO. Not like other tribunal, WPA, WCT like this, my lord. So CO is the actual forum, civil revision. That is why I have come before you, lords. But can we have look the order, my lord? A fraudulent, a dishonest, a corrupted person has been chosen as a matawalli.
So where is the question of staying?
And kindly have 6 this LCR is missing. LCR is missing, and my lord, and way case is deferred.
You serve and move it before the regular.
But my lord, in the meantime, administrator should be appointed. Otherwise, my lord, that person is continuing as a matawalli, my lord. That is why I have come before your lordship.
It shows. Considering the submissions made on behalf of the petitioner,
LCR is missing.
None appears for the opposite party. Considering the submissions made on behalf of the petitioner and considering the nature of the order impugned, comma, the petitioner is directed to serve copy of the application upon the opposite parties and file affidavit of service when the matter shall be taken up next. Paragraph. it is made clear that this court has not considered the prayer for interim relief. Full stop. Paragraph. And simple direction for service has been met. এই যা লিখেছি আগের তা তুমি তো নিয়েছো করে 2 তারিখ করে দাও বিফোর দি রেগুলার বেঞ্চ 2 তারিখ 2nd of December before the regular bench. Thank you, sir.